Okay, we're on. Make sure you speak clearly into the mic, please. Mic's on. Good morning. This is the New York City Board of Standards and Appeals public hearing for December 10th, 2019. We'll begin with the appeals calendar. Yeah. Item number 1, 6713A, 945 Zarega Avenue, the Bronx. You can put the other one in front of the podium. What? You can put the last one in front there, in front of the podium.
Well, I think it's okay for now. Thank you.
Oh, okay.
Thank you. Good morning, Madam Chair, Commissioners. Andrew Wallace, representing the New York City Department of Buildings on the application. I attended yesterday's review session and heard the comments of the chair and the other commissioners. I think based on the comments yesterday, the board understands perfectly the department's application and the evidence that it has presented. Just very briefly, as we are all aware, the crucial question is what, if anything, was on the roof of this building on the establishment date of November 1st, 1979. Was there an advertising sign on the roof? And after 6 years approximately of review, investigation, litigation, at this point, the best available evidence is the relatively new evidence that the department has provided from the business records of the New York State Department of Transportation, the 5 photographs. And
hold the mic in your hand, please.
Whoops.
And the five photographs are right here. As we see, there's no sign and no structure on the roof in June 1978, approximately a year and a half before the establishment date, and June 18, 1981, approximately a year and a half after the establishment date. Similarly, there is no sign, there is no structure. As I believe Commissioner Chanda pointed out yesterday in her comments, a sign and a structure of this type is not easily moved overnight or over a weekend. Moving on to 1985, we still see that the sign and the structure are nowhere on the roof of this building. It does not appear until sometime after 1985 in a picture dated October 22nd, 1990. So again, the strength of these pictures, the conclusiveness of these pictures as to what was on the roof of this building on the establishment date. The board also commented on the relative deficiencies and weaknesses of OTR's evidence regarding this. At this time, as there were no comments or questions directed to the department from the board yesterday, I'll certainly entertain any questions or comments that the board has right now. Thank you very much.
Thank you. I just want to clarify, when did this information become available, and do you know how it was discovered that it was available?
Madam Chair, my understanding, and it was in our submission of, I think it was in February of this year, we provided an affidavit from Mr. Fortier, who's an attorney. He's the director, the executive director of special enforcement with jurisdiction over the sign enforcement unit. And he, to the best of his recollection, is that he was in a meeting unrelated to this topic in the, I believe it was the spring, early spring of 2017. Yes, early spring of 2017. And an individual, again, just not discussing this, but discussing a completely unrelated matter, said that the New York State Department of Transportation maintains an archive of the state highways, and that triggered Mr. Fortier's thought that maybe this might have evidence that might be helpful in this matter. So shortly thereafter, he contacted the State Department of Transportation, and they provided the 5 photographs.
So he knew in general about that archive. He didn't know that specific to this specific project. They have these kind of evidence. So he knew about the archive. You said, let's go and check. Maybe we can get something. And then you got these pictures.
That's correct. He was unaware of the archive before this meeting.
Okay.
Someone, again, he does not recall who specifically, but did mention that there was this archive, again, on an unrelated matter, and that triggered Mr. Fortier's thought that perhaps it's worth a try to speak to the Department of Transportation.
And he received those in a certified and delegated manner?
He received them in an email, and then when we reviewed them, we went back to the state and advised that we'd need them to be certified as a business record. And when the board had questions about the process that the State Department of Transportation keeps this record, makes and keeps this record, we similarly provided a letter. And again, I think that was
on the last.
in our February submission.
I'd ask that be made part of this record because it wasn't attached.
Yes.
Yes. Yeah, I'd say the whole rehearing request record will move into this actual rehearing record. Okay, I just want, and we've read these materials, but I thought it would be useful that it's in the hearing transcript also.
Of course.
Thank you.
You're welcome. Thank you.
Any other questions for Mr. Wallace? No? Okay, thank you.
Thank you.
Thank you very much.
Yeah. Would the owner like to speak? Owner's rep?
Good morning, Chair. Good morning, board members.
State your name, please.
My name is Ari Noe. I'm with OTR Media. I'm actually, I'm not a lawyer, as you know. I was not fully involved in this case. I had great attorneys before. I am actually, it's the first time here, the first time you see me. I'm not new evidence, and I was always available. But before I start, I want to say publicly thank you for Mr. Matias to be so helpful with everything to guide me what to do here. Thank you very much. But today I want to bring out 4 points, and I'm not going to go into the pictures because I'm not familiar with that. I just want to bring out 4 points, and I want to say one thing. When I talk about DOB, it's not DOB at all. They're very great people, great commissioners. I'm talking about a few DOB individuals and the sign enforcement unit. So I want to make a few points. Point number 1. The standard for rehearing whether newly discovered evidence of DOB was not available at the time of initial hearing.
Okay, I'm sorry, just for a moment. Didn't you appeal the rehearing, the granting of the rehearing?
It's in Article 78 as we speak.
And in that case, you do have an attorney.
In that case, we have an attorney, but not a BSA attorney. He's not a BSA zoning attorney.
Okay.
A litigator.
It's a litigator.
Also, just to clarify, we're not here to discuss pending litigation, so to the extent that you have an objection to the board's determination to grant the rehearing, that's going to be settled by the court.
The entire thing here about the rehearing will be settled by the court, yes.
So-
I'm not talking about the court. I just want to clarify, I want to be on the record, my letter which I sent to the board is there.
Yes.
And since I'm here the first time, I just want to
Okay.
say my opinion, my humble opinion, and my points.
Okay.
I appreciate giving me the opportunity. So these New York City DOT pictures, photos, was always available. They have pictures from 1975 up to 2003 and on. They had an archives, a reasonable due diligence on it should be there, and the DOB never presented, and it was always available. Public record is always available, as we cite the Douglason case there. That's, to my knowledge, that's to the point. So it was always available. It's not new evidence.
Excuse me, if they were available, why didn't your attorney at that time reach out to the state DOT? If they are available and everybody knew about them, why didn't your attorney reach out to the state DOT and get a copy of these, and we could have been done since then?
Good question, but you have to ask him why not. But I
No,
would
no,
say,
I'm asking you, your attorney.
yeah, you asked me about my attorney. I can't speak for my attorney, but I believe we showed our burden of proof on the standards which the DOB had on the website since 2010, guidance what kind of evidence is good. One of the evidence says New York State Archives since 2010. So DOB knew about it. I would assume DOB knew about it.
Who's the owner of these signs? You, right?
OTR, yeah.
OTR Media.
Okay. Did you know about the history of these signs?
I started my conversation before. I do not know fully, but as I learned and I know the history, yes.
So you weren't aware that these signs weren't existing at the time shown on these pictures? You're
Again?
testifying that you were not aware that the signs did not exist in the period?
I am the owner of the company.
Okay.
We had hired once Phyllis Arnold from Bryan Cave, which the chair knows very well. She was the general counsel in DOB. She gave us a list, what is legal, what is illegal. 945 Zariga was illegal, and I took her advice, and based on the history, what we have, and based on what she was very involved with DOB, to rewrite the new Rule 49, which the chair knows well, because in September 20, 2005, the chair had sent a letter to Mr. Fortier explaining more about the Rule 49. So we got advice from the attorneys at that time, all the evidence what we had, and all the evidence that we saw other companies being accepted by DOB, and they have the same kind of evidence. That's why we pursued. We spent a lot of money to take over the sign. And there was a company before me, before OTR had it, a different company had it. The only problem it became a problem is when OTR took it over. That's when it became a problem, but there was no problem before.
You just acknowledged that you knew it was illegal, the sign.
What?
You just stated that you knew the sign was illegal.
No, I didn't say that.
He misspoke. I don't think he meant to say that.
I think he meant that the list from DOB stated it was
It's illegal.
illegal, not that you agreed to it. That was what you said. I believe your statement was that the list from DOB said that Zariga Avenue was illegal, not that you believed it was illegal.
There was no list from DOB. If it's illegal, it's not legal. The only thing what DOB had was from a different competitor provided DOB with all signs of New York. Okay, that didn't make a difference which one is legal, which is not legal. But they provided, I assume so, and as from other courts that we saw documents and emails. So therefore, we went there because we had the history and we saw how the city accepted other companies with one blurry picture with no history. They accepted their OAC and they considered it legal. And we did more digging than any other company, and we had the Department of Finance photos with other and the leases. So we assumed, and we always believed, and we still believe it's legal. Number two, this is already adjudicated by the courts.
Yeah.
It's already adjudicated. We have a Supreme Court judge, and it's 2 times back here, after 6 years or 5 years. The judge says she found it illegal, non-conforming, a legal non-conforming sign. So I don't know why we arguing here. I believe it's up to the courts. It's already decided. It's dead. It's done.
May I ask a
That's
question?
my opinion.
Okay,
Yeah.
let's say, putting away the opportunity of rehearing aside, do you believe that?
Commissioner, can you please
Sorry,
speak into the mic?
putting the questions of rehearing aside, and whether this is, or whether or not this evidence should be admissible on a rehearing, do you believe that these photographs are probative? Do you believe they're relevant?
I appreciate the comment yesterday that I'm a seasonal businessman, but I'm not a lawyer, and I'm not going to go into that, what I believe, what I don't believe. I do not understand zoning, but a little bit which I saw this morning is I saw there's some inconsistency with the miles, the distance, so I'm not going to go into that. I'm just going to say the 4 points which I believe, and it's
Okay,
irrelevant because it's already adjudicated by the courts. It's a legal non-conforming sign. It's done.
But you
That was my
understand
belief,
that,
yes.
I mean, if you read some of those cases, I
Yes.
don't know if you did, that were used as an example.
Yes.
Those cases where they reopened the case to look at new evidence, right? And sometimes they'll look at new evidence because the evidence changes the position of the court, right? Or changes the position of the reviewing body, right? So in this case, we didn't have access to these photographs. And now we see the photographs, and the photographs show actually the absence of the sign during the window that would have been the critical year, right? And so you're kind of asking us to not see the absence of the sign when we look at the pictures. And what I was hoping was someone would get up there and say, well, actually, that mile marker that's indicated on the photographs is the wrong mile marker, or something like that. But nobody's ever gotten up and said that.
The reason is because I'm not a lawyer, and I'm not going to go into the legal, because I don't understand to that. And I do not have, since Ariel Holzer left, I do not have a reasonable attorneys after spending here money again and again and again, the reason to dry us out, wipe us out, okay? I didn't have attorney to come and give the representation. And plus, I don't believe it's even relevant because it's not new evidence. It's already evidence available always. It was public available, and not only this, the FOILOC from the New York City Department of Transportation has multiple agencies requesting for pictures since 2013. Mostly, basically every agency, the law department, asked for photos from the New York State Department of Archives. So it's hard to believe they didn't know. And we also did a FOIA request, which we got stonewalled. We're waiting for that to see if there was any if DOT knew about it.
If DOT knew about what?
If DOB
Knew about it.
knew about it prior to 2017.
Okay. So I'm sorry, you did a FOIA request to DOB to ask whether they...
I believe so. I believe the other attorney, I need to double check. I'm not sure.
So the litigation attorney who's working on the case is working on the FOIA request, is what you're saying?
I believe we did a FOIA request and he got stonewalled. We didn't get it yet from the city. So there's this overwhelming proof that all the agencies, they asked for FOILOCs. They should know it was public records. And 6 years later, they're coming up with the new pictures. That's not new evidence. It was always available. And with reasonable diligence, they should get it if they spent so much time investigating this. Now, speaking of I have to say...
Can I just ask you a question?
Sure.
If it was always available and DOB really knew about it all this time, don't you think they would have just called it right up in 2006 or whichever year they started this whole process, not just with this one, because it's actually the very first time we've seen these New York State DOT photographs on any sign case. And we have lots and lots of sign cases here, and most of the time, the imagery comes from Google, satellites, movie stills, Department of Finance tax photos. We have never seen a DOT photo. So you would think if if DOB has access to this kind of incredible photo source on all the arterials, they would have been pulling it up consistently with all of their cases.
And I
I-
would think going forward, DOB may change its rule and require that as one of the subsidies.
I think
Well,
that this
yeah,
question
yeah.
is a question that we had discussed on rehearing.
Yes,
At that point, we did reopen the case, and we did, that
Yes.
evidence is now admitted into the case. So the question whether or not this is admissible evidence, I don't believe is before us right now.
no, but at the same time, I do think it's fair because Mr. Noe's not represented by counsel to let him speak and to
Okay.
hear our responses. He hasn't been here before to speak, so I just think it's fair.
Thank you. To answer the question, thanks for the for DOB or DOT to let us know, to give us the knowledge about these pictures, because we believe after then we reached out to DOT and got a lot of other pictures. I believe half of the signs of New York will have to come down if that's the case, because there's multiple pictures with other location with just no photos of DOT. So I'm not saying that's illegal, but if it's good for the others, it has to be good for us. An example, I put it into the letter, 2284 12th Avenue. The three pictures from DOT shows no sign, the same, similar situated at 945 Riga. Did the DOB had the rehearing, open a new application for rehearing?
We don't know
I don't
yet.
know yet, but I don't know, but they didn't. I don't know what the board rules is, but they didn't. So,
Whoa,
yeah. Sorry,
we're sorry. Carlo,
Thank you.
can you fix the podium, please? Sorry.
I'm fine.
Yeah, we're a little
Thank you.
underserviced.
So that's our point. Point 4, I would like to raise it because I believe, in fairness, I have to raise it. I believe it was raised already before, but I would just say it on the record. BSA is the BSA. In every court, and on the website, it says independent body, fairness and all of that, ethical and all of that, correct? So if that's fair, I have a problem, not with Mr. Court Steinhaus personally, he's a great man, great guy, great lawyer, but he was the attorney here before. He was standing at this podium presenting DOB on this case, and now he presents the general counsel. He's general counsel, and he's on this case on the BSA side. So, and there was communications ex parte, which I don't know the rules here, but in a regular court of law, ex parte conversations cannot,
Sorry, ex parte conversations, when are we
With the
talking
client.
about?
meaning if he represents the court let's say we're in a regular court,
Yeah.
he represents, he's a law clerk or something, a general counsel, he cannot speak to or get emails direct, I believe so.
If I may.
It's
I-
different in the
just-
city of.
Maybe not, maybe, I'm not trying to,
I would just like to clarify that I did
you
not
mean?
solicit any emails. And to the extent that the email from Mr. Ed Fortier is in the record, I believe that's what you're referring to. That was
Correct.
not shared with the board. And so, I mean, it's in the administrative record now, but to the extent that you feel that the process has been compromised, I also contacted
That's-
the Conflicts of Interest Board, and I would also note that the Corporation Council represents both the Department of Buildings and the Board of Standards and Appeals and litigation on this matter. And so,
Mrs. Tanis, just how long have you been counsel on when this case was pending before the BSA?
Sorry, what?
How many-
This came to the BSA in 2006 initially.
And this is the first time this objection has been raised that there might be a conflict?
I believe it was in a footnote in their papers in February.
Of this year.
Yes.
Yeah, okay. But the fact is that there isn't any prohibition against working on something within the city, right? Because the city represents the city,
Oh.
right? Okay.
okay, so Maybe that's the rules, but in a regular court, and if it's independent and fairness, I must raise the question, but with all the respect, it's great. Great
But,
attorney.
but not also to forget that it's the commissioners who make the decision, and council just advises the commission on legal matters, right?
And
and
commissioners
so-
write
and-
the resolutions.
Sorry?
And the resolution is
The
written by,
resolutions are based on the testimony that you hear and the
Which is general
submissions
counsel.
and the 3,000 pages or something like that of submissions that have been made on this case. Which we read, we interpret, and then the testimony that we give drives the resolution. Okay.
great. Thank you. I'm not here to change the opinion because I'm not
Yeah.
going to change the opinion, but I just want to say these 4 points for the record,
Understood.
and I really appreciate it. Thank you very much.
Thank you very much. Appreciate it. Okay, any other speakers on this? No? Okay, so I don't think there's anything else to discuss. I think we could close this.
I have a
Yeah.
question for the DOB. The state DOT archive, is this like a public archive? Can anyone from the public like log in and download pictures from it, or it's kind of a governmental archive?
Commissioner, earlier this year, I did look at that, review the DOT website, and at that time, I didn't see it prominently displayed. There wasn't an easily accessible link to it. As I say, our access of these archives came to us from, based on a conversation that was described with Mr. Fortier and an official in Albany. What updates DOT may have made at this point, after this request and maybe other requests for this type of material, I can't speak to. I just don't know what they're showing at this point on their website. But earlier, when we were gathering this evidence, it was not, it was not readily available on the website.
Thank you.
So, okay. Okay then, so I'd like to make, any other comments, questions? I'd like to make a motion to close then.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
And I don't know if there's any further discussion, but I'd just like to make a motion. So go
I
ahead.
would ask the owner if he's intending to bring in an attorney.
No, no,
I
no,
would-
we just, we closed the hearing, so that's
Can't do this
the
then, yeah.
end
It's
of,
done. Vote.
right? So once we close the hearing, then we vote on, we can discuss our opinions amongst ourselves, but that, it means that we're done with the testimony, right? So, and my impression is that the
I
owner
apologize.
isn't going to be bringing in an attorney, or he would have asked.
I should have asked before closing.
Yes, okay.
Okay.
But I think the owner probably would have asked, can I come back with my counsel once I...
That's fair
right?
enough. Okay.
So I'd like to make a motion to, let's see how this works, grant the appeal of the Department of Buildings, right? Isn't that? Yes, that the new evidence indicates that the sign was not initially established based on the new evidence, right?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Thank you for coming.
Item, continued hearing, item number 2, 2017-310A, 1002 Farragut Road, Brooklyn.
Good morning, Chair and Commissioners. Timothy McKernan for the Department of Buildings. Just want to state that this hearing is regarding calendar number 2017-310A, which is DOB's application to modify the CO to remove accessory regulated medical waste treatment, transfer, and storage. There's no question that the CO is incorrect because of incorrect information provided the owner to DOB. And 2, that DOB and BSA have the authority to modify the CO to remove the incorrect description of the use. In light of the appeal in 2019-49A, the department agreed to adjourn this action, the CO modification action, until the resolution of the interpretive appeal, which the board knows was decided in favor of the owner. The department agrees that a new CO may be obtained for a use group 16D regulated medical waste transfer station. There's no dispute about that. In fact, we've approved their application. But this does not change the fact that the current CO is in error. So here we are today. The deputy director asked for an update, which I provided last week, which set off a flurry of activity. And I think based on conversations with Owners Council now, it might be helpful if we both appeared, or are you willing to? I think there's some confusion about whether the department's position is no question that an inspection and a PW7 is required.
Yeah, I'm sorry. Can you go into, like, can we back up just a little bit? I'm holding the 2015 final C of O.
Sure.
Okay? And the final says on it, with respect to this use, says, use group 16E, accessory regulated medical waste transfer and storage. It says that on it already. Occupancy group B, that's the only thing that's really relevant. And then the other side of the wall is minor auto repairs, auto body, accessory offices, and 21 open accessory off-street parking spaces, right? I see the Schedule A that's related to this alteration type 1 that was approved recently, actually, which says that so there's a little disconnect, but it says that the existing C of O for the subject says existing occupancy group E, so that doesn't match, but maybe it's because it's the old, it's a 68 occupancy group E that's being referred to on this Schedule A, even though the 2015 Schedule A shows occupancy group B. So it seems like the 2015 CO already says the correct occupancy group, which is one of the reasons that I'm thinking you think there needs to be another inspection. The other thing it says is the existing says accessory regulated medical, it's misspelled, but anyway, it says water, but I think they mean waste, transfer and storage. And then it's going to be changed to use group 16 regulated medical waste transfer station. So,
I think the accessory needs to be removed because it's not accessory to something.
Right, it's primary use.
yeah, I
primary,
get that, right, but at the same time, so the word accessory is removed, and then there's going to be CO comments. The comments are occupant on first floor, use group 16 must maintain a New York State Department of Environmental Conservation permit issued pursuant to, it's misspelled again, so there's a lot of typos, but anyway, 6N something, I guess it's NYC Part 360, or maybe it's New York State, it's probably New York State RR Part 360. Transshipment of radioactive materials and treatment at the premises are prohibited. Those notes were related to what we discussed at the hearing because we wanted more specificity, right? So I'm trying to understand why the department feels like, given it already says use group 16, occupancy group, whatever it is, B, on the actual CO, why then, like, what's triggering a new inspection or whatever the PW7 does?
Is there auto use there, right?
What?
Is there auto use there still?
Is there what?
Auto use.
Yes,
Yeah,
that's
all right,
still there.
so-
I'm just talking about the critical aspect
Okay.
of it. It's really a change from accessory to straight up use group, but they both say 16, and this one says 16E as opposed to 16. The new one doesn't specify which letter, 16D or so, it just says 16, right? So what's triggering the PW7?
Because a new certificate of occupancy is required. They submitted incorrect information to the department in 2015. The existing certificate of occupancy is based on incorrect information provided to DOB.
Oh, it was so we had a CO,
Correct.
2015, and we didn't rescind the CO, right? We didn't revoke the CO.
Well, that case is pending.
No,
That's
no, your case isn't to revoke the CO. Your case is to modify the
to
CO.
remove the words accessory regulated medical waste, because that description of the use was based on incorrect information. It was not accessory.
Okay, but what we're talking about kind of paperwork at this point, right? So what I'm trying to so we didn't agree that 16 is not the right number. So if we had said it's 18, then you would have had a kind of a bigger change on here, because then it's shifting you probably also into a different occupancy group for all I know, right? And maybe different kinds of building code requirements. But since we're staying in 16, the CO exists, it's not been rescinded. And all we want to do is, with the cooperation of the owner, as opposed to going through and voting to order a modification on the CO, we're trying to work with the owner to cooperate, right? And if this site was already inspected, as I mentioned yesterday, by almost every agency that could inspect, so much more than the Department of Building.
Can I say something about that? When we
Yeah.
inspect in that context, to the extent DOB inspected, they are not performing what we consider a final construction inspection, which is a very different thing. In a final construction inspection, the department is walking around with the plans to make sure the as-built conditions match both the law and the plans. And that did not occur in the context of this BSA appeal.
Didn't it occur when it was first in 2015 when it?
That's correct. So I want to make clear, I'm not accusing the owner of performing illegal construction, but hypothetically, if an owner of a building received a CO and a complaint was submitted 2 years after that CO, and illegal construction had been performed and completed, and an inspector came and did not see ongoing work, and the complaint was construction without a permit, that inspector would not be aware. So that the as-built conditions did not match the plans at that time. So then, in this case, we're 4 years after that final construction inspection occurred, that was 2015, and we're being asked, I think, to issue a new certificate of occupancy with a date, and let's just say it happens this year, 2019. And unless we inspect, we cannot say in 2019, unless we inspect with the plans and perform a final construction inspection, we cannot say that the built environment, the as-built conditions still match the plans that we approved in 2015.
But, what's the difference between a modification and a new CO? Your application here was not to revoke the CO, it was to modify it. And like when sometimes fire department has us modify the CO, where they're asking us to change something that has to do with the sprinkler system or the fire alarm system. And so we allow the modification by adding some text for fire department. When they modify the CO for the fire department, does the owner have to submit to a new inspection? It was only fire department that requested the change.
I'm not familiar with the fire department process. I can tell you my understanding with respect to this application.
No, I want to know with respect to applications to modify when there's like,
Brought by the Department of Building.
no, when someone comes and modifies let's say I want to modify my CO, right? Because I want to clarify something about the use that's already listed there. It already says the right use group, but I want to clarify something about the use group because whatever, my client feels uncomfortable about it, or the landlord is upset that it's not really clear about it, so I want to add a comment. How do I do
Sure, that would be filed with an Alt-1.
Yes.
And you would be required, a new CO with a different number would be issued, and a final construction inspection would be required.
Just to change some words?
That's correct. The Department of Buildings, per the administrative code, does not issue new certificates of occupancy without final construction inspections.
And
So even a modification is considered a new?
So a
CO?
modification is a word that appears in, I think I can, in section 28-118 about DOB's CO revocation and modification authority. There is no, I don't believe, jobs that are considered jobs in our own system that are considered CO modifications. It would be an Alt 1, and it would be an Alt 1 if you're changing the CO, and that requires a CO final construction inspection.
Question, so isn't there a type of alteration, type 1, that's a no work? And so there would
Even
still
no
be
work-
an inspection even when it's
That's
a no
correct.
work?
Even no work applications require a final construction inspection. So the Department of Buildings does not issue new certificates of occupancy
But-
without a final construction inspection.
Sorry,
Yeah.
do you have the citation to the construction codes for that?
Sure, I mean, I cited in my letter, 28.118.16, and I think perhaps the letter submitted by owner confused the issue. So I believe they relied on 28.118.3.2.1, and I can read that here. It says, changes in the address, block, lot, or zoning lot. When changes are made in the address of the structure, block, and/or lot numbers or meets and bounds of the zoning lot that are inconsistent with their certificate of occupancy, the owner shall obtain a new or amended certificate of occupancy within 1 year. That does not state that a final construction, owner's council represented that does say that a final construction inspection is required. I just read it. It doesn't say that. All it says is they can obtain a new or amended certificate of occupancy. So the Department of Buildings does not issue new certificate of occupancies without a final construction inspection. And I think that's particularly important here when the final and still valid certificate of occupancy that exists is based on incorrect information. It was listed as accessory. It was not marked on the application, as we discussed previously, that there had been a similar job that was denied, that was not included on that application in 2015. And that's why we're here, because it was listed as accessory, which is incorrect.
Where does it say you have to, I'm at 118.16. Where does it say that you have to go for an inspection? Or is that in your rules as,
So 28-116.2.4.1, final inspection prior to certificate of occupancy. In all cases where the permitted work requires the issuance of a new or amended certificate of occupancy, the final inspection shall be performed by the department in the presence of the permit holder, the registered design professional, or the superintendent of construction.
Wait, but that's permitted work, though.
A permit is required for this work. Anytime a certificate of occupancy is changed, a permit is required. When we say a no-work permit, that is still a permit, and it requires a final construction inspection.
Can you tell me the public policy behind that? Do you know the
I
policy?
think I just tried to explain it in brief, is if we put our date on a certificate of occupancy, we are representing to the world at that time, at that date, the plans, the as-built conditions match both the plans and the law. And for us to date a certificate of occupancy based on an inspection that occurred 4 years earlier, I think would be inconsistent with both public policy and our practice, because the world, what we're saying a certificate of occupancy is to the world, this building complies with code and plans. And if the date is 4 years off, a lot can happen in a property in 4 years. We know that owners, and I'm not accusing owner of this, we know that owners perform illegal construction. And when we issue a certificate of occupancy, we want to make sure that hasn't happened.
okay. So it doesn't look like there is such a thing as a modified C of O. Like, is there such a thing? I mean, I don't find it.
Yeah, so I can, let's make sure I have that. So as far as I know, the term modification is only used in 28-118.17, and that's revocation of certificates of occupancy. And I can read it here, but the commissioner of DOB, is authorized to request in writing pursuant to section 645 of the New York City Charter that the Board of Standards and Appeals or a court of competent jurisdiction revoke, vacate, or modify a certificate of occupancy issued under the provisions of this code. So when we applied to you for a CO modification, it was within the context of 28-118.17, because we acknowledge, I guess, the majority or close to it of the uses listed on this particular certificate of occupancy were valid. we were not seeking to force them to terminate those existing uses. We were seeking to modify, to remove accessory regulated medical waste because we had never approved that as an accessory, as a principal use group 16 use.
Okay, understood. So I think actually this is one of those classic drafting problems where you don't have consistency in language between 28.118 and 28.116, which is about creating the COs, where there they talk about amendments and new, and here the word used is modify, and so it's like a disconnect. Okay. So, okay. So are there other?
No,
Yeah, I just want to ask one last point is our preference is that the board continue to adjourn because in similar situations, and again, I'm not accusing owner, but a possibility is that owners abandon or for whatever reason don't pursue the other application. In this case, we've approved plan exam approval for the use 16D. But in other cases, for whatever reason, owners abandon those. And if you vote and close the record, DOB winds up in a very awkward position if for whatever reason the owner doesn't pursue that, because we're left with a valid CO that's not been revoked, but that's admittedly incorrect. And the owner there's really no pressure on them forcing them to complete that other application. And then DOB is left with very little options except to initiate a new CO modification action. And so our preference is for you to continue to adjourn until the new CO is issued, which again, I think both DOB and the owner believe can happen in 3 months. It can happen very soon. I'm told by our Brooklyn office that the service levels for these types of things are 1 week. So in theory, it could happen in 2 weeks. Obviously, there are hiccups and unexpected delays, but this should, in theory, be able to happen very quickly. But our preference is that the board continue to adjourn, because if the record closes, we're left without tools to.
No, but I guess my question is, what if we voted, I'm not even sure what the effect of it is, but what if we voted to grant your appeal to modify the CO? That doesn't give you something?
My understanding is in similar cases that's happened, and then for whatever reason, the owner has dragged their feet on the other, and DOB has been left sitting in an awkward situation. So if you voted to modify and remove, without changing to theirs, then I guess actually we would have at our disposal the ability to take the current CO down or administratively change it to remove. But I think in this case, we're not trying to force them to cease the regulated medical waste.
Right.
We'd prefer to adjourn, give them time, let the inspection occur.
Okay.
Understood. Any comments,
No.
questions? Yeah.
Let's hear from the owner.
Steve. Owner.
Madam Chair, members of the board, good morning. Marnie Kudon, Cosmo O'Connor for the owner. I think I'm just going to help clarify a little bit. I listened to the review session yesterday and obviously today. So one of the reasons why we objected, not to the adjournment, but one of the reasons why we objected to the inspection was for the very reasons why Madam Chair pointed out a minute ago, was because we already moved to get our CO issued in 2015. We had it inspected, we had it signed off, we had a PW7, and if you look in the building in the bid system, everything has already been inspected and approved and done by the Department of Buildings. So we then, obviously, there was some history here. Obviously, it started in 2016, around that period of time, where there was an accessory, and we agreed to amend that to get rid of the accessory. But I don't know if the board remembers, but when we tried to do that, we were kind of delayed a bit at the Department of Buildings. We got an audit objection, which we then appealed from. So that brings us to our current appeal, which the board had already unanimously approved for us on the use group. So technically, if we had not done anything, our use group, put aside the accessory for a minute, but our use group would have still been completely legal based upon the successful appeal. So we then obviously have no issue amending or modifying the accessory, which we agreed to do. I think that there was a lot of miscommunication because we agreed that we would remove the accessory. The reason why, by the way, it doesn't have a designated letter next to the use group is because that is what both the owner and the Department of Buildings agreed to, because I think there was some concern about there being, there was not an actual use, and they didn't want to designate something and it not be accurate. So we agreed to accommodate Department of Buildings in that respect, and all the language that you see in there was an agreement to accommodate the Department of Buildings with regard to making them comfortable and everybody agreeing about what the use would be. So to us, the amendment to, or the modification to the certificate of occupancy is not a change of use. It's not a change of egress. It's not a change of occupancy. It's anything other than just the change of language to accommodate the Department of Buildings so that we could resolve both matters and move on. And if that was the case, then we had already gone through all of the steps. And when we decided to submit the amendment to the 2015 application to modify, to do this, the other reason why we had a lot of miscommunication is our expediter went back 4 times. The plan examiner had a lot of issues. The first time it was rejected because there wasn't a BSA decision, so they rejected it outright from us. And then we had to go back again, and Department of Buildings helped out and cooperated and communicated it down the chain that this is what we agreed to do and please pass it through. And then at the last minute, we only found out last week, Wednesday, Thursday, I don't remember what day it was, oh, and by the way, now that you got it approved and you have an inspection and you got it that you got the application approved, we're going to need an inspection and a PW7. We were under the impression that once we filed the application, got it approved with the language that they wanted, that this part would be over and this issue would be 100% resolved. And as well as the fact that, as Madam Chair pointed out, we had already had the task force there, everybody had already been there. We obviously have nothing to hide. We don't have an issue if they want to inspect. It's just the point of, we've already stalled this process 4 months trying to even get the plan exam. And so now, obviously, the owner is a bit concerned. If it goes to the inspection level, what's going to happen now? Are we ever going to see an end to what's going on? Because I don't think that the communication is going from, the head of the council down to where it needs to go at the administrative level.
Does what exists at the site right now match the plans that are going to be linked to this new C of O?
100%. We have not changed any work. As a matter of fact, before I attended this hearing, I looked. I have the plans with me. The plans that we submitted to you and the plans that they're both stamped February 2015. So the only thing that we did for the board was, I remember that the board had asked for delineation or demarcation or some kind of on the plans to show where that wall and that separation is. But that wall and that separation had always been there. It had always been fire rated, it had always been there, and we didn't change or do anything, which is why we submitted a no work. Because the only way, unfortunately, to get anything done at the Department of Buildings is you have to submit an application, you have to submit plans, even if you're not doing anything. That's just the formality that the plan exam won't look at anything other than the full application for it. And there is an administrative code section, by the way, and the administrative code section is 118.3.1, which basically says that you need a certificate of occupancy, you need an inspection, you need a certificate if you're going to change use from one use to another, from one zoning group to another. But we didn't change
But
the
you
use.
understand that, you even admitted that DOB is very formulaic. This
Right.
is just what they do. They don't do a lot of extra thinking about this, because they're processing
Yeah.
a gazillion applications, not just yours. So
Understood.
literally, they've got their blinders on, and it's like, we do this, we get a PW7, and then we go do an inspection, and then we go print out a new C of O. That's what they do.
Correct.
So you're acknowledging in that, and you realize to change their formula is an appeal,
No, I understand.
basically.
And I'm
So-
not asking for that, but what I am asking for is, again, I think there's a lot of bigger issues here, and that's, you know, there's a lot of interpretation issues between the section of the code, but that's for another day. But you know, for example, there's a section of the admin code, which is, I think, what we were going under, which is 118.5, which deals with that if you're making a review of an application for a certificate of occupancy, which is what we thought we were doing, that we're submitting it for review of the application for the certificate of occupancy, then the commissioner shall, it says shall, it doesn't say may, shall approve the certificate of occupancy issued within 10 calendar days. That was our understanding of where we were in the process, because we had already had an inspection.
But you
know.
understand that, would you agree that when you first filed your amendment, that there would be an inspection?
No, and as a matter, we did not, because again.
If
I-
that amendment, no, if your
I'm sorry.
original amendment that wasn't rejected, if that was accepted, to be accepted, there would have to be an inspection.
No, because I have had expediters before. Again, I don't know how they do it, but I have had expediters before. If you're just changing language, some blocks and lots, like we mentioned the other mention before, or just language. Sometimes the BSA requires in the end of their decisions to say, and by the way, put the calendar number on the bottom of the certificate of occupancy, and then you sometimes have to go and do that. That doesn't trigger a reinspection, at least in my experience. So it's a little. Honestly, I mean, it's a little gray as far as what it does and doesn't, but I think in this particular case, this is a miscommunication of, we thought that we were going to resolve it, we thought that this is how we were going to resolve it, and we thought that we were at the phase of, we submit it, and then they approve it, and then we get on, because we've already gone through the inspection. Now, if I had an open application, if I had an open permit, which I don't, so there's no work permit that was issued here, because the work permit was issued back in 2015 when we got everything approved. So when we submitted this application, this new modification, it wasn't submitted with a permit. It was a no work all.
I'm sorry, I need to correct you. I'm looking at the alteration application, and it isn't a no work. The box that was checked was an alteration type 1.
It should have been a no work, but an alteration type 1 can be.
I know, but that's the second
Oh, I know
box.
why. I'm sorry. Because in order to amend, modify, or otherwise change a certificate of occupancy, it always has to be an alt 1. That's.
No. It's an all, there's the second box says alt 1, OT, no work, architectural no work, right?
Yeah.
So you didn't check that box, or whoever didn't
I mean,
check
I
the
don't.
box.
I can look. I don't.
I'm
yeah.
looking at a copy of it, so
Yeah.
I'm just telling you what a copy of it says.
Yeah.
It says job types, alteration type 1, check. It doesn't say job type, alteration type 1, OT, no work.
It looks like, it appears from Biz that this job number goes back to 2015.
Yeah, exactly. We pulled it off the original job application
And
because.
so this is a post-approval amendment, and you
Exactly.
completely fill out the form to, I guess, update the.
Correct. Right. We didn't want to open a brand new application because honestly, that would probably open another can of worms. Plus, we'd have 2 applications, and we were also moving everything that was moved under our appeal and everything that was moved under their modification was all under that job application. So it made sense for us to submit a PAA under the original.
But so therefore, it wasn't a no work.
No, but I guess let me correct that. When we were saying a no work, when we were submitting the PAA, it was with the intention of obviously we're not changing anything apart from the language, which is why the notes on the PW1, which I think they submit, it says that it's done for the purposes of administrative to change the language on the certificate of occupancy.
Says herewith filing a post-approval amendment to answer audit objections and to revise the Schedule A to read use group 16, regulated medical waste transfer station as one of the uses on the first floor, revising the plans to reflect the wording.
Right.
So there were also plans.
Well, yeah, well, we have to submit plans because the DOE won't accept
So,
anything
I mean,
about
to
it.
sort of cut to the chase about this, right?
Right,
There's
right.
2 parts of the chase. One, I want to say is that, as you know, the prior decision was a very, very lengthy review process where we struggled over what in the world this use is, right? And the board, uncomfortable that use group 18 would be the description for this particular use, said, well, somewhere in use group 16 it's falling, but we don't really know what it is. So we need a further description on the CO to characterize as clearly as possible what the parameters are, because we don't want it to turn into effectively a use group 18 transfer station, right? So to let's say, underplay the importance of the change on a CO, I think is disingenuous. We're not saying that your CO was correct before. We're saying because it wasn't an accessory use to an ambulance or whatever repair facility, that was completely incorrect. And as you know, the whole community was watching this. And as you know, this was a very public and controversial subject, right? So in DOB's defense, you can understand why they would want to hold to the protocol, which it says very clearly in the building code that there is no such thing as a modification of a CO in the building code. It's either you amend it or you have a new one, right? And then you go to the inspection and it says no CO shall be issued absent the inspection. So as to just repeat what Commissioner Ollie Brown said so correctly a while ago, you can't, for one, you can't change their protocols, in part because in the building code it says they have to do it. It'd be different if this was something where occasionally they issue sort of little administrative notices or whatever, and they vary according to convenience. But in this case, I would just have to say, if you want to get this done, you should let them inspect, fill out the form, and just do it. Otherwise, we may be in the position where we have to kind of make you do it.
Well, here's the thing. So, and this is what I was mentioning to the Department of Buildings earlier today, and which is what I was trying to get across so that we don't have to waste anybody's time here today, is that we wanted to agree to the adjournment because I thought, or the owners thought, that we'd be able to kind of resolve this between the two of us outside without having to come here, because I think that at the end of the day, we would get where we needed to go. So we have nothing to hide, obviously, and we have 100% been cooperative with regard to everything that has been asked of us to submit it in a timely manner. I think, and we will have it. If that's what it needs to get done, then obviously we'll do it. I think the major concern, and I don't think the board can do anything about this, but the major concern that the client has is that, because this has been something that has been kind of up front and center in front of everybody, and because the Department of Buildings is also sensitive to this, and we had to go back to the plan examiner 4 times, and there might be some, whether it's misunderstanding or the fact that they had to reverse their own decision, I don't know. But we wanted to avoid having to go through another 4 or 5 times of an inspection in a PW7. We just want to get to the end. And if, and I understand why, the conversations I've had with DOB's counsel is that, yes, they have been cooperative, but when it gets down to where it needs to go, there is no communication happening at that point. And I think that's our major concern, is how do you control that?
Right, so we can't control it.
I know.
But counsel is here. You have 2 counsel sitting here hearing your issue. They can make a phone call to the commissioner and say, please expedite the inspection.
Can't they go as well? Could one of you attend?
The inspection, you mean?
Yes, to ensure that whatever communication gets clearly communicated down the line. There's no better way than for
Yeah, we
council to
sometimes have that.
actually be present during the inspection to determine the scope of the inspection and determine that it actually complies with what's required to get a new C of O, and is not a fishing expedition, which is what I think you're afraid of.
That's exactly right.
That this becomes fishing expedition, and it shouldn't be.
Right. Yeah, we're just trying to have a regular inspection.
That's right.
Like you do on other buildings that are not high profile.
Yeah, I understand what you're saying. I don't know that it would be normal protocol, but I have to say it's very frustrating to sit there and listen to this. The board voted on September 10th. Owner took no action until November 1st. And then I admit there were hiccups with the plan examiner. DOB, then plan exam approval happened on the 19th. So they did nothing for 50 days. I worked closely with our Brooklyn office, got the plan exam, got the plans approved in 19 days, and then no action, no CO was requested until the deputy executive director asked for a status update. So it's very frustrating to sit there and listen and have the DOB painted as interfering with this process. I just don't think that's fair. There's no
I don't think that anybody is stating that DOB is interfering with the process, but having managed a large agency or a large department in an agency, oftentimes the communication is not clear all the way down the line. And so you're thinking something, and maybe the people who report to you think something, but the person in another borough has got his own
Commissioner,
issues and his own views.
I totally acknowledge your point. That did in fact happen here. My point is that the timeline here is that was resolved in one day, and they did nothing for 50
Right, but you
days,
can
so.
understand, then there would be fear on their part, because I would be fearful as an applicant of going and completing the process without having some kind of oversight.
But I don't want
That's
to,
all.
it's not our job to manage how
Right.
DOB functions, but you heard the concern, and so that, all we can say is, you know, do the best you can, kind of, in the light of this, and whatever has happened,
I understand.
and let's move forward, so,
Then I think the
okay.
cooperation should be on both parts,
Yeah, property owner also.
property owner also.
Right, right, okay.
So I think that despite all that debate, I think we both agree to a 3-month, we both request a 3-month adjournment, which, again, I think now that we're we both fully understand what the process is, should be more than enough to allow the final updated, the final new CO to be issued.
Okay, great. Are there any other speakers on this? Fine.
Okay. Continued hearing on March 24th, 2020.
Special order calendar, continued hearing items. Item number 3, 86348BZ, 25916 Union Turnpike, Queens.
Sorry, I'm still scrolling. Okay, I think Mr. Duarte is not coming today.
Mr. Duarte is under the weather, so he won't be able to
Yeah.
appear. Neither can and he was not able to have the owner come and appear also. He asked for short adjournment.
Right, okay. This was one where we asked that the owner come, and the owner is not available, right? So we do want to put this on for, did he say the end of January or early Feb?
He's doing the knee surgery and, he said maybe like the middle of January, because he said he would be doing surgery in about 4 weeks, but that's before
What'd you
his
say?
surgery.
February till February, because
Mid-
it's going to be winter,
Yes.
and that may slow down his progress in rehabilitating his knee
Yeah,
afterwards.
okay. So, end February
And
then.
plus, we could
Okay.
probably catch up on that landscaping.
What?
There's there's
Not
landscaping.
until spring.
Yeah, landscaping cannot be done.
Can't do anything unless we
Right.
have a very odd winter.
Considering we're having snow tomorrow.
Is there sufficient
Uh,
to respond to comments?
Well, yeah, I mean, to the extent there, so most of it is about doing physical work, so I don't know what comments there are to respond to. We were supposed to see landscaping, and we know the plant, well, by the end of February, all the plants will be dead, so that will prove out the
Your point,
theory,
right.
right? So if anything, maybe a set of photographs submitted, but he's not going to be able to go out and take photographs
Did FDNY submit a recommendation?
on this site. Anyway. Yeah, I think it was a letter of no objection if it was on
It's a
this site.
recommendation with certain improvement being done.
Wait a minute, we had one from a while ago. No, we had an old one. We had one from the last initial hearing.
Yeah, I believe I have
Yeah.
in my note.
Yeah, yeah.
In line, yeah.
Okay, so, I don't, other than photographs, but I don't know that he's going to be physically able to go out and take photographs. So maybe his, the tenant can take photographs of the conditions on the site, and that's the only submission, that's all I can think of.
Okay, and the owner needs to appear next time as well?
Yes, owner must appear.
Okay, so submission of photographs updating the board on the site conditions, February 5th, 2020, with a continued hearing on February 25th, 2020.
Item number 4, 1715 61BZ, 12902 Guy Burlow Boulevard, Queens. Please come, hi, you have to come visit me, please. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions? Please sign in.
Please state your name for the record.
This one shows.
Good morning, Madam Chair and Commissioners and staff. As you know,
Say your name, please.
Michael H. Choi, the applicant. As you can see from the application, this store is a very small store. It's approximately 15 square foot. And the store has been at the same location for over half century. And the current owner, who is sitting there, has operated a dry cleaning store for over 30 years as husband and wife working together every day, except Sundays. Now, I attended a review session yesterday, and there was a mention about the boiler violation, and I checked the building department record. There's no boiler violation on record, and the owner never received any violation notice from anybody. But I spoke with the owner, and according to the owner, there was recently annual boiler inspection done with an inspector who was designated by an insurance company. He asked the owner to do a couple of things, according to the owner, which the owner thought was not necessary, but nevertheless complied with as a small business owner. Let me briefly explain about the situation about the boiler room.
About the what?
The boiler room,
Okay.
yeah. There's no fan in the boiler room. The boiler is connected to the chimney, and the air comes out through the chimney. I have some photos about the things that the owner and the inspector discussed. Let me bring the photos if you need.
You sent that yesterday, though, right? Okay. Just remind her.
Yeah, the first one, the first page of the photo, you know, you see the boiler is connected to the chimney, and there's small half-brick size, there was small half-brick size opening and or hole, and the inspector pointed out, and this is closed. That's one thing. The other one is there's also small. It's on the second photo. Small hole or opening between the store space and the boiler room. It's approximately 11 inch by 6 inch, very small size. It was there so that owner may, from time to time, observe the inside of the boiler room. but in complying with the request, they closed. So everything has been done. There's no issue here, and also, as a matter of the requirement, owner will have to comply with the annual boiler inspection by the end of the year. So it should not be the cause for delay. So I request the board approve the application.
Thank you very much. Are there any other speakers on this?
Also, Madam Chair, the project manager emailed you yesterday.
Yeah,
The
that we
compliance
had-
officer.
We had a
Comments?
DEP, oh, really?
Well-
We had a DEP confirmation that there are no pending violations on air emissions. Was there something else that I don't?
No, I just want to make sure that you said.
What was that was what you're talking about?
Boiler.
And what?
Air and boilers are valid.
Yeah, okay. Okay, good. So then I'd like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Well, this is a request for an extension of term and an extension of time to obtain a CO, which expired because of the term, really. So I'm not really sure why you need an extension. It's really, the term expired, right? So, right.
Only
The
if,
term,
I'm sorry, just to clarify. You will require it if it was a condition that a CFO were obtained by a certain amount of time
Oh.
prior, and that didn't happen? Or sometimes the wording is just that you need to update a new CFO because your term's expired?
yeah, it really is that, because they had a CO in 2011.
No,
So
CO
they weren't
So it
expired.
just expired. Yeah,
CO
yeah.
I'm so sorry, CO expired in 2017, not 2011. This typo.
Yeah. No, that we know.
Yeah.
So it was issued in 2011, expired simultaneous with
Yes.
the expiration of this
Yeah.
approval.
So it's an extension of term?
Yeah, so, right, so then the extension is a 10-year term. We could start it from now. I don't see any reason to start it from 2017, right? They're here, they're complying, I don't know. I don't, never really understand that. So I'd like to make a motion to extend the term for 10 years, starting as of today's date.
And there's going to be a condition that the board takes no position on the legality of the.
Yes, right, correct. That the board takes no position on the legality of those fans that are shown on the drawings as exhausted
But it
to
was
the
approved
sidewalk.
already by the building department, right?
Yeah.
So
But we just don't want to opine, we don't want it to look like that the board approves those fans.
So
So
Madam
we
Chair,
say
but
that-
if you don't say anything, then
Yeah,
you don't steal any position by
Yeah.
saying nothing about that.
right, but we have to say that we take no position, otherwise it could be construed by Department of Buildings that we approved something that we didn't look at. So if they're legal, fine, and if they're not legal, it's not our department.
Well-
And it could be, I'm sorry, we're done with this
Sorry.
discussion. Okay, so I'd like to make a motion to grant on that condition.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Thank you very much.
Thank you very much.
Item number 5, 17193BZ, 3245 75th Street, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions? Please sign in and proceed. Print your name, yeah. Print. Very good.
Good morning, Fan Baton from Sheldon Lobel, PC for the applicant. We attended yesterday's review session. Were you able to see the submission that we made last night? I have some hard copies, I don't know if you.
Yeah.
Thank you.
So just to review the submission that was made last night, the architect provided some more details regarding the signs. There's a sign calculation on A003 and A004. Those were the only two pages that were revised. And his version of a bubble is really a line around the calculations. We don't believe that the no parking signs count as signs for DOB, but even if they were to count towards the sign, as a sign per zoning resolution, it's still under the 150 square feet that's permitted. So either way, we're still in compliance with C1 district regulations.
Great, okay.
And also in the packet, we included the receipt for the New York City Parks application for street trees. So those were applied for, and the receipt's in there, and the Parks Department is currently reviewing.
So it says, this is to confirm your plan review application received by Department of Parks?
Right, for the street tree
It
application.
just doesn't say how many trees, but do I assume that?
It's the BSA plan. It's the
What?
6, I think it's the 6 extra trees. It's matched up with the BSA plan.
How do you know that? You don't know that. The attachment doesn't
I
make.
could, if we do a second call, I could just submit it. I could submit the
So,
application.
no, I guess that's my question. How do you know when you look at this?
I have the application as well, so I
Oh,
could
you do?
submit it. I
Yeah,
could submit
if
it
you
from
could
the
do that,
architect.
that'd be
So
great,
I'll just,
yeah.
I'll submit it. It
So
shows,
let's second call it so we have the full material.
but
Great.
while we're here, I'm joined by Mark Lasher, who's here to talk about the parking concerns.
Great, okay,
and
thank you.
operations.
State your name for the record.
Mark Lasher.
Hi. So what we were having trouble with is, thank you for coming, by the way. What we were having trouble with that there was parking on the sidewalk right in front of the sign that says no parking on the sidewalk. What are we going to do?
Yeah, well, we've been there since 1937 on the boulevard, and we try to really control everything. We have 300 employees and 70,000 customers, so people tend to just pull up on the sidewalk sometimes and park, but we have people in place to move them. Our intention is never to have cars on the sidewalk because we know people walk there. But it does happen on occasion. New York's a crazy place. We have a place for customers to park. They could pull in there and park. Sometimes they prefer to double park or put on the sidewalk. But, as soon as we see them, we make them move. That's really what we have to do.
So that's your protocol, is that you may, it's not actually one of our commissioners'
I have
experience.
seen one of the guys working at the place where the car was parking, and actually he saw it. And then I tried to talk to him, and he said, no, go to the front desk and talk to the people.
Okay.
And honestly, when I went to the front desk, they were like very cooperative. He came out immediately, and I hope they took an action.
Yeah.
But
How many cars
I
were
believe
there?
it was one of your cars. It wasn't like somebody who was trespassing or he left the car on the sidewalk. No, it was inside our car.
Oh, it was one of
It
our
was
cars.
what?
It was, the car was, I believe it pertains to somebody from inside the facility, from inside. the
A
car.
staff
workers,
person?
Yeah, maybe. Because when he parked, the other guy, the guy from inside saw him, and he didn't object. So,
Yeah, well, again, with 300 employees, anything's possible, and, the amount of traffic there, but was it one car on the sidewalk?
just one.
Okay, so it can happen sometimes if they're, say, moving a car out and something like that, they might do that. Maybe they're not trained, maybe they're new employees, but I mean, as a general practice, you look up and down our sidewalks, I have closed-circuit TV, we keep it clean,
The site is clean.
Yeah, we keep
It's
everything
beautiful,
nice.
I would say.
Yeah.
Don't block the view to the site by parking on the
We
sidewalk.
try our best, and we'll try better. I mean, I can implement some new things to, try to make it even better, but there's always gonna be somebody doing some
Do you
stuff there.
have a way to reach out to the employees and tell them that?
Oh, absolutely, yeah.
And what would that be?
Well, to give you an idea, when we hire a new employee and that we onboard them, because so many people drive cars in our business, because it is a car business, we make them sign the Vision Zero initiative, that they understand it, that they'll abide by it, and all that kind of stuff. So we do a lot of things, but it's, biggest thing we do is have 300 employees and give them benefits and they're union employees, and we really try our best to impart to them that it's a community, it's a neighborhood. You know, when you drive your own personal car and even when you're leaving or coming from the store, you know, you have to be respectful of the community and,
You think you could send your employees a reminder not to park on the sidewalk?
oh, constant.
Is there a sort of a
But no,
location
employees
manager?
don't park on the sidewalk.
Is there a location manager at the site?
There's a service manager, yes, at that site, and he's responsible for making sure. We have closed-circuit TV, so when we see something, we usually go right out there and,
So the TV can see the sidewalk?
yes.
So since you need to come back for, we'll call second call, where you're just gonna make a slight change on, give us a little additional information on the trees, could the two of you talk about an operational plan that you would type up, have your office type up and submit to us? What you're going to implement to ensure that cars are not remaining on the sidewalk. So, you know, just throwing out an idea, your service manager, and there's either you need an additional camera, or maybe you have enough cameras?
We have sufficient cameras. to
Okay, but so
do
the
that.
service manager will check several times a day or something like that and make sure that the cars are removed, or, you know, I'm not sure exactly how this works. Sometimes we see signs that say no parking on the sidewalk, cars will be towed at owner's expense. I don't know if that's what your no parking sign says, and if it doesn't, then maybe it's worth changing
Yeah,
the sign.
we try to stay friendly to everybody. It just says no parking on sidewalk, but.
Right.
But I
the
think the camera initiative is a good idea. We do it, but I didn't do it as a protocol.
But if he sees the car parked there and the driver's not there, then what, right?
Well, we can usually find out who it is, because if it's there, somebody's in our establishment getting parts or
Oh,
doing something,
okay.
you know. But-
And as Commissioner Shibata mentioned, maybe circulating another memo to the staff
Yes.
stating that no sidewalk parking is permitted
Absolutely.
of any vehicles of any type.
Yeah. Like I said, if you go by, you take a look, I mean, if there's one, that would be it. You know what I'm saying? It's not like we park cars up and down there. We try to keep it.
No, right.
There's a lot of old people pushing shopping carts and stuff like that. We know that. And, you know, we try to make sure it's clear for them.
Okay. So if you do a protocol, then,
Okay.
okay, thank you very much. Second call.
Thank you.
Thank you.
New cases, item number 6, 76456BZ, 20005 Horace Harding Expressway, Queens. This is a request for postponement on this.
Right, did he say, same time period then, right? End of February?
Yeah.
Make it the same as what the
Okay.
other one.
Well, if there's a submission, February 5th, 2020, with a continued hearing on February 25th.
Yeah,
It's
you have-
actually a postponement, so this is a new
Okay.
hearing.
Yeah, but he needs to make a submission. I asked him for additional information, so,
Oh, okay.
yeah. So it's postponement anyway, but, so he has to do new notice. Oh,
Does
shoot.
this have to be renoticed?
Yes.
Yes,
Yeah.
it's an amendment.
Mm-hmm.
There should be also an instruction to the administrative staff to resend out a notice.
Yeah.
Yeah, I usually put it on the vote sheet, new notice. Item number 7, 75178BZ, 200-15 Northern Boulevard, Queens. Do you raise your right hand? Ah, I think you're getting away with it. Do you affirm the truth, the whole truth, and nothing but the truth in your testimony before this board and respond to the board member questions? Making me work for it, be careful.
Good morning, Todd Dale for the applicants. So we were in attendance at review session. I know there were certain questions that were raised.
Right, while you're looking, I just want to, I believe this is the one that Mr. Hewler sent a letter on.
I didn't see the photo. Is he talking about the photos in that were submitted by the applicant? Because I just emailed him to say, look, I didn't see the photos attached unless it's just me.
I believe those photos may have been from a previous letter,
Oh, okay.
Oh,
but
so,
I'm happy to respond to issues in that letter in conjunction. with
Yeah,
this. But I don't know if
that'd
you
be
want to read
great.
the
Okay.
letter or. just make note of it.
I
We
mean,
just-
the comments were similar to what we had from the community board about the clothes bins, the trash storage. Really is a problem with the tires being stored outside of an enclosure during the day.
Sure, I can speak to all those issues.
Yeah.
And jump into those. I can start with the easiest one, which are the clothing bins. Those
Okay.
were removed as soon as the property owner found out about them. I was at the site yesterday, they're still gone. There's no intent to bring them back. So I think that addresses that issue. The tires, I actually, since I was here for this case, the last time I was before the board, I think only Commissioner Otley Brown was here. I don't know if you remember this one, but I want to pass up 2 copies. These are 2014 photos to sort of put the tire issue in perspective, because it was an issue before and what's going on now. When these photos come along, you'll see, I don't know if it's both sides or if it's just the one, but at the time of the previous action, there were permanent large tire racks that were always outside on the site, and that was the tire issue that came up at the time. In conjunction with the previous grant, those racks were removed. The operator changed their inventory process to store far fewer tires at the site. They try and do more in order on an as-needed basis. The tires that are currently shown, I believe it's photos 3 on the most recent photo set that was submitted with this current application. The way the tires work now is when they are closed, the tires are all stored internally. And I believe Mr. Euler reflects that in his letter. They store them actually in the bay where they do the work. During business hours when they work, they move those tires out and they do stack them along the wall. And they do endeavor to try and stack them so they are not taller than the wall. There's sort of a split wall that's on the eastern frontage. Portion of it's 5'6" and portion's lower. And I think if you look at photo 3, you can see they try and mirror the wall so nobody can see it. So,
Well,
I really
not
don't
nobody
believe-
can see them. The people who are living in the buildings behind, but otherwise you wouldn't have been able to take the photograph. Obviously, everyone
Well,
can
you
see
can
them.
see them, but they're also out only when people are actively working on the car and the cars are there, so it's not a constant disturbance. Really, the issue that was raised by the community board before was that these tires were always out, they were ever present, they were sort of over present because these tall, large racks that were there. And to try and work with the community, they really did change their operation plan to try and minimize the amount of inventory they have. They would still like to continue with this operation procedure where they keep all the tires stored internally when it's not, when they're not open during non-business hours. But during business hours, it's helpful if they can pull and store some items on the side. If it wasn't the tires, it would be like some of the racks that they use and they move. But everything is stored internally unless they're actively in business.
Well,
So-
my question is, since there are sort of 3 points of contention that are being raised by the community, or 2.5, say. There's the big storage container. There's the dumpster that's not in an enclosure.
Correct.
And there are these tires that, like, inconveniently, the workers have to pull out of the workshop every morning and put back every evening. Why not put them all in a fenced, slatted enclosure or a PVC fenced enclosure? All that stuff is inside there, then they can kind of do what they want. Oh, and the other thing that Mr. Euler mentioned was that behind the storage container, there's sort of this no man's land,
Sure, I
which
can speak to
becomes this trash opportunity. So if there were an enclosure with a fence all the way around it, you would discourage people from
No, I understand what
using
you're
that.
saying. A lot of this is deja vu, so we're going back, because
Okay.
I know you weren't here, so I'm going to go back. The reason that they have that current storage container as approved is it allows security, because they can lock it up. You have a PVC or an enclosed, if it's not fully enclosed, people can jump in and steal tires and steal materials. So having the locked enclosure is very important to them, or bring it into the building, they can lock it at night.
Okay.
You talk about the inconvenience. If the operator's willing to take this effort to move them out in the morning and move them back in when they're closed, obviously I don't think it's an inconvenience, because they're willing to do this in order to work with these issues. I mean, really, the core issue that was raised about the tire was, if you look at those racks were bad, and they needed to be removed. And they did remove them. And they really did revise their operation plan to have far fewer tires on site, but they still need some tires on site, because even if they order them on an as-needed basis,
Understood.
somebody is 6 hours late for an appointment or says, I can't come today, they need to have some on site. So this really is a balance between understanding, the community's concern about the appearance, but also allowing them to operate a business that's been there for 40-plus years.
But
I just
so-
have a question.
You go
With
ahead.
regard to originally there was permanent racks outside.
Yes.
And there wasn't any concern about them being stolen at that point, the tires being.
I think
So
what they-
I believe what they would have done is probably put a chain through the
Put a
tires.
chain through it, exactly, yeah.
So I guess if their chain through the tires was still the case behind a fence, wouldn't that solve that problem?
Because then you have to on-chain and fence, it just adds a different
I
level.
understand.
I understand what you're saying. There really was, I just want to, the big overall picture here is there was real consideration given
you
to,
can see that.
To what
Okay.
the community did, and they did that.
Mhm.
And, I understand, but, they would agree to a condition, and they really do try and do it, not to stack the tires higher than the wall. They understand that the wall is there, and as you can see, they try a pattern when they do bring them out in the morning to respect the wall and not to be obvious. So, the hope is that they can continue with this procedure. The one thing I will also say is that I know Mr. Euler wrote a letter, but no violations have been issued and no other complaints. When I went to the community board myself for both the committee and the full board meeting, nobody from the public had any issues about the operation of this site. I think that a lot of the comments that Mr. Euler made in his letter are less corrective and more preventative, and I understand that. So, I'm happy to listen to conditions and bring them back to the operator and the property owner about the tires, but we do believe that this system is reflective of a response to the
Oh.
2014 and trying to really work.
I don't think there's any sort of accusation that,
Okay.
it's not better or you ignored the direction of the board or anything like that. But it's the last time, it was a 2013 10-year extension, right? From, that dated back to 2009, right? So, in other words, you're back all those years later, and then you get to observe what's going on.
Sure.
And then say why can't some behavior be modified, right?
Sure.
So I continue to look at the same question and why you couldn't keep the tire racks in a storage enclosure, because the other issue is, what about the trash container, right?
So,
And what
respons-
about that little area behind that fills up with trash? Like, how do you prevent that?
I'll speak to that little area.
Uh-huh.
When I was there Monday, it was cleared out. The operator, as informed to us, checks it daily, because once they were made aware of this issue with the bus stop, there is a bus stop at the end corner of that triangle, and they're right, that's generally people at the bus stop throwing things in there because there's no public trash can there. They do check that daily. I believe that Mr. Euler referenced as a Sunday visit, they're closed on Sundays. So if there were items that were back for Sunday, if they're doing daily inspections when they're open for business, if something's there Sunday, they're not going to see it till Monday. But they do check. I've been there, as I said, I was there yesterday and there was no trash behind there. And I regularly go up and down Northern Boulevard because we have this client, we also have other clients trying to check sites. You may remember Star Toyota, I drive by them, I do try and check on these sites. I haven't personally seen a continued issue with trash there once they were made aware of it and they regularly inspect it. So we would agree to daily, checking of not only that, but the entire site. And I think the site as a whole is generally kept fairly clean. I don't think that there have been complaints about that. With respect to the dumpster, when issues were raised at the committee meeting of Community Board 11, we went back to the operator and they requested an increased pickup schedule. I haven't seen an overflowing dumpster since that time. I don't know if anyone else has, but since that time, I haven't received any complaints from Community Board 11 or any known issues. They do store the dumpster right there for a couple of reasons. One, it's the easiest spot in order to get access, but also because of the unusual shape of this site. If they move the dumpster elsewhere, they would actually eliminate a parking spot for a car. That's really, if you look at the strange setup of the site, there's like a little concrete ledged area where they have seats where customers can sit while waiting for a car. And there's like a little alcove, which is where the dumpster sits right in front of the building. It's screened from the sidewalk with the parked cars. If they moved it to that back wall, they effectively lose a parking spot. So that was the thought about keeping the dumpster in that particular area.
What's stored in the container?
Supplies, I do know that there's some tires that are stored in there. They do other work beyond just tire work, I believe like mufflers. I'm not a mechanic, so I don't know all the materials they have in there, but it's generally supplies for the repair work. I don't know if they, I think they also may at times store one of those dolly lifts that goes in there also if they don't have room within the bay.
The owner was here last time, my recollection. He was very responsive to the board's questions and the board's conditions. Like, he was, I mean, it may not have been the color choice that
The color was the sticking point,
or
yeah.
the board was interested in, but he put a lot of thought into it, you know, in his defense, and he actually thought he was beautifying the site and matching the storage container to his site in terms of color.
Yeah, the mauve storage container
Yeah,
matching the
to
building
match
was
the
a
pink side.
considered choice. I also, just to speak very quickly, I know that there was reference about a car being parked. There was at one time, and Mr. Euler referenced, I think when this was first filed, when they did have one car waiting for service, it did encroach slightly on the sidewalk, and they immediately moved it back, and they're very careful about checking the sidewalk. There's a car on the northern side that was referenced as far as parking on the grass. There is actually a Christmas tree vendor who is selling Christmas trees at that little corner by the bus stop. They have a license from the city. They have a relationship with the operator. They don't ask for any rent. They just ask for the space there. That Christmas tree vendor drives his car up there. We've spoken to the property owner and the tenant and asked him not to pull the car up on there, but that's what that car is. It's not the shop. It's Santa Claus who's pulling his car up on the northern side there.
Santa Claus, right.
So, but we've asked him not to do that. As I said, I was there yesterday. I did not check today. I don't know if it's been removed, but they've been informed that they can't do that. That car that gets pulled up there doesn't block the sidewalk, just to confirm. It's just,
So if we
and I can
just,
guarantee it's gone in 2 weeks, so.
okay, but in terms of the landscaping, since there is none, if you were to, I mean, that, it really should be landscaped, right? It was supposed to have been landscaped, and now it's just sort of dead grass, right? So, yeah, did you want
If
to?
I can speak to that, the discussion with that, when it said existing landscaping, that references the grass that was there. This landscaping actually came up as a discussion at the last hearing. And what we pointed out is that this is the only site on the block. There are no adjacent residential uses. The closest residential building is the one to the north, which is adjacent to the P.C. Richards, and then there's one to the east. Landscaping there at the previous hearing was determined that it would be superfluous because there are large existing street trees. And by putting any sort of landscaping in the building, it really wouldn't serve any purpose because you have trees on the north and east side, you have a row of parked cars, you have the street, you have another row of parked cars, and then you have street trees on the far east and the far northern side of both of those streets. So if you put any landscaping there, the residential uses, they don't see anything. They can't see, you know, anything at the side of the building if you put like small bushes there adjacent to the building. So the thought was that it doesn't provide any real effect. It's not a situation where this is a blank view to those nearby areas. So that was the discussion that happened at the last time. When it said existing landscaping, it just refers to the grass that's maintained adjacent to the building.
I don't buy any of that.
It's the truth, though.
No,
But I
I'm
mean-
not saying it's not what was argued, but I'm looking at it and looking at this sort of abandoned grassy area on which cars could park, right? And you're in this residential neighborhood where the guys who are across the street on one side are looking at the side of a commercial building located in a residence district, right? Plenty of room to put shrubs.
If you look to the north, the building that's to the north has a large gap, and there's a tremendous number of trees. They're also more immediately adjacent to the P.C. Richards, which is fronting on Francis Lewis Boulevard. And to the east, there is a residential building there, but it's also immediately adjacent to another commercial building. So I would say it's not a residential district, it's a mixed-use district, and anyone who's been on Northern Boulevard knows that it's actually more commercial than it is residential. That said, we're respectful of those neighbors, and, you know, that landscaping there, this is not a situation where it's blank. There are large trees there on both sides of the street, and, you know, nobody who's immediately adjacent to it.
Not on the east side, though.
There's trees on both sides of the east side, yeah.
Yes, I only see one on one end.
There's
and
two
one
on our side, and I think there's two on the other side of the street. So in any case, I mean, I know landscaping has been an issue, and it's been discussed with applications, but because of the particular nature of this site, and it was something that was discussed at the last hearing, this is in and of itself, they are on the block. If there were another, use right next to us, I could see the benefit of that. But in this case, you're planting for planting's sake. It's not going to screen anything.
No, you're planning for residential character's sake. That's the whole issue.
Well, I would say if you look then at the other buildings in the area, nobody else has any planting next to them.
Well, but they're not-
I mean, I've just been there. There's nobody who's got planting like you're describing at
Well,
any
not
of the
from
other
the
buildings in the area.
But yeah, they're not before us. I don't know if they're illegal non-conforming uses, or they're coming the next time, or, right?
I think, I know we do require landscaping in this side, and when I'm comparing it to the PC Richards building, which is probably in the commercial district, it has no landscaping. This is a standalone block and a lot with a lot of frontage. And I think Northern Boulevard, and this is, even though it's zone residential, it is definitely part of the Northern Boulevard character, which is commercial. And none of the, I think the trees are quite substantial, and they provide the streetscape that is very much we desire to see in the residential area. And I mean, the grasses don't grow because most of the time it's in shade. And so.
Well, all the more reason why you should plant it with something.
I really don't think it's going to make or break anything here because of the location. The residential buildings that are there, they're seeing the trees mostly.
I would also just note quickly that it is a commercial district. The reason it's here is just because of the use, but it is a C2 district. I just want to clarify.
It's here because of the use.
Yes, but it is a C2 district.
Okay,
So
commercial.
it's a C2 overlay on ours,
C2,
yeah,
mhm.
C2-2.
All right. I don't
The
agree.
only other comment, as I know it was in Mr. Euler's letter, so I just want to speak to it. There's a question about the hours. We would like to maintain the hours of operation. At the previous hearing, we actually did a survey showing the hours of operation for other businesses. In the immediate vicinity, immediately across the street, are two 24-hour restaurants. There's a 24-hour 7-Eleven that's across the street, and then the PC Richards is open till 9. This site is actually closed on Sundays. The allowing to be open to hours, the operator prefers to stay open to 9 as they have been. They haven't received any complaints, and they just find that their clientele appreciates those little bit of extended hours. So we're hoping to keep those hours the same as were previously.
I just want to go back to the landscaping. The landscaping area that we are referring to, it's outside your property line?
No, it's in the property
It's
line.
outside, based on the diagrams.
I will double check.
Because I haven't seen
It
this.
may be a portion of that, like, because the sidewalk and the extension of the street, we don't have a survey with this one.
At least where the property line is drawn.
It actually, I actually believe it may be outside the property line, you're correct.
So weird.
So the property line is, the building is right up to the property line, and that existing cinder block fence is the limit of the property line. So that is correct.
Okay.
I just want to correct, your statement says Pep Boys is open till 9, but if you go on the website, Pep Boys is open till 7.
Okay.
And is Prella Enterprises also auto use?
All right, so the Pep Boys, I can double check that, hang on. I believe they may have been open till 9, but if it's 7, okay. Corella, did I put that in?
Because you list Prella Enterprises as being open till 7.
Commissioner,
I was just wondering, is
the mic,
that?
the mic.
Yeah, you're listing Prella Enterprises as being open till 7, and I'm wondering if that's another auto-intensive use?
Let me double check. To be honest, it's been a little time since
Because that's who you should be comparing yourself to, not to 7-Eleven necessarily, because the complaint by the community was the machinery making noise, and that they wanted a break from the machinery noises after 7.
After 7 or after 8? I thought Bueller said.
Right, he said he would concede and let
Yeah.
it be till after 8.
Yeah, oh, okay.
Is that from a previous, I'm trying to double check here, I'm not sure where I see in the statement.
It could be your previous statement.
It
I
may-
don't
maybe it
know.
is
I
from-
just read
Okay.
a statement. You know, sometimes
Okay.
our system is not the most updated.
I will double check, just from recently when I was visiting, took a look. I know the PC Richard Hours, the 2 restaurants across the way, and that. I do know that the Pep Boys is more removed, it's closer to the Clearview Expressway. At this point, I'm not familiar with that particular use, but I could check on it. But I do know that, in reference to this, again, when I was the community board, both at the committee and the full, I received no specific noise complaints, no neighbors came to testify at issue. This comment that was made about the hours was made at the last time. The hours were granted to what they are now, to 9 o'clock, Monday through Saturday, and there have been no known issues with their operation. So, lacking, specific issues or specific neighbor complaints, we would request that we get to
Well,
maintain these hours.
Prella is auto service.
Thank you.
This is an extension of term, so you don't notify immediate neighbors. If you really wanted to argue that the neighbors aren't upset by the hours, then you'd have to notice neighbors, right? If neighbors aren't notified, they'd have to be aware there was a community board hearing about this.
I would argue then definitively that there have been no violations issued for operation and no known complaints that have been presented to our office or the community board.
No noise, it would be a noise complaint, right? It wouldn't be a
No-
DOB
No complaints.
complaint.
No, none that were issued, and at the Community Board 11 regularly will let me know. They're not bashful about letting me know when there are neighbor complaints that have been presented to the Community Board, and none are for this site's operation.
I
We
think it
also
would be
say-
fair to just give us the most recent survey about auto uses and their hours, and then we'll look and see if it's an unreasonable request.
I can do a survey of auto uses
Service uses.
in the area.
Would you also like a notice to the neighbors?
That's one way to check on whether the immediate neighbors find the hours objectionable, right? I mean, to make a statement that there have been no complaints doesn't mean, like, these 311 complaints that go to the DEP, I don't know how we ever find out about them.
I'm not sure that a complaint would be held when they're operating within the hours that they're operating.
Right, no,
So, like,
exactly,
there's
they're
nothing
allowed to operate, so DEP, it's not like they would issue anything, they might not even go out,
If it's within there,
Right. Yeah,
Then if this is
Okay.
agreeable to the board, this is what I will do.
okay.
Is we will go back to the operator. We will confirm that they still want the hours. If they're agreeable to Mr. Euler's suggestion, we
Okay.
would present that, and then it's a done issue. If they
Okay.
want to maintain till 9, we will do a survey of auto-related uses in the area. And then we will also mail the residential neighbors that are in the area, which I think are all to the north. Everybody to the south is a business.
is that the only issue that's open?
Well, I still go back to, why can't you build a little enclosure for all this stuff? I'm looking at the argument that you have that there's, you're gonna use up a parking space, right? And of course, the parking spaces aren't drawn, we only have a one-page drawing here, right? If you just draw a rhomboid around the trash container, it creates, not the trash, sorry, the container. It creates enough space to put a dumpster and tires and not take up a parking space, because you can't park, I don't think, next to the container. It's like not enough space before you hit the street. It seems to me.
What I can do is I can speak to the operator and the property owner and see if there's some form of enclosure for the dumpster that we can do. I don't think that anything would work next to the storage container, but perhaps there's some, I don't know, maybe there's like a little enclosure that can happen at south of the garage bay that's listed there.
No. If you just look at where the dumpster, now I'm looking at a street view and I see a car parked on the sidewalk in front of the storage container, right? So you don't want a car to be parking on the sidewalk adjacent to the storage container, so if instead there was a fenced enclosure that went from the property line around it to, around the storage container, I
So you're
believe-
saying, sorry,
Yeah.
where the triangle, so if you look at the plans, where the word storage container is, we could put some form of fence structure there that would basically be parallel with that storage container,
Yes.
and that fence then could contain it. I will
Yes.
bring it,
So it's parallel with the storage, not parallel, it's parallel with the property line.
well, the dumpster would be parallel with the storage container, and then we would extend the property line. I know what you're talking about, like,
Yeah, it's like a rhomboid or a trapezoid or.
I have, that's an excellent suggestion. I will present it to all the parties that be.
Okay, good.
How extensively is that extreme-most curb cut used?
You have to speak up.
How extensively is that extreme-most curb cut used that's close to the bus stop?
I honestly do not know.
Well, that's kind of, that's what you're saying, it would block that curb cut?
It may.
Yeah,
That's why I'm, because
I don't know, but that's something that we'd take a look at. I mean, we can respond either showing an enclosure for it, perhaps an alternate enclosure that works. It's definitely something that we'll present to them. I will leave it to the operator to decide what works best for the business, then work with the architect.
Okay, good.
Vice Chair, did you mention a lumen spread?
yes,
Yeah.
I had asked for a lumen spread. Are there sorry,
That's fine.
my voice doesn't seem to carry. So lumen spread.
This actually came last time. We didn't do one, again, because there's only 3 lights. I can present photos. There's no mounted lights on the north or the east side of the building. There's only 3 spotlights or lights that are on the front of the building, and they all point directly towards Northern Boulevard. So there, again, the previous hearing, there wasn't any issue.
Actually, now, what I'm realizing is this is a standalone block
Yes.
without any abutting residential properties. So whatever light spread it will have, it will at most
Like the sidewalk,
light the sidewalk, and so
Right, okay.
I'm okay with it.
yeah.
Okay.
I mean,
I take
we
that.
have had situations where the light is positioned in such a way that shines right into the apartment building across the street. So you need to make sure that they're turned away, which was one of the conditions before. anyway.
Right, and they do comply with that. They'll continue to do that. There are no lights on the north or the east side of the building, which actually eliminates that issue. So just to confirm the items, we will look at the enclosure for the dumpster, and then we will address the hour issues, either reducing them, or if we want to maintain them, doing a combination of use surveys and notification.
Good,
Okay.
okay. How much time?
We can do that pretty quickly. You know, I know that they're interested in moving forward, but it's the holidays, so how's this? We can be flexible with the board schedule, but if there was anything in January or early February, because they're interested in getting the CO updated.
You want them to do notification to the neighbors?
Yeah,
So,
Conditional,
right, so early February we have.
that'd be
I think
fine,
that's fine.
sure.
Submission date January 22nd with a continued hearing on February 11th.
22nd and 11th,
And you
perfect.
know for the notification
We've
to
done it,
neighbors.
sure. We
That
would-
they can write in or appear, right?
Generally, what we do is we take like a copy of another notification and just modify it and make
Right.
sure that's all the
But it's
information.
just to make sure, because sometimes the notifications often don't say you can write in or appear. And-
We'll do that.
and
We
you
get
have
the
to make
phone
sure.
number and everything.
Yes. good,
Okay,
Okay,
sure. Okay, thank you.
great, thank you. So
Item
let's take
number-
a- Wait, wait, it's 12. Let's take a 10-minute break.
okay.
So, I think
Mic's on?
that's fine.
Madam Chair, mic is on, not on?
Yes,
Okay, now it's
Madam
on.
Madam Tony, yes.
Second call item, item number 17193BZ, item number 5, 17193BZ, 3245 75th Street, Queens. Please remember that you remain under oath.
Good afternoon. Fan Baton from Shell and Lobel PC for the applicant. I just made a submission with the application that was made to Parks that the architect had provided to us, and it shows on the plans it's a proposed 6 new trees with the 5 existing trees. So the plans are in there. I've also revised the statement of facts. The statement of facts and findings to include an operational plan. The applicant prepared an operational protocol in order to prevent cars from parking on the sidewalk. The applicant notes that both the service manager and parts director and the manager himself have access to CCTV cameras that provide surveillance for the block. Anyone with access to the cameras will monitor sidewalk conditions for approximately every 30 minutes. The applicant, service manager, and parts director all have access from to the CCTV cameras from their phones, and he actually did show me a live stream while I was out there, and there were no cars parked on the sidewalk. Additionally, the applicant will periodically send memoranda to the employees reminding them about this protocol and to take any proactive steps if they see someone trying to park. Additionally, the applicant employs approximately 6 porters who will monitor the sidewalk.
Great, okay.
And all of that's in the statement of facts, and it's also in the cover letter that I just submitted.
Okay, terrific, thank you very much. All right, are there any speakers on this? All right, so I'd like to make a motion to close.
Oh, let me just get back to the page. Okay. Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, and then a motion to grant on condition. The first is that the fencing and landscaping and sidewalks be maintained, the building be maintained graffiti-free, as nicely painted and so on as it currently is, that there to be no parking on the sidewalk, and that the no parking on the sidewalk be maintained according to the operational plan, and you can make reference to the operation, you can make reference to the details in the operational plan in the resolution. And that, what else?
Street trees. The trees.
Street trees must be installed according to Department of Parks approvals, and maintained. Well, it's actually Department of Parks who maintains, so installed according to approvals. And signage shall comply with C1 regulations. I think that's it. Okay, so on that, a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you so much.
Thank you.
Item number 8, 6414BZ, 1320 East 23rd Street, 1. Raise your right hands. Do you affirm to tell the truth, the whole, keep your hands raised up, thank you. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board to respond honestly to board member questions? Thank you, please sign in and proceed. Is it not, ink not running? I think it is. Yeah. Get rid of it then. I'll never make basketball. Right there. I'll never be a basketball player. Shit. Silly.
Good afternoon, Lear Altman from the Office of Lear Altman. We did have somebody attend your executive session yesterday and heard your comments. First thing I'd like to do is to bring up Moshe Dov Stern. He is the owner of the property. He'd like to address a couple of items, one of which is the question regarding the financial constraints that he had run into that put the delay on and the reason for the lack of permits.
Please state your name for the record.
Moshe Dov Stern. I understand that there were questions why this took so long, why we're filing for extension of the special permit. And obviously, and I look at it very obviously, there were financial constraints. We couldn't move ahead with the project. Building a house is not a cheap project, and that's basically where we're at. And we came to August 25th, And that was at the time when the permit was to expire. I reached out to Lyra and I said, well, we'd like to extend. And she said that should not be a problem. We're still within the time constraints of extending this, and that's where we are today. Here before you to ask for an extension.
What were your constraints?
Financial constraints. I was pretty much underwater. You know, the first, basically, we looked at a 2-year process to get the first special permit. And in that time, there were bad investments and other things that held me to what I had to do. And it was trying to get myself out from underwater and not move ahead with a project like this, which is over $1 million. This is a $1 million project. And I couldn't do it at the time. Now I can, and I would like to get an extension, please.
So, okay. Are you living in the house right now?
Yes, I am. I've been living there for 13 years.
Okay. So, and the reason that you, for instance, didn't file for a permit or anything like that?
It's $35,000. I couldn't do it.
But you didn't even, the architect didn't file anything, didn't do
It's
anything?
$35,000. I could not do it. It's 4 years ago. I could not do it. I had to worry about feeding my family. I couldn't worry about filing a permit.
Okay. Okay, thank you.
Thank you.
Do you have a plan on how to move forward?
Absolutely. Hopefully you'll grant the special permit and then we file with the DOB, like we should. You know, I've retained the same architect and he's gonna take care of all the paperwork and move forward from there.
And you're no longer under these financial constraints?
I would say not as constrained as I used to be. You know, I'm not out of the water yet, but I'm doing better. I feel that if I started the project, I'll be able to, over the course of 2 years, I'll be able to finish it. Look, it's very expensive to build in Brooklyn. You know, I grew up in New Jersey. Over there, construction is half the cost. But this is what it is, and I gotta deal with it because this is where my family is, and that's what I'm doing. Okay? Thank you.
Thank you.
So here's the thing. You know about the Putnam v. Putnam Armonk versus Southeast case, which has to do with vesting, and then about whether or not you're allowed to continue construction once it's vested?
This is not a vesting case.
Sorry, do you know this case?
I don't, but I can pull it.
Okay, so
Pleasure.
you need to look at that case.
Pleasure.
And the issue with that case goes like this. First, you vest the permit, right? And in this case, since no work was done, the permit never vested. So in a situation where you have a special permit issued and work gets started in some way, you know, the board can look at some degree of work as having vested. For example, we had a case recently where there was a 4-year delay between the granting of whatever it was, the permit or the variance, and the date, and so no physical work was done. However, it was 4 years of permitting approvals that were worked on diligently throughout the whole time. So it was difficult for the board to say you haven't done anything because in fact there was 4 years of actively doing. So that was in the case of the Putnam, one way of looking at having substantial expenditures, which is one of the Putnam tests, right? It's one way of looking at it. It's a kind of a broader view to allow that permitting shows a real intention to proceed, right?
Right, that you haven't
But then
abandoned.
sorry?
That you haven't abandoned.
Yes.
The right
So
to-
the Putnam has a second test. So first you vest, and then the second part of it is, should you be entitled to proceed? And the first question is, have you abandoned the approval? So no overt acts of having the intention to proceed. There are no overt acts here of the intention to proceed. The other one is, did you recoup your investment? Well, there's kind of like no investment here, so everything stays the same. When we talk about recouping an investment, usually it's the developer buys a piece of property with the intention to develop and then doesn't develop, and so the investment is the purchase of the property, right?
Okay.
And then the third one, which is important in this case, is change circumstances that have to do with health, safety, welfare, or change circumstances in the conditions. And the famous situation with the Putnam test was that there was a lapse of time and the community had moved on to other sort of standards and had installed, in that case, other ways of handling sewage and so on. But in this case, I'm looking at it and saying, we've been doing these permits, these special permits for 5 years, and that this subject case came in before there was the acknowledgement, first of all, that the board didn't have the authority to grant the reduction in the total side yard widths to less than 13 feet. This one is reducing it to 10 feet, so that's the first part. And the second part was making clear what the amount of demolition was permitted to be. So in this case, when I look at the drawings, I see that the house will be basically demolished with the exception of maybe, I don't know, 15 linear feet of exterior wall. So that is completely contrary to how we are clearly operating today. So I would have to say that because there were so many changes in circumstances and no overt act on the part of the owner to take advantage of the special permit, that it's incorrect to assume a continuation of that house. But what I would recommend is you could file for an amendment to the application and modify it to comply with the standards, which are not a reduction of the existing side yards to less than 13 feet, total less than 13 feet. You can, I think on this house, you can reduce the side yards somewhat because you have more than that. And preserving 50% of the exterior of the building on the exterior. And then you'll be in the place that's consistent with how the board has been operating in the last 4 to 5 years. And your client can move forward, and since you have the same architect engaged, the architect knows the house, they doesn't need to remeasure anything, and perform like that.
Well, I'd like to have an opportunity to review this case and to do some research of my own as well. I've done some since yesterday, but as you can imagine, between yesterday's executive session and today, there's a limited amount of time to do research. And I'd like to be able to submit something to your board, and once I've done my research, I'll have a conversation with my client, and we'll decide how we would like to proceed.
Okay. So are there any speakers on this? No? Okay.
Excuse me.
Okay, please submit by January 22nd, 2020, with a continued hearing on February 11th, 2020.
February 11th? Which one? Okay, so it's February 11th, and I'm sorry, what was the submission date?
January 22nd.
Great, thank you very much.
Thank you.
Item number 9, 2017-207BZ, 2030 Broadway, Manhattan. Anybody here from Mitz's office? Second call. Appeals calendar, item number 10, 2018-198A, 85 Trenton Court, Staten Island. No, it's an A case, you don't need to be sworn in.
Good afternoon, Todd Dale for the applicant. So I know there were a few issues raised at review session. If we can speak to those. Just to start, this is an unusual situation where we don't have a map street, we don't have a CCO street, we have this sort of intermediary, where the city has title to the street, owns the street, but it doesn't have either of those status. Just to give the board some background, we approached DOB and tried to get them to accept this as of right, being the equivalent of a CCO street, since it actually is one step above, and they didn't accept it, so that's why we're here for this particular application. So I wanted to do that sort of some overall perspective.
But did you, I mean, I don't know that it would qualify anyway, but did you check the other option? You know, there's two options on GCL's 36, paragraph 3. Did you
Right.
check the other option?
The other option with the block, yeah, we went through the whole block and nobody else had an approval. Because it has to be both, it has to be on the block, but it
Right.
also has to be fronting on the same street.
Yeah.
So there actually is a home that was built immediately across the street recently. If you actually look at Google Photos, it's there in some, and it's not in others. We actually know the person who built that. They didn't need the approval because Hanover is a CCO street. So even though the driveway is on Trenton Court, because they have the frontage on Hanover, they're allowed the exception.
Yeah.
But
No,
nobody's on
that we see, yeah, that we see.
we looked at the exception, we tried to find, because it didn't, I mean, this didn't seem the type of case that needed this application, but here we are. So we'll move forward. Just to start, spoke to the architect about the self-certification of the builder's pavement plan, and said that you wanted to go through the full agency review. He's prepared, and we'll go ahead and we'll submit that for them to take a look at it. It's an unusual situation with Trenton Court because the curb cut that's proposed, there actually is an existing curb cut. I printed this out. We actually, our for next submission will provide more street level photos. I realize we just had the satellite photos, but just for reference. Those are just from Google Street View. You can see there's an existing curb cut that actually is existing all the way to the extent of where this is proposed to be built. The fire hydrant that's proposed to be relocated slightly is there, but you can see that there is an existing curb cut there. There is no sidewalk currently. I know that the BPP we submitted showed a sidewalk. What's unusual about the sidewalk is that there is no sidewalk at all on the west side of Trenton Court. There's also no sidewalk on the north side of Hanover. So if we build that sidewalk, it's sort of a sidewalk to nowhere. And I'm not sure the best way to resolve that, because even if we extended it all the way to the corner where Hanover is, it would stop dead there, and there's nothing on that particular block of Hanover. So, you know, when I spoke to the architect, he said he was pretty flexible with what design, whether we show a sidewalk or not a sidewalk. And
But this is, you know, it's a builder's pavement plan, right?
Yeah.
It's really, and this was a self-certified plan. This is really why it needs DOT review, because it's too wacky for words. And,
so we're happy to submit that. My understanding, I could be wrong, but I know that when they submit these builders' pavement plan, it's actually DOB that does the review pursuant to DOT directive, but I don't know if anybody from DOT actually looks at these BPPs. So that just as an aside, but
Yeah.
how's this? We're flexible. Everything planned was based on that existing curb cut because it didn't seem sensible to destroy a very viable, or excuse me, a viable curb.
where are you looking at a curb cut?
No, sorry, curb. I
A
misspoke.
curb.
A
The
curb. Yeah,
curb
there's
goes
an
in
existing
front of
curb.
this person's house.
Goes all the way to the extent of where this property is. So a
Right.
curb cut would have to be created in that curb in conjunction with the relocation of the hydrant. In any case, we will go through full agency review of the builder's pavement plan and, you know, submit that to the board.
Isn't that forested area where the site is? After the sort of bar, the barricade?
No, the barricade is actually the further extent. I'm going to put this in perspective. I'll actually mark yours. So I'll mark this one especially. So just to provide some clarification on Trenton Court.
Venice.
I'll give you
Harvested.
this one marked so you can see.
Okay.
This is from the New York City street map, the online street map. And you can see that Trenton Court existed, actually is proposed to go straight up and then veer to the right to connect to Dorenzo, okay? What I marked on the one there with a pin is I did roughly where the particular lot for this building would be. The dash line that's on there is where that existing barrier is. Trenton Court just stopped dead into that forested area. So
Oh, it's the same? Okay, sorry.
I have it up here, too.
Oh, okay.
Yeah.
So if you compare the photo with that, you can see that the barrier on the photo is where I marked on the plan at Trenton Court, it just stops. In addition to the builder's pavement plan, we're prepared, we did provide the PD1 and this street map. We'll submit the street map, but we'll also go to the topographical office and get the topo map so you can see where Trenton Court exists. But Trenton Court's sort of an unusual street north of Highland Boulevard. As I said, it just exists from Hanover up to Dorenzo and then to the right. There's actually a portion of Trenton Court south of Highland Boulevard. I know it's not on any of the maps we submitted, but just for informational sake.
You mean it picks up later?
Picks up, yeah, south of Highland Boulevard.
Right.
So we'll find the status. But we'll get a little bit more clarification with the map to sort of put this into perspective. I don't know, upon all research we did, the city doesn't appear to have any plans or intent to pave or build Trenton Court to connect it to Dorenzo. I don't know anything about that.
Isn't it weird that they acquired title to this, of all things? This is what they chose to buy?
This is.
That may have been to access this parkland, that may have been the
Yeah.
intent.
Well,
I mean-
somebody should have told somebody.
As you know, we do a lot of these applications, and this is one of the quirkiest
Yeah.
of them all, to say the least. So, but we'll get more.
So I don't, I know that DOT is really overwhelmed, right, about lots of other things that are much bigger projects than this. But I'm really concerned about, building some weird anomaly sidewalk thing that, and so fire department we need fire department to.
We actually
waive-
spoke earlier, if you want to speak
Yeah.
to.
Yeah,
Why don't
but
you
it's
jump-
also, when they look at your builder's pavement plan that has this sidewalk jutting out from nowhere, but at the same time, no one lives on that street except you, right? Because everyone else, arguably.
The only people who would access Trenton Court would be the existing home that's at 95 Trenton Court, does have its driveway fronting on Trenton Court. The building across the street, the front door is on Hanover.
Right.
Their driveway is actually Trenton Court. So there would be, upon approval of this, if it were built, there would be 3 driveways on Trenton Court. And those would be the only people.
Can I ask you a question
Sure.
rather than a sidewalk? Maybe, this is just a question. And I don't know, I have no idea how much this actually costs, but when we see all these gas stations and everything that do striping, like what if there were like a 4-foot wide striped walkway thing? That instead of being a curved up sidewalk, were a striped walkway, so at least pedestrians would know, walk over here, so that the cars would be driving on that side?
Realistically, if somebody was walking there, they would just walk on the grass.
It would?
Yeah, because
Then you
the
trespass.
sidewalk we're showing, just so you know from the BPP, just to put it in perspective, I'll do a quick little drawing. There's an existing curb cut here, like this, and this is Trenton Court on that side. The sidewalk that's shown on the BPP would be right there. So it's actually, it wouldn't disturb the existing curb cut. It would actually be, if you look at the photo I
The
showed you.
existing curb.
The existing curb, you're right, I keep saying curb cut. Where the existing curb would not be disturbed, it would still be in place. That existing curb is right at the lot lines.
So
or
it
like-
would be on what is now the paved Trenton Court?
No, it would be on the grass.
Oh, it would be.
So if you look at the photo that I circulated,
Sidewalk would be on the
okay,
What about all those trees? Are they?
Kind of
the,
like.
the trees are
they-
part of the DEC, I think they'd be
No, where
removed,
the
and I think that they
hydrant is?
might have to do some planting with
Where's the
parks, I don't know I think we
No.
submitted the DEC permit.
Mhm.
I can ask about,
He's
Sorry.
saying he's gonna build where the trees
Here's the
are.
hydrant. This is the
Right.
existing front of the existing
So
hydrant.
that's, where's the existing hydrant?
See, the next door neighbor.
Yeah, no, on the plan. So, sorry, Mr. Dale, can you point out where the existing hydrant is on this drawing? On the builder's pavement plan?
this is a touch, so this is the builder's pavement plan.
Yeah,
So this is the existing hydrant right here, see? Right there.
Right
So
there.
That's the
Oh.
hydrant right now from what's shown on the Google. This curb cut exists.
only there, so
This
the,
curb exists. And then the hydrant would be moved,
To the other side.
yeah.
So, okay, so the drawing is super confusing because it's not showing the curb extending all the way down to Hanover. It makes it look like the
Because-
sidewalk is going to be projecting all the way out, but,
Because the builder's pavement plan is just for this lot, so that's why he's showing the curb just for this lot, but you are correct, there, this right here, look, it says existing curb right here.
oh, okay.
So this curb connects there,
Yeah,
so
can he
really they
change
moved
that?
this.
So, yeah, because the story that it tells, which is why I kind of panicked, is that it's going to be this sidewalk that projects out from the curb, which is not at all the case,
So
right?
better BPP, we all agree
Yeah,
on
yeah,
that?
okay.
Just one question.
Sure.
So that curb is going to go across the neighbor's property as well?
This curb would not be disturbed, okay? This
Okay.
hydrant would move here,
Okay,
and a curb cut would be placed here.
okay,
But this curb would remain,
got it.
okay?
And
And
if
this
you-
photo, just so you know, this is before
Dated.
this was built,
Before-
this is
right.
dated. There's a curb actually
And
right there now.
Right, and a curb cut where a driveway goes in.
Yeah. So,
If you were to put a sidewalk, it was going to be about the width of that hydrant pavement?
roughly,
Is that
yeah, I
what
would
you
think
were-
so. I think that
Yeah,
that's what's
that's what
shown
it
there.
seems
No, I
But as I
see.
said, it's really weird to put a sidewalk, I mean, to put it in perspective, he showed just the sidewalk in front of this subject lot because that's
Sure.
what normally done. If it were beneficial, I think this property owner would agree to extend the sidewalk all the way to Hanover.
That'd be
But the
amazing.
problem is, there's no sidewalk on Hanover for it to connect to, so it's still,
There
you
aren't
basically, you'd
sidewalks.
have like this sidewalk to nowhere, or a little bit longer sidewalk to nowhere.
No, but
It's
it's
really
not a
not-
sidewalk to nowhere, because for me, the issue is, you've got like little kids or whatever, and the car drives down, and this is a perfect, amazing little kid play area, right? Because it's a dead end.
Right.
So the kids are all gonna wanna hang out here. This is, I'm going to Bobby's house, right? Because you can skateboard and
Right.
everything else, right? So when a car comes, at least there's an official sidewalk for everyone to retreat to, and then you can go back to playing in the street.
I don't
So-
think they have any objection to considering extending that sidewalk for that frontage. Just so you're aware, when it was built across the street, they put no sidewalk in across the street. I don't know what the approval process was for that there,
There
but
wasn't, because there's no sidewalk on the front of that block.
Yeah.
The sidewalk doesn't happen till many blocks left of
Yeah.
this location.
No, I get it, but that's part of
But
the
I
problem
certainly
with this
understand the concept
Wild
of,
West phenomenon of no sidewalks in an urban environment, right?
big picture, we'll get a revised
Okay,
BPP to you,
great.
and we will seek to have that reviewed, not self-certified, but reviewed.
Okay,
Done.
that'd be great.
And as I
then
said,
there's
we'll
that
also,
weird part.
we'll get the topo map from this area to supplement the street map that was circulated. I know there was a quick question about the, I think the DEC approval. Was there a mention about that?
Yeah, just give us a copy of it. You
Okay.
didn't
We did
give
give
us
a
the
copy, just so you know.
drawing.
I told the architect, I asked if there were drawings associated with it, and he goes, when he got that back, that there were no plans associated with that approval. He did give me a copy of the plans that were submitted with it. I can submit this as part of the record. These are the plans. They're essentially exactly what is shown in the BSA plans, absent the BSA notes. But it doesn't get stamped approved or anything like that, but for reference, we can submit
Okay.
the,
So in other words, it just shows that that border at the back is one of those designated areas.
yeah, exactly.
Okay.
That's what that was.
Yeah, it's just for us to have a complete
That's
record.
fine, I have no
So
problem doing that.
the DEP approval number or something
It's
should be on the
DEC.
plan?
No, this is DEC, this
It
is the
still should
water,
be on the
freshwater
plan.
wetland.
We'll submit the
Should be on the
plan
plan, the
that
notation.
DEC
Yeah.
reviewed, but when we submit it, it will just be, our reference as far as this is the plan they looked at, but it's not gonna be a stamped plan because they don't do that. I know the fire department, you had questions about that, actually, you gonna jump up now and speak?
Good afternoon, John Daly, Fire Department. I reviewed these plans and application with the Bureau of Operations, and they like that it's a dead end, so they have no objection to this application.
Really? Okay.
Yes.
So, I'm just curious, so if a fire truck has to come into that location, it's no problem because there's a fire hydrant right there?
There is a fire hydrant, but the operation for the engine company that would hook into the hydrant, really, as it explained to me, they would stop right at the corner of the intersection of Trenton and Hanover, connect the hose from the hydrant to the truck, and then the truck into the house. That's how they, and it's not such a, it's less than 150 feet, so which is a one hose line length that they have no objection.
Oh, so it's just because it's such a short dead end?
And that is correct, right.
Oh.
And we have the barrier, so, which is even better. Had there been no barrier, yes, the fire department would have objection because you have people, you can connect into the back street. I forgot the name of the street. Thank you. So, yeah.
They would have had an objection if there were no barrier?
That's correct,
because
yes.
Why?
As it explained to me, they believe if there were no dead-end barriers there, then that opens up the possibility of cars parking there.
Oh, I see.
And also that the administrative company would have tried to use it as a shortcut to get to the back street.
Mhm.
So, when having a barrier there, it stops our guys at the corner to position their engine truck. So they hook to the hydrant and then hook the hose from the engine to the house.
I see, okay.
I'm still learning the
Interesting.
science too, it's crazy.
Huh, okay.
Yeah,
Thank you. So you'll send us a letter though, right? Because we don't have it yet, the letter yet.
I do apologize for not
Okay.
sending it. Yes, I will be
Okay,
submitting a letter of no objection.
Great, thanks.
Yeah, just to follow up on that, even
Interesting.
though this isn't a fire apparatus access road, if it were, since it's less than 150 feet, that's,
the.
if for a fire apparatus access road, I forget the section of the fire code, but when you need to provide the hammerhead and the turnaround, that's only if it's more than 150 feet. So this wouldn't even apply if it happened to be that particular road.
Okay, so this is unpanicking me. So,
Good.
so then, the other thing then is, because the picture that you submitted looks less weird than the drawing. The picture just shows a straight way down Trenton, right?
Right.
Whereas the drawing makes it look like you were gonna have this very strange unpaved area opposite
Right.
your property, but you're not, it's already paved,
Correct.
right? You may doll it
we'll-
up, but it's already paved,
Right.
right?
And there's actually a stop sign on there already, because it is a city street. If you're coming south on Trenton towards Hanover, they actually have a stop sign there. So the city has taken ownership of this street, because it's their street. It's a very unusual situation.
Okay, all right, so then, I think, yes, you should get DOB reviewed just because, but now I'm
For sure.
not so concerned about DOT thinking that this is the weirdest thing in the world. I don't know. I think I'm okay with that. We do need the city planning drawings, right? You got a subdivision approval on this?
Okay, I'll take a look. I thought we had submitted that, but
We
if
only,
I didn't,
all we
I
got
apologize.
was
Okay.
the letter, not the drawings.
Okay, so CPC plan,
Mhm.
we'll do the full builder's pavement plan, we'll get the Borough President Trenton map, along with the street map, and we'll submit the DEC plan referencing that it's not stamped, but this is the plan that they
Yeah.
looked at. And I think that's the
that's
list,
it.
right? Okay.
Just
We can submit,
Yeah. We do need, I still believe we need a hardship argument.
He
Well, you
provided
sent it
that.
something this
I sent
morning.
a supplemental statement
see that.
speaking to like the practical, I can speak to it now. In this issue, we would claim that there is practical difficulty for this particular lot because it has frontage only on Trenton Court. There is no other existing frontage, and therefore we are required to access through Trenton Court. Because it is not a mapped street, but it is city property, we're forced to apply.
Anything that would distinguish it from any other self-created harm arguments.
Correct, yeah.
Right.
Okay.
And, you know, maybe another, it is a subdivision that's creating this other lot, but it's a very large lot that it's being subdivided for only one additional house. It's not like
Sure.
creating an entire development back there.
And it seems like it should be approved as a GCL 36-3, but as by TOB.
We would agree.
Yeah.
So, you know, this is the thing about, if only the drafters of paragraph 3 had spoken to us first, we could have given them a little bit more opportunity to make this easier on so many others, because this idea that it has to have had BSA approvals when there was a time period where nobody went to the BSA for approvals, right? So then that cuts out everybody.
I appreciate the effort that the Builders Association did in getting that amendment changed, but I agree.
They didn't ask.
Other parties could have
Yes.
perhaps helped.
Yeah.
The community board's argument about the tandem parking,
Right, so the tandem parking issue,
because you know that CPC's.
right, so, so the tandem parking issue that they raise is an issue that makes sense whenever we talk about this relative to fire department. So if fire department had said, we need our truck to drive down this street, and we can't have parking on this street, then I agree that we have a problem with the tandem parking. But they told us that the truck actually doesn't drive down the street, right? So it won't be obstructed by the cars parking. And I have to say that it's this little dead end thing. It's like almost doesn't matter who parks there.
It's a long curb with only 3 houses that have driveways to it. I'm
Yeah.
not sure there's going to be much street parking that's going to be taken
Right.
up.
So I think, I understand why the community board would have been upset about this, because like I thought, I think they thought fire department would need to drive its fire truck in and turn around and all that stuff, and couldn't possibly, right, if there were parking on that street. Is that correct? Okay, so that's good. Are there any speakers on this? So,
We can be flexible. I would say, since we do want to submit the builder's pavement plan for review, I'm not sure the current timing on that, but we could extend this out a little bit longer. The rest of it should be quick to, I mean, we could submit the rest of this very quickly. It's just the builder's pavement plan that's the only thing, so.
yeah.
Okay.
Yeah.
Okay. Submission date, January 22nd, for a continued hearing on February 11th.
That sounds familiar, and that works.
You're putting all of the cases on vacation.
Oh, okay.
Do you have any preferences?
Yeah, if there's something that you're like, oh, I see that.
I think this is a good.
No,
Thank you.
these are, I think this one is fine, right?
Item number 11, 2019-270 BZY, 12-14 East 48th Street, Manhattan. Okay, you gonna go? Go. You don't have to be sworn in, it's an A case. Not yet.
Good afternoon, Jessica Rubenstein on behalf of Greenberg Charg. We attended yesterday's review session, and we believe the only action item for today's hearing is to update the board on the status of the violation hearings. So our statement of facts stated that there were 2 open DOB and 2 open ECB violations. 1 ECB violation was scheduled for a hearing in October, and 1 DOB violation was scheduled for a hearing in November. Both of those violations were dismissed at the hearing.
Huh. Good, thank you. Okay, any other questions, comments? An interesting first exposure to this odd kind of vesting
Definitely.
application.
Yeah.
So, okay, so are there any speakers on this? Like to make a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
All right.
A question, would the board be interested in having the resolution be postponed until the last day, because it's only a year, right? That the board can grant?
Oh, that's such an interesting point. So wait a second. So our authority is, let's just read this. It says, C of O for the entire amendment. In the event that such C of O has not been granted prior to such date and an application is filed prior to such date, which it was, the board may permit the new permit to be renewed for a term of 1 year. Okay. But it says the TCO shall be obtained no later than January 31, 2021. That's an interesting point. 1 year. So,
Or perhaps the term could just start from the resolution could just specify that the term starts and it can be released as soon as possible.
yeah, maybe it's like, is that okay? So in other words, it would be, the term is January 31, 2020.
Right.
To 2021.
That works for us. That's what we're
Okay,
looking
and
for.
so we can release it.
Before we
can
vote,
get
do
to
we
it.
want to reopen? I don't believe we asked if there's anyone from the community that wants to speak
No,
on it.
I did.
Oh, you did?
Yeah, unless nobody answered. Yeah. Okay. Is that okay? So let's
That's
just
fine
do
with
that.
us.
All right. So then a motion to, I already closed, right? A motion to grant with that term starting January 31, 2020.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Thank you.
Zoning calendar, continued hearing items. Item number 12, 2018-167BZ. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Good. Sign it.
Richard Lobel of Sheldon Lobel PC for the applicant. Good afternoon. Chair, had a representative at the executive session yesterday. We received all the board's comments, those being primarily that the plans should better delineate the existing versus proposed construction, that the second floor show retention of greater than 50% of existing floor area, and that the yards on the second floor and attic be moved to 27 and 30 feet respectively. This has already been accomplished by the project architect. We should be receiving plans later today.
Great.
Would be prepared to submit those by tomorrow.
Oh, by tomorrow, you don't think you could submit them today?
May I ask the chair, to the extent that the scheduling would permit us to come back next week? I think maybe it just would be better so that we can just make sure everything's clear.
Okay.
I mean, we're happy to second call. We have somebody who's down here in the afternoon.
Well, you could second call, we're gonna be here for a
Right.
while. So, you could second, you wanna try that? See if you can, I don't think there's a lot of hours that are required
Right.
for the architect. So if the architect is working on them today, it's possible we could do this today. I'm not sure we have time for next week.
Oh, that would be, that's an issue for us. If it is next week, we can easily provide the plans and hopefully just.
Why don't we try, there's some tricky ones. Yeah. Why don't we try for second calling it?
Okay.
And you do your best?
Fine.
Okay.
Thank you, Chair.
Thanks.
But to be clear, the second call would be in the afternoon session?
Yeah.
Okay.
Yeah, it could,
If you want
afternoon,
to.
evening.
Understood. Great. Okay, thank you, Chair.
To be frank.
Oh, no.
Item number 13, 2019-6BZ, 138 East 39th Street, Manhattan. Thanks. I have to separate it out. I can't interrupt. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Good afternoon, Madam Chair, Commissioners. Frederick A. Becker. I had someone attend the review session yesterday, heard all of your comments, and the bottom line is we will re-examine the application. We will look towards all of the issues that you raise in terms of plans, in terms of statement, and provide a more cogent application that should simplify the matter and set forth a better presentation for you. I must admit, I am somewhat confused of some of the issues that were raised, and at no point in going through the items after having gone through 2 staff reviews and a prior hearing, and nothing has changed with regard to some of the items. I realize there's some confusion with plans. We'll go through it. That's the bottom line.
If there's something you're confused about, then what are they?
Well, I mean, for
Talk
example,
about it.
you mentioned the fact that the Cornell argument doesn't work in this. This was never raised previously.
No,
that-
that's not what I said. I said that you make an argument in your statement of facts that the reliance is on programmatic needs as your A finding.
Mm-hmm.
The A finding is never programmatic needs. The A
No, it's the B.
finding,
Mhm.
the A finding is the Cornell deference doctrine,
Mhm.
which you make by saying, by citing to the Cornell deference cases, right? And then explaining why you are a house of worship, or that you are a house of worship, and so on. And then the minimum variance is determined by the programmatic needs.
Understood.
And then to Commissioner Ali Brown's point is, then you have to explain the programmatic needs. And it has to comport with the claimed number of congregants or participants or whatever it is to justify the size of the room that is going to be sitting within the rear yard. Right?
Understood.
So it's a pretty direct, simple, but it needs to be
Okay.
kind of
That-
linearly argued like that.
that is helpful.
And
That
I
is-
want you to clarify it because I want to make sure that you don't get the idea that programmatic needs is an A finding.
No, that,
It is not,
I
right?
yeah, no,
Okay.
I didn't think it was. I will clarify that. Just for purposes of clarification, this is not a congregation per se. This is a combination, think of this effectively as the Vatican. This has, there are religious services that are held here, there are educational provisions, there are all of these functions that occur here. There is no congregation per se. This is the eastern headquarters for the Armenian prelacy. In terms of the number of people who attend, there is no set congregation that attends. The current occupancy is 35 in the multi-purpose room. We are getting anywhere on the various functions that were mentioned in the statement from the Armenian prelacy, 60 and up to 75 or more people here. We are looking for a space that will occupy 74 people, less than a public assembly permit. So that is how the occupancy is determined. Right now, the 35 is inadequate. I can't say that 50 is the magic number, but less than 74 is the magic number as far as we are concerned. So that is how we are basing it, because we know that our current programs are going in the 60 to 74 person range, varying depending on you saw the prelacy, in their own words, gave a whole list of activities per month in addition to weekly activities which ongo, and that is the nature of the beast. Does that clarify at all, perhaps a little?
I mean, it gives me a little more information than the statement saying everything is in excess of 50 people.
Okay.
So now we're actually moving towards a number
Okay.
that corresponds to the number on the room.
Mm-hmm. Okay.
But if a little, obviously, she's saying it's getting her a little closer, so why don't you deliver the...
I will deliver the goods,
Yeah,
as
there
so
you
to
go.
speak. I don't know why this is the first submission in umpteen submissions with illegible plans. I don't know what happened. We'll resubmit the plans. So I really honestly, I submit plans weekly to you, and I've never had this come up before. We'll resubmit and make sure they're clear.
Because,
the bottom line.
what I don't know, since I'm not aware of what people do when they submit their PDFs, right?
Mhm.
But it's important to open the PDF on however you're delivering it, on your thumb drive or on your CD or on your PDF before you hit the send button, and to see what it looks like, right?
We thought they looked fine. Again, we always do it. This is the first, I'm
Yeah.
here weekly. I've never had this come up in many, many years. So a gremlin was in the works. We'll resubmit. End of story. I'm not saying that they weren't legible. I'll just make sure that we'll boots, belt and suspenders. We'll go through the floor count, the statements, the sections, which I believe are correct in the analysis. You are allowed 23 feet, but that's only one story. We have 2 stories, so that is the issue.
And the lot coverage.
It's the lot coverage.
What's
It's
the lot cover?
issue.
Okay.
So you asked for a waiver of lot coverage, check section 24-12.
Mm-hmm.
I don't believe you need that
Okay.
waiver.
We misheard that one. Other than that, as I say, I understand, I think I understand where you're coming from. I appreciate the comments.
So when you go through your statement of facts, if you could figure out a way to clarify by saying former second floor, former first floor, something like that, it's very difficult to figure out what's going on when you say there was a grant on the first for an extension on the first floor, which is really the second floor, which is maybe really the basement. I mean, so if you could just clarify your terms.
All right. What I may do, I think I'll put a chart in. That may help as well.
Okay.
We do a
Something
column,
like
a
that.
column chart. Yes, I understand it. And I will reiterate that this was brought up to me since the initial filing, and this goes to Commissioner Utley Brown's comment. There is a chance, due to economics, that the building will not be gutted. As of now, we are proposing it, but if the building is not gutted, then that second floor, which is the parlor floor, which has a much significantly higher space, is the key space, and we cannot flip. That's all. I understand
Well,
if we...
but so that might have an effect on what happens at DOB, right? Because we're going to submit a set of drawings and indicate whatever. Right.
If this is unknown, it's economics with a not-for-profit, which, if I could, economics for not-for-profit. Anyway, so should this all change, we will come back to you for an amendment at that point in time. But I'm just saying that this is why we can't flip.
Okay.
But right now, we're shooting for a new building.
Okay. So then, just to keep going down the list so you understand what the comments were, in your statement of facts, at page 10, you described the site as a school.
Right, that's a
okay.
leftover, sorry.
And then, as Commissioner Sheta said, there's a lot of disagreement within the drawings. So please have, one piece of information to the other. So please, both you and the architect, scrub the drawings and make sure everything matches.
Absolutely.
Okay.
Mhm.
And I think that was it. Everybody else? Okay. Are there any speakers on this one? Okay. Yeah, that's fine.
Okay. Submission date February 5th for a continued hearing February 25th.
Thank you very much.
February 5th? 25th. Okay. Item number 14. I'm sorry, did you say something?
No, I'm just checking on the date.
Item number 14, 2019-29 BZ, 30 Clinton Avenue, Brooklyn. Is it? Coming? Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Sign in and proceed. Yeah.
Richard Lobel of Sheldon Lobel PC for the applicant. Chair, in our frequent appearances before the board, we appear in various postures, and I think that schools are one of my favorite applicants. The reason being that for those applications, there is a distinct unity and interest between the applicant and the board. And that is that essentially pursuant to the laws of the state of New York, the board is instructed to give the applicant, a school applicant, every benefit of the doubt and to presume the beneficial effect which they will have on the surrounding community.
Unless what?
Now, the chair refers to an impact on public health, safety, and welfare, as is well vetted in Cornell University versus Mignardi. That case, which is a foundational case with regards to schools and religious institutions, demonstrates that those risks which are included in that public health, safety, and welfare are not general risks, and they don't lack specificity in Cornell. They talk about fire and emergency risks, and they talk about traffic hazards. The context of the discussion in Cornell is basically that you have, in those cases, in both Cornell University and Sarah Lawrence College, which was the second educational institution discussed in that case, the traffic hazards are basically that you are introducing a college use into a residential neighborhood. And so, the typical pattern of who's opposing this was with regards to local residential populations and the fact that the court said you don't have to stand by in your residential neighborhood and let things happen, that you have a reasonably drawn special permit, that there are factors which can be reviewed. But it wasn't what we're looking at today.
I think it was an example of that was those facts in that case. I believe that with school safety, if this was before them, this would be a very good example of what a danger to the welfare of the community would be.
Respectfully, Commissioner, I don't think that this case would satisfy that standard. My understanding, having litigated both school cases decided by BSA, as well as special permits decided by BSA in the appellate division, I don't think that standard is appropriately applied in this respect. And here's why. It's because the hazard that's demonstrated is one from the applicant outward to the community, not what is being discussed here. When they discuss conditions, reasonable conditions placed on an applicant, those conditions placed on the applicant are essentially to provide for the safety of the surrounding area. And even those conditions, when they're discussed in Cornell, are discussed as being, they're not permitted to be so obstructive as to result in the inability of the applicant to locate in these areas.
But you do have both here. You have it from both angles. You have it from the school to the community and the community to the school.
I have trouble understanding or acknowledging an argument that there are effects of the traffic of the school on the safety of the surrounding community. I understand the commissioner's discussion regarding the effect on business. I get that. But it's not with regards to this. It's not with regards to, is there going to be such a heightened activity at the site that there is going to be a safety impact. And one of the reasons I think that I feel so strongly about this case and about these cases is not only because you have a special permit involved, which is not a variance, it's a special permit, it has conditions, you review those conditions, and if there's special permits, the courts have been clear that there's a duty. It describes it as a duty of the administrative body if the conditions are satisfied to grant the special permit.
The conditions or the findings?
The conditions. If the conditions are met.
Which conditions?
Well, here we have A through D. Here we have the conditions. And so understanding everything that's going on to date, we're at the D finding. I mean, that's really where we are.
Yeah, so how are we doing on that D finding?
Well, Chair.
For the benefit of the commissioners who don't know the D finding, because it's not right in front of them, it says that the movement of traffic through the street on which the school is located can be controlled so as to protect children going to and from the school. That's the D finding.
Correct, Chair. And Chair, this board doesn't see all the 7319 cases it could see. Why is that? I'm a gating person. I gate these applications. I have applications for 7319s coming to me on a regular basis where we have serious conversations. We sit down with environmental consultants and we take a deep breath and we say, you don't have a case. You can't make your D finding here. And this is, it's critical for us, and it's poignant because what we're doing here in this room here is going to affect literally thousands of kids, and I can't overstate that. And so we've got professionals. I'm a professional, but as the board has recognized, we have varied professionals, and some of those professionals deal with traffic and safety issues. We wouldn't let those applications through. We wouldn't be as passionate as we are about bringing them if we thought that there were going to be kids who were going to be hurt.
Counsel, for me, I think this, if you want to distinguish this case, it would have to be in writing for me, and with some case sites or something.
I would be thrilled to do that in advancement of this application.
But before we go there, so let's just talk about what the issues
Yes.
are, right? You heard us, and you heard what school safety said. We're concerned about the 80 parents dropping
I get
off
it.
we're concerned about the busloads of kids all standing in front of that
Chair,
same
I don't
frontage.
disagree with you.
Wait. So,
Yes.
if the applicant were really serious about addressing those questions, what DOT said and what we said was the solutions are flaggers, parents getting brochures,
Yes.
right? Those are not architectural solutions.
Yes.
If we use, for example, I forget which zoning district it is that requires that a school have pull-up, drive-ups, parking areas for all of that stuff so that it all happens off the street. Perhaps there is a solution where all the cars drive into this building, and it's a new building, right? All the cars drive into the building, drop off, and leave from inside the building. You don't have any children who appear on the street. The buses drive into the building, load and unload inside the building. If there was a solution like that, at least the drop-off concerns wouldn't be there. I don't know, because I would then defer to the parents about whether they'd be willing to go inside the building and drop the kids off, and whether there is actually a viable solution there. But it seems to me that unlike all of the other applications we see, and you may be the gatekeeper in terms of your clients, but you're certainly not the gatekeeper in terms of all of
Admittedly.
the other schools
Sure.
we see, where sometimes it's a hair-raising situation. And we have seen many schools where there's a hair-raising situation, but there's a solution somehow that's worked out that doesn't depend on flaggers and brochures, right? So I would say, we like schools as much as the next person, but there is a limit to how much risk we're willing to expose the children to. So I might suggest you and your clients think about whether there's an architectural solution that will address all of our concerns. I'm not sure there is, but, it doesn't hurt to try.
I think it's, Chair, as a matter of public record, in the first 7319 that I ever brought before you, which was on Park Avenue in, I think, around 121st Street, there was a school, we wanted to put a school in, and there was a drug treatment facility in the building. And at that, as a matter of public record, you asked the applicant to install a new elevator. And we couldn't do it. There was a physical impossibility by doing that. But what we did was we worked with you and the commissioners and staff and developed a situation where nobody was unbelievably happy, but we lived with it. And that school has been a thriving school at that location for the last number of years. So all I'm asking, Chair, is that the school will, I want you to know how seriously they take this. We'd like to do whatever we can. We will give whatever we can, and then, at some point, we hope that will be good enough. And I don't know where we're going to end up on this application. Like, I don't know whether or not, obviously, the applicant has timing issues and such, and we're going to do the best we can. I know that there's other environmental issues which require solutions and reporting, and so it's going to take us, I've heard, 3 months for us to finish those issues off. Mm-hmm. So it's not like a decision needs to be made today, but I just wanted to impress on the board that that this is a very serious situation for the school. They're basically facing an inability to locate somewhere where they were looking forward to housing over 700 kids. And so I'd like us to go as far as we can as an applicant, and for the board to, to really understand that we are making every effort that we can.
I think that, if you want to take another stab at your arrival dismissal plan, I'm not going to stop you, but it has to be a plan that literally is poked constantly for inconsistencies or things that may look good on paper but not actually
I understand.
fly.
When I listened to the board's comments, I totally got it. Like I understood the timing, and you looked at some things and you said, well, that doesn't sound really like it's really feasible. You can't have that in an operational plan. I get it.
Right.
So
So in all aims of everything you implement has to ensure that children are safely getting in and out of this block.
Understood.
Basically, the entire block. And so you can't have any kind of procedure that's gonna lead people to try and cut corners, getting children onto this block and into the school.
I understand. Because I just want to, I can't make and I know Kevin would like to speak, and probably it's a good idea. I can't make representations about what we can do architecturally. I don't know where I'm able to go on that. I can tell you I can go as far as we can go on it, but like, I just want to make sure there's an understanding that we're going to supplement. There will be additional measures, and I think that the board needs to look at the applicant here, the existing operating school, and that they will do what they need to do to continue on with this amazing operating history that they have.
So I want to, if the term is sort of disabuse you of a direction, right? The direction should not be submitting more paperwork that says that parents will then pick up in 2 minutes instead of 50 seconds.
I know
or
that.
11 seconds or things like that, but basically we're still with flaggers and brochures.
Are
and-
flaggers still an option for the board?
No, so I think that point was made very clear by the board and by DOT, that a non-architectural solution in an extremely dangerous situation like this isn't going to work. And so when I'm saying you could give it an architectural try, I'm saying you go back to the drawing board about this project, right? And, frankly, maybe it's not a 7319. Maybe it's a variance that you're talking about because you might need more bulk or something. If you need to lift the building up in order to get a drive-through underneath, which is a much more expensive project, I admit it, but you're going for trying to solve what is, at the moment, an insoluble difficulty. You have forklifts driving around on the sidewalks where kids are going to be, and we can't rely on adults to escort every single kid. It would be like having a kid be, there's this phenomenon of kids being followed, trailed, whatever. You're essentially assigning an adult to every kid to make sure they don't run across the street and get hit by a car, right? That's just not workable. And I have to say that, as we talked about yesterday, I am also concerned that this is one of the few manufacturing blocks we see that's heavily business. And so the goal of so if we talk about the impact that the Banyard, the Cornell case talks about, is our goal is not to destroy all of those finally some successful manufacturing and industrial businesses, right? So it's almost like you need your buses and your parents to be slipping onto the site and slipping off of the site without disturbing the neighbors. So, and all of that done within reason.
Right,
I'm not saying
because
that
even
cars don't drive down.
Cornell talked about the fact that the measures imposed could not be such as to be so restrictive as to effectively cause cause an inability of the school to locate.
But we don't focus as much on the businesses, though we do have another application for a school where, for instance, there's parking right in front of the businesses for the school. And we're saying to them, no, you have to move to the other side of the street in front of the school, right? And so those kinds of things, we're concerned that the businesses are being deprived of their parking. So it's normal for us to be protecting the businesses. So within some kind of degree of reason, you could have bus parking, for example, in front of the school, but you can't have 80 cars plus bus parking. Right? So I would suggest looking at a drive-up and using the same criteria that are used in whichever zoning district that is. It's one of the low-density districts that's requiring the drive-up and the drop-off all to occur on the school property, whether or not you have enough room. I don't know.
Right. Well, it's an important issue because it potentially imposing that potentially in the event we cannot provide that results in essentially causing an inability of the school to locate, which is
and in this case,
contrary
it's
to Cornell.
because you didn't. No, it's not contrary to Cornell. For one, this is not a variance application. It's a special permit with a finding. It's the D finding that requires that the traffic be dealt with and not be a danger to students. And here we're finding an extreme danger to students, right? But just to throw out ideas, I think you worked on this case. It was or maybe not. There was the parking garage in front of the Pineapple Supermarket?
No, not us.
No, that might have been, okay. So the reason I'm thinking of that is that had an incredible throughput time for the parking garage, where there were these turntables, and the car went on the turntable, and really, it was like within 4 seconds, it was rotated, the people were out and shopping, right? So I'm not saying it's not an expensive solution, but it seems like there are architectural and mechanical solutions possibly that would address a lot
Chair,
of the issues.
again, we would like to take a harder look at this. We just want to make sure that in the balance here, that, the fact that we have an educational institution is really measured by the board. And the fact that there is this, it's a strong presumption. We don't take it lightly and we understand. So, I don't know, I think
Right.
Kevin probably wanted to talk.
And just for one more.
Sure.
I don't know that the board has ever denied a school application.
I don't think they
So it's
have.
not something that we do lightly.
Right.
It's something we do out of fear, right?
Right.
We don't want to be the ones read about in the paper. And there was only one other case that I can think of where we almost denied it because of air quality issues, and the school took it upon itself to cure the problem.
Right.
So, at enormous expense to
Okay.
the school, right?
You know, another option might be increasing the number of students that attend by bus, almost making it a mandatory must arrive and depart by school bus, that if you can't get buses from the city, you're gonna have to employ private buses. And that would control for the 80 vehicles coming down and parents getting impatient, because if you know that everybody is getting off of the bus could stay at the north end of the block until it's time to get in front of the school. So that's something you can explore, that might help.
Okay.
But then that's a
But this is-
real
this is kind
permanent
of-
commitment.
Right.
I'm
This
not,
is- This is kind of an operational fix. I would love to go with an architectural
yeah,
fix.
the
because
architectural is more
Yeah,
sure,
yeah,
right?
it's more sustainable. The operational one could be changed
At
but
any
in a
time.
little bit.
Right, right.
Okay.
Thank you, members of the board.
State
Kevin
your name.
Williams for Equity Environmental,
Yeah.
for the applicant. So there's a couple of things that I would like to just correct the record. There's a lot of numerical misunderstandings of the substance of the operating plan that was presented. And then I'd just like to have a brief statement, a few of the elements that concern me in terms of the board's evaluation, which has multiple planners present, and as well as discuss very briefly some of our coordination with school safety on this application. The first issue, and some of these they're not going to change your mind about things, but I think it's just important. So there was some reading, some of the board members noted 2 children per drop-off. It's very clearly stated throughout the document that it's 1.3.
Right, but you can't be at .3, so that's when I said.
Well, yeah, but
right?
that's a major rounding. It's 104 students with 80 cars. The other issue is DOE buses are by route, not by grade level. So it's not like you have to wait for a half-full bus. This is the way DOE buses work. So they become fully, in capacity and go into their routes, and students are assigned and organized through the building from their classes down to the waiting areas as described in the operational plan.
But so if they're by route, then how do you know how many routes there are, right? I mean, you know how many
Well-
kids need to take a bus, and there are, say, 55 kindergarteners.
Right, we
and they-
geocoded the addresses and assigned them based on that. So, and that's one of the things I need to digress from, because this notion that we have some fanciful report that meshes time and space and the throughput of children and buses, the idea is it's a process engineering procedure to evaluate how people enter children and their caregivers, drop children off, how you have 150 feet of space, and how you could process various amounts. And this notion that it's 80 cars, let me just say that's 3 times what it's likely to be. We have to use Department of Transportation factors from another school at Brownsville Charter Ascend that has no realistic public transportation. So the mode split is something like 52% drivers. This is an area that has 18% car ownership. So I want you to understand, first of all, that 80 cars is well beyond
any rational amount of cars that would be utilized either from our surveying of the applicant or of what would be realistic in terms of other charters that we, as you know, members of my team present many charters to the school. This would be far outweigh any mode split. But we do that in order to evaluate and how many cars could fit. And the idea is, it's not like that's a hard and fast operational plan. You flex it and you edit it and you organize it over time. It's a means and a method to evaluate a throughput of an area. Now, of course, you have to take an understanding of the area. And the other key piece on this is 30 seconds was referenced for the arrival and departure of an individual car. It's actually 1 minute. It's a little over a minute, and we've shaved 10 minutes off the end. Still, I'm sure you find that to be a shallow time. Having said that, the other key component of this, and I think it's very important to note, is this notion that is being, and I think it's being abused reasonably. It's been, DOT questioned it, is this use of human factors and people obeying rules in terms of coordinating and planning people's movements and arrivals to a specific type of land use in a specific area. So I have worked on and evaluated schools on 4 different continents, 6 different countries. I have looked at least 20 different charters in the New York City area. And yes, PSs are probably the worst of all of them in terms of arrival and departure protocols. But this notion that I heard from the board repeatedly, that people are going to drop their third grader off across the street and have them run across the street, and this notion that people are not going to follow rules for the safety of their children, and that a school is not going to follow a protocol, I think disabuses the entire notion of planning. And it disabuses the notion of the responsibility of a parent.
I have to object to that because, parents, yes, you're right. Parents aren't going to drop their child in the middle of the BQE and say, hop over the fence and get to the school. But parents who are pressured to get to work will make little adjustments to the procedure to suit themselves, fully believing that this is the one time that nothing bad will happen. And you see this on TV over and over again on the news. Parents go, I didn't know that when I left my child home and ran out to get that pack of cigarettes, they were going to light the place on fire and everybody's dead. Parents make calculations constantly, and I'm a parent, and you just think, it's not going to happen to me. And so, if I have to be at work at 8 o'clock or 8:30, and I'm being told, I'm sorry, there are 6 cars in the waiting area already, you have to go around the block. If my child is 8 years old, I may consider stopping on Park Avenue and saying, get out, I gotta go, and hoping that that child's gonna make it that 100 feet to the school, and hoping that, the odds are in her favor, she's gonna get there. She may not get lucky. But I'm going to have to make that calculation. And parents do it, parents with more judgment than me and parents with less sound judgment than me. So I don't think that you could say that everybody is going to comply with whatever regulations that your school is going to impose unless it is by threat of expulsion. And I haven't seen that in the paperwork.
So, Commissioner Brown, absolutely. And let me just tell you, so I'm not ignorant of a human condition. I have undergraduate degrees in psychology. I'm a professional planner. I went to architecture school. I went to law school. Okay, I have studied these matters for 20 years. So I get it. I lived in New York for 20 years, studied all sorts of environments. But I do agree with you. People are going to cut corners, and yes, there need to be countermeasures against that. But this notion that a school cannot operate in accordance with the plan, I think disabuses the responsibility of people that live in New York and how things need to operate when you're operating in such an environment. That's why we put together a protocol and a plan and a procedure. And yes, there ought to be kickback if you do not follow it. You get warned, your child gets removed, or you otherwise have to go to a drop-off. And this notion that we're not, there's actually another very important matter that I want to discuss very briefly, because this is going to be an issue. Because I basically had DOT tell me that children are free-range chicken, they're going to wander wherever they're going. Parents aren't going to pay attention to me. And this is very, very disconcerting to me as a person, who works in an urban environment and prepares plans for a living and tries to provide a protocol for any school. And let me tell you, I've seen it in every single school that I've been evaluated, with one crossing guard, with no procedures, cars double parked parents on lawn chairs in front of the schools, waiting for their children to get out. I've seen all manner of insanity, all right, all manner of near accidents in the city. And what I'm saying is we need to have a higher standard. And this client and this applicant is offering that higher standard and willing to work with that. And I think this notion that everything has to be an architectural solution and treat parents and their children like lemmings through a funnel to get to a school and because this is New York City.
We could be looking at things realistically.
Just give me one quick second. Children have a route to school, right? It's not just the block that has to be safe. They take risk getting in their car. They take risk walking down the street. Children, fourth, third, second graders, I have seen on New York City subways on their own, walking to school in environments, then this notion that an industrial environment is somehow worse than 56th and 8th in Manhattan, I think is really presumptuous. And the other final issue here, the applicant has had to design here is a program to deal with widespread illegality of the adjacent land uses. It's not illegal it's not legal to run a front end loader back and forth a sidewalk all day long. You need a revocable consent for such a thing. It is not legal to place pallets outside your business operation on the sidewalk. It is not legal to park a 30-foot pallet truck on the street. And what I had asked DOT to do in furtherance of this application, in furtherance of placing a school, is to work with us. We will get these people cited. I can quote Section 7, 2010, sidewalk liability, Section 19, 152.
So I have to stop you there. So there's like different public policies at work here. One is the need for schools to be cited in safe places. And if I were going to take your reasoning all the way through to its logical conclusion, there is no place on earth that you would argue is a bad place for a school, including, the front lines.
No, I would say Maspeth, where you have, if you want to locate it near a waste transfer facility.
Because that's air quality and so on.
No, it's trucks going in and out that are handling heavy, duty, vehicles with dump trucks with construction debris going in.
Is there anything in between that, or is that just the limit of it?
No, so what I'm referring to is it's a responsibility to me, and I've been before the board many times where the presumed condition of illegal land use action is presumed to continue on to the future in perpetuity, and the applicant just has to handle it or go away. What I am suggesting is industrial land uses, such as this, should be held to a standard of legality.
Okay,
but yes, there is.
But we're not responsible
so let me just say,
for that.
Richard,
and we can't control that. But what we can control is what goes on at this site, and that's what we're tasked with.
And I'm saying this site needs to operate legally, and we are committing to help with that end. But let me.
But wait, I just want to interrupt you right here.
Yeah.
So the fact is that these manufacturing districts are manufacturing districts for a good reason, right? They
were.
No, they're current. This one is a current manufacturing district. It's an M11 current manufacturing district filled with manufacturing and industrial businesses, right? And in order for these businesses, these are industrial businesses, right?
No,
manufacturing uses.
There's not a lot of manufacturing going on.
Excuse me, sir. Could you
Sorry.
Interrupt? And so the point is that these businesses are functioning on these blocks, and our goal is not to put these businesses out of business because you situated a school there. We're trying to be respectful of the existing manufacturing uses, or industrial uses, or whatever they are, staying in the M districts and not moving to New Jersey. That is part of the political, the public policy issue.
I'm so with you on this, and this is why you do a 7319, right? You don't rezone the whole block and lay waste to it.
Part of the point is also that if a business needs to operate in certain ways, where their trucks are parked out all night and so on, this is something where the city has generally said, we want the businesses to thrive, and we're not going to cite them every single minute that they have somebody on the sidewalk in front, because it's all manufacturing, and they're not interfering with each other's activities. And my interest is not in having you basically destroy these businesses because, let's say, an incompatible use comes onto the block. That's not the goal of these special permits. These special permits work great when they are located in M districts that have already started to shift or even shifted all long ago, to essentially being office and residential districts.
It's shifting, and you acknowledged in a previous hearing that this area is in fact transitioning and has been for a long
No.
time. I have you on the
No, it is
record.
not. I mean, I would say.
There was
I
a
mean,
rezoned on the block.
I
right
know
behind
that,
you.
I know, I did the rezoning,
Right.
I was at HPD. The navy green rezoning
was
was
an
done
M
by
district.
HPD for affordable housing.
Right.
Because that was the only city on site that was available. But that was a full block site.
Right.
And everything to the west of BQE is M zone. Everything to the east of BQE is residential. So there is a very clear demarcation of the uses, and except for navy green and for those few townhouses that are fronting along the navy green portion, everything is manufacturing there. So the transition has not happened, and it is not going to happen because you have a very active navy yard.
There are at least
And-
a dozen applications present in that industrial area that you're referring to for art spaces, commercial space. At our block alone, the site that's been laying vacant for approximately 15 years is now turning into a commercial retail use at the
And
end of
those
our
are
block.
permitted uses because they can be compatible. You're dealing with adults. You're dealing with people where where their operational uses are not going to create that much of friction.
So my only concern with what you said, and
conflicting uses
trust
also.
me, I've been on this application for over a year. I've had all of the concerns that you have. And all I want to say, I'm going to wrap up. I just want to respond to the last comment. This notion, and I don't think it's proven, that the siting of a school present here is going to abuse the current operations, or, as you noted, that there is some extra legal mechanism by which they're able to operate and create unsafe sidewalks that people can't walk on, and operate correctly, is somehow going to diminish those businesses, I think is a presumption that has not yet been proven. And there are plenty of industrial actions all over the city and actors all over the city that operate out of the purview of the sidewalk and the public right-of-way, which is illegal, and unsafe in its existing condition. So that's all I want to say. So listen, I get your concerns, but I believe we have provided a safe zone here, and in combination with some work with the neighbors, can provide safe conveyance along the sidewalk. And that's really all we tried to show.
So I'm just going to reiterate, I think if we had left it with operational plans like flaggers and brochures and so on, the board would have already voted to deny the application. From my perspective, that's not going to get you anywhere. And if you really want to try to make this happen, you're going to need an architectural solution. I don't know whether, it's viable to have the busing solve the problem, only because how do we commit? Maybe there's a way to make it a permanent commitment where, violation of the busing of 100% of the students is somehow or other a DOE issue, or put it in the DOE contract that all of the students must be bused. And then you have to figure out how to time that and all of that sort of thing.
So I just want to say I appreciate the back and forth, and you're bearing with me. I just felt like, given the amount of time, I just want you to understand that we do take this application very seriously, and the discretion of the board.
So we
And-
understand your passion. You're passionate about it, and I think that we all are passionate about it, and I don't think any of us are offended by the back and forth.
Right.
But I think that what you need to understand is, while you may be talking about two different aims or goals, the one of citing a school and also whether or not industry has a right to freely use the sidewalks, we have three different policy issues that we're dealing with. One is keeping the manufacturing districts alive in the city to employ people who have less formal education. The second one is to provide school siting, okay, and support the mayor's initiative to ensure that there are enough quality school options for people who live in New York City. And then the third one is Vision Zero, which is to ensure the safety of the populace traversing the streets and the sidewalks. And so those are three things that the board is grappling with and trying to balance. So any solution that you put forth has to recognize that and not belittle or diminish our concerns, because they're concerns of the city. And we have to take that up here at the board. Those are the issues that we have to address.
Beautifully said, thank you.
Matthew Levy for the International Charter School. Chair, members. I'd just like to draw your attention to a discussion we had at the initial meeting that the International Charter School is in its 5th year of operation. We currently serve approximately 430 children in 2 locations. We have successfully been helping children and families to arrive and depart for 5 years now. There's not been a single incident that's happened on our watch. And as I think I said at the Department of Transportation meetings that we had prior to this, there's no misalignment between our interest in children's safety and yours. We understand that as Kevin was alluding to and as you've discussed, we understand that human beings are amazingly complicated in both positive and negative ways, and we work with that, we think, quite effectively in the current configuration where we have, again, about 220 children who need to arrive and depart from 2 buildings every day, 185 days a year, which we have successfully done for, as I say, going on 5 years now. So I just want to acknowledge that we do take that seriously, that we have taken that seriously, and we've operated successfully. With respect specifically to the factors, I just again acknowledge that we are currently seeing far fewer parents use private vehicles than are indicated by these Department of Transportation factors. Car arrival and departure has not been an issue for us, despite the fact that we are operating on 2 very narrow streets that have a variety of uses. It's different than the M zone, but it presents its own complications. We've successfully navigated that again for 5 years. And I just would hope that as we develop a response to the concerns that you've raised, that appropriate weight could be given to the fact that the school does have a successful operating record with 430 children for the last 5 years and no incidents, despite the fact that we do serve these same parents who are human beings, who are complicated, who are pressed for time, which we understand and agree. And that's all I have to say.
But
Thank
not
you.
on a block like this one, maybe.
It presents its own challenges, Chair. I agree that each block is unique, but we've risen to the challenges of the locations where we are and have no reason to think that we can't rise to the challenges at this other location as well. Thank you.
Thank you. Are there speakers on this? Members of the public would like to speak? No? Okay. Yes. All right.
Just have a question for clarification. So they're going to respond to
Speak
all,
into the mic.
they're going to respond to all that was raised. Currently, the seeker DOT is still under review. But the school safety had responded to the same proposal that they issued the
Yes.
letter. Should I continue with the current DOT review or cancel that and wait until we have a new?
I think the most efficient thing would be for you to submit something that's actually responsive to our concerns that's architectural in nature.
Well, I think we definitely need a new iteration of the
So
proposal.
maybe hold off on, because we're going to be looking at a different EAS with different studies, arguably, yeah.
Okay, thank you.
Okay, thanks. Okay, 3 months?
Yeah, I think that internally, when we discuss this, that the host of issues, not even inclusive of a change in the operational plan or other factors, but merely just for the other environmental concerns would take 3 months. And so I think we can accomplish everything within that amount of time.
No, but it'll take 3 months only if we proceed on the existing application. But the discussion is that you can't proceed on the existing
No,
application.
I understand. But I'd
right?
still say that 3 months is, for us, would be a good time.
Yeah, so that's a submission, 1, 3. Yeah, that's good.
Submission date, March 4th, for a continued hearing, March 24th.
Thank you.
Okay.
Thank you, Chair,
Thank you.
Commissioners.
Item number 15, 2019 40BZ, 175, 179 East 73rd Street, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? I do. Thanks, Dan. Just sign in. No, that's one. Sorry. Okay.
Good afternoon, Dan Eggers from Greenberg Charg, representing the applicant. I understand from review session there are no open issues, so if that is the case, I would respectfully request that the board consider closing the hearing.
Check noise. Yeah. Are there any speakers on this? No? Okay. Anybody open things? All right, so I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta, sorry.
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition that there shall be no amplification at all on the roof, on either roof, lower or upper roof, if that's right, just lower and upper roof. No lighting after 6 p.m. on the roof. No use of the roof after 9 p.m. And no use of the lower roof except for mechanical equipment. Okay. Anything else that I leave out? So on that, a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
And Commissioner Shabeta?
Aye.
Thank you all.
Item number 16, 2019-157BZ, 8802 Northern Boulevard, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Elise Fullader from Eric Palatnik, PC, on behalf of the applicant. I made a submission. I'm going to hand it out.
Oh, okay.
Thanks, Elise.
So, in the submission, you have plans, revision cloud plans, additional photographs, and then I have a cover letter which explains a few things, but I'll go through each of that. So, the plans have been revised to reflect the current landscaping at the site, and they more clearly show drawing Z005. On the revision cloud, it's not fixed, but on the actual plans that are going to be stamped, 005 is clearer. Do you
Sorry, 005 what?
Z005 was blurry,
Oh.
and you asked for it to be not
Oh, I see. Okay. Okay.
Oh, sorry.
Yeah, okay.
In the photographs, you can see the close-up of the drive-through menu board with the signs beneath it. And the drive-through menu board says beneath it, drive-through menu board closed during the following hours, Sunday to Thursday, 9 p.m. to 7 a.m., Friday and Saturday, 9 p.m. to 8 a.m.
So what do you do during those hours if you want to order from the drive-through? You
It
pull
says, drive-through menu board
Oh.
closed during the, it says, I think it says go up to window.
Yeah, drive up to
Please
window.
order at the window.
Window,
Okay.
yeah. I guess, or go inside, get out of your car.
Well, that defeats the purpose of the drive.
I know, but I'm just saying, like, if it's not a good time.
Okay. So according to that, then, you're saying you don't need an acoustical fence?
Well, then I have a next sound attenuation response. It's a little bit long, but the New York, so we looked at the sound attenuation, we looked at all the previous conditions, and we are not trying to veer away from any of those conditions. We have kept the same conditions for over 30 years, and we're trying to stick to those. And the New York Seeker Technical Manual, Chapter 19, Noise, Table 19.1, Noise Levels of Common Sources, provide ambient noise levels for typical suburban areas at 50 to 60 dBA. Typical urban areas at 60 to 70 dBA, and passing automobiles with mufflers at 70 dBA. Shown on drawing Z007 and Z008, the maximum noise level from the menu board speaker that would reach the residence is at the second floor window with an external level of plus or minus 50.73 dBA. While the noise from the speaker would contribute to overall noise experience at the residence from the speaker and ambient sources, as the maximum level reaching the residence from the speaker is at the lowest possible ambient noise level for the area, it would not be distinguishable. That is, you wouldn't be able to pick it out separately from ambient noise levels and would be drowned out by ambient noise. Conversely, and as an example only, if the speaker created a higher noise level such that the level reaching the residence would be above the ambient levels, for example, 80 dBA, then this would be distinguishable from the ambient. As this isn't the case, the speaker will not have an impact on the residents. I'd also like to point out that this is on Northern Boulevard, a major street which has major traffic, and we have not, in the past 30 years, had complaints from the residents in the rear. And the community board also approved this application, and that didn't come up.
So, but on so many of these applications where the menu board is so close to the property, all we do is put up an acoustical fence. Why don't we just put up an acoustical fence?
Wouldn't that require a whole new fencing, $30,000 of work? And
No, acoustical
There's these
fencing.
fabric liners that
Yeah.
are.
just fabric, I mean, I can ask them about fabric liners,
They're
but I don't want
installed
to.
with like twist ties
Yeah,
practically.
people use twist, they're usually green.
Okay,
Green
I mean, I
fab,
can
like
bring that up.
plasticky, kind of rubbery
They've
fabric.
not had, the reason that, they didn't do it before is it wasn't a requirement and nobody's complained, so. And it's on a Northern Boulevard.
And since it's White Castle, you probably can get it in white color also.
Okay.
Yeah.
I mean, if it's just that, I can ask them, but
It's
to
a-
rip out a whole fence
It's
is.
called, it's an acoustical fabric material made by a company that handles acoustical
Okay.
fencing, right? And maybe because you worked on something where at one point it was this major wall that had to be
I have
installed.
done that.
But we also have a lot of these where they just hang up this fabric. And they
Okay.
put it on chain link fence, they hang
Okay.
it over picket fences.
That sounds way more
It even comes
reasonable than.
in a vegetated form, looks like pine. Not that I'm recommending that, but, you pick your home.
And it's a belt and suspenders for your owner.
Yeah,
Okay.
exactly.
Okay, no problem. And then the last issue I addressed was lighting. The lighting levels are calculated using a photometrics program. Each type of light, area light, wall light, et cetera, has a lumens output value file that is obtained from the manufacturer and inputted into the program along with the types, heights, opacity of physical barriers. The program takes all these factors into account and produces the photometric grid you see on the plan. The grid numbers are light levels at 2.5 above ground level, so when levels are shown as 0 on the residence side of the property line, it is because a physical barrier, in this case an opaque fence landscaping, blocks the light completely from those locations. So it's raised from high, so it appears really light, but then if you cross the fence and you stand beneath it, it's not going to be that light.
How high is this light fixture?
24
feet.
It says, yeah.
20 feet, 4 feet high.
Look at it. But again, we haven't, didn't come up at the community board as a complaint. Northern Boulevard is very.
Well, we don't even know if the neighbor was notified. These are the things about,
Well, we had to notify the neighbor because this was filed under a new number, so we had to.
you did do
Yeah,
a
because
notification of this
these-
neighbor?
These
Okay.
only get 5-year extensions, so it wasn't worth it to us to come back under the old number, so we filed the new number, which requires an owner's list.
Okay. So the only thing then is the acoustical fence.
And would ask if it's possible to make that a.
How do we know that you'll do it? How about this? We could decide on it, but you don't get the resolution until you show us a picture of the acoustical fence
Good with
installed.
that,
How
better
about
than
that?
telling them no.
Is that good?
We still have outstanding ones from April, so.
Don't advertise. Okay, are there any speakers on this? Okay, so then I think that's a way to do that. All right, so I'd like to make a motion to close.
Okay. Just real quick, so these are These plans are acceptable, you're fine with this,
Yes,
this is good?
right, yeah.
And they've been
And these were
submitted.
submitted.
I know these were submitted, but I couldn't tell all the stuff, it was hard to read in the email, sorry.
Everything was kept bubbled from the previous submission. The only thing that was added was landscaping was a little changed.
Okay,
So it wasn't like a whole new.
all right. Motion to close, you did already? You wanna-
Yeah, motion to close.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
And a motion to grant on condition, so it's a collection of conditions that the, acoustical fencing must be installed prior to the issuance of the resolution and maintained in going forward, that the lighting levels should be maintained so as not to shed onto the adjoining property owner, that, what else?
The conditions
Oh,
of the sign notes should be listed in the resolution.
The sign, no,
Drive-up windows,
Oh,
closed,
yeah,
blah, blah,
right.
blah, yeah.
that the board shall only be used from, I think it's 7 AM to 9 PM. It's the same conditions as was on the original approval.
shifted it an hour on that sign.
Oh. Here, okay,
It
it says,
Sunday through Thursday, 9 PM to 7 AM, Friday and Saturday, 9 PM to 8 AM. I don't know why they didn't do Saturday and Sunday, they did Friday and Saturday.
okay. You got that? It says it on there.
Do you have a
So then
height?
it's on the drawings.
So,
It's on the photo, it's not on the drawing.
It's a, yeah.
it says Sunday to Thursday, no, so it kind of does it the opposite way. No, if the menu board is closed from 9 PM to 7 AM, Sunday to Thursday, and from 9 PM to 8 AM, Friday and Saturday.
I think we focused on the 9 PM.
Yeah. Right. Okay, and then, did I leave anything out?
Wait a minute, I'm sorry, I hate to be picky about something. So you're saying the drive-through menu board's closed during the following hours, Sunday to Thursday, 9 PM to 7 AM.
Yes.
Friday to Saturday, 9 PM to 8 AM. Please drive up to the window. Then you have the sign that says, "To respect our neighbors," the intercom
I think that
speaker.
was the old sign, so I'll ask them to, it does, yeah.
Oh.
Because the intercom sign, there's a sign there that says,
That was from the previous.
but it's still in the damn photo. I mean, come on. Sorry, I didn't mean to do it, sorry.
She's so touchy.
But it's in the photo.
Yeah. I'll tell them to remove it.
I'm
Because
reading,
that's
I'm
what I
reading
have
from
it
the
from
big
those
blue
days.
sign with
So you want the
yellow
big,
letters.
all right.
I also had the old sign.
Yeah.
And that's why. I
Because
was
someone's
like-
gonna look at it and go, what?
I'll tell them to remove the old sign.
Yes, all right, so the
Because
big
they're
blue.
trying to achieve the same thing, but they're
Yes.
an hour off. I understand.
Okay, so we're reading from the big blue sign, if it's clear, with the yellow letters, okay. Then, landscaping shall be maintained, in accordance with landscaping drawings. Anything else that I left out?
Do you have a height on the acoustical fence, or do you not want to include a
It
height?
should be it should cover the height of the fence.
Yeah.
in place.
It's just gonna be the fabric acoustical fence from the, yeah, okay. Okay, got that? Based on
Yeah.
that, recommendation, motion to grant.
Okay. Chair Promoter,
Yeah.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Okay. Item number 17, 2019-158BZ, 8903 57th Avenue, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Okay.
Elise Fullader from Eric Polanic, PC, on behalf of the applicant. I did another submission.
You submitted this when?
Like 10 more.
Yeah, we got it.
You have.
Yeah, we have it.
I think I gave you it. Oh, no, it's just a certification.
Thank you.
Plain woman.
So again, this one has plans, photographs, and then I talked about lighting, and then I have a letter from White Castle that addresses the other issues. I don't think sound was as big of an issue because the menu board was way further away in this one. So again, drawing Z004 Z005 is more clearly shown in the plan, in the ones that are going to be approved. Additional photographs show the landscaping, which was also updated on the plans.
Oh, they did delivery. Oh, cool.
You know, I mean, yes, these additional photos do show landscaping, but they're kind of sparse, they're not that well, in that good condition. And I know this is not the season to plant,
Yeah,
but.
I think that was the attempt, like they made an attempt.
Yeah. I don't think anything new was planted since the last time I went to the
Okay,
site.
because we had conversations.
When
Sorry.
did you take these pictures?
Those pictures were taken the end of last week.
No, again, I mean, there's quite a bit of barren land here.
And then you can see the, I even like how it looks better on Z007. They updated the landscaping photos.
I have the bubbles. Yeah, I have the bubble, right?
So you're saying those photos are different than the photos you just gave us?
It's the same.
They're of the same site, but two different people took them. The photos I got from the construction manager, and these photos were put in by or somebody put them in, either the engineer or somebody sent them to the engineer to put in the plans. I didn't use the same ones as him.
Part of it could be the seasonal difference.
Yeah.
Yeah.
I mean, what's very hard to tell is if you just pick any of them, you have all these little indicators of plants. It's impossible to tell whether all those little plants are actually in from these photographs, right? So maybe other than even number 3, I count 5 little things in a tree.
But it says two, existing 1 AC, existing 2 FEG, and it
Yeah.
goes with that chart. I mean, to me, it looks like they'd have to take out other stuff to put in new stuff, because there's a lot of short bushes, but they cover the.
Yeah. And, you know, the other thing about bushes is that if they grow, they're supposed to grow, right? And get wider and taller and be maintained. So I'd say that a lot of this is, how are they doing next year? You know, do they
Okay.
fluff up
Fair
and
enough.
stuff like that? But what we could say generally is that the landscaping areas need to be maintained, densely planted, right? It's not supposed to just be like one bush. Densely planted with living plants.
Yeah, fair enough.
Okay, what else were we looking at?
So the lighting was the same question as kind of the other site. I explained again how it's taken. So if you were to stand, he showed a picture or something, but if you were to stand on the other person's property and not, because the light's face down, you wouldn't have that kind of lighting that you have beneath. But I don't know what picture you showed. But yesterday.
But
yeah.
you don't, the previous one, you did show some shield, lighting shield. Here, you're not proposing lighting shields? Or
Well,
you
they're
don't have
saying
it?
pointed down. You could see in the photographs of the landscaping with the lighting. They're high and pointed downward. In viewpoint 4, you can see the light on the left. What it looks like on the landscaping plan.
Near the dumpsters,
Yeah, just like as an example of what the light.
that's a very low light.
I believe the issue with the lighting for the engineer who's providing this diagram is, he usually provides the lighting at a certain elevation above the existing grades, which is, I believe you indicated
2.5.
2.5 feet.
Yeah.
I believe it would be much better if it's provided at the top of the existing fence.
Okay, I think he does that based on I don't know what he does it on, but I think that the photometrics program and
It's
that's
most
it.
likely a computer code that you put the data in.
Yeah, but I'm saying he probably uses it based on some sort of standard, I don't want to speak on behalf of him, but 2.5 is probably, that's, you know.
Yeah, but if it's 2.5 and you're showing whatever inside the property,
Yeah.
when you look at the other side, you're gonna see
I
zero
understand.
because you have that physical
Right, it should be the
barrier.
height of the fence, right?
Yes, but if you take it at the height of the fence, if you have X this side, probably the other side is gonna be 0.99X. So the drop is not gonna be much.
Yes.
Okay.
No,
And I,
that makes sense. If these
Yeah.
are high post lamps,
Yeah, you can
right?
see this,
Then
this
you
is
would
the.
see it spilling over the fence.
I would look at the lighting, if you look at the lighting plan, you're gonna see 4.5, 4. I just don't wanna like ignore what I saw on site. If you look
Yeah.
at the lighting, 4.5, and so on. I believe what's happening is, if you go up with the elevation, instead of at 2.5 feet, let's say we go to 6 feet. If you go to 6 feet, these numbers will go even up,
Yes.
because you're closer to.
the lamp.
The light.
Yeah.
Exactly, and
But
then
yeah.
when you cross to the other side, there is no barrier, so
Yeah.
you're gonna see some.
do want to point out that there is a fence barrier in the back, and the buildings are set back. I mean, I know it's not on our property, but it's not like they're directly on the
No, but
property.
the issue is you're not supposed to be lighting
No.
the neighbor.
No, I
Right.
understand that, but I'm
Yes.
saying, I'm pointing out that there is a fence. I'm just pointing out that they probably don't have light shining into their property. I can only speak on
We don't know,
2.5.
because what you have is a very high lamp
Yeah.
at like 20-something feet,
Yeah.
and it shines down, right?
And there's, I
And
get.
if it doesn't have shields, it's shining down for the entire range of its spread. And the fence obviously can't prevent it from 24 feet
Yeah.
from,
There's also,
from casting down onto the other side of the fence.
there's also thick bushes in the rear. I mean, trees.
Yeah,
If
but
you look
it's not the
But
same
you're
as a
not
shield.
supposed to be lighting
No, I
bare
understand. I'm
bushes,
just-
right?
yeah.
So I do take that point, we should probably change the rules about
Yes.
the height, the
Yes, that's
lighting
true.
plans, that it shouldn't, I didn't know it was taken
But the
from
issue
so
is, if
low.
we have like two fences, two different heights,
Yeah.
we need two plans.
Right, but I actually didn't know that they measure from so low, because normally things are taken from eye height. Normally, it's kind of, you typically think of things as taken at 5 feet eye height, not at, in general. All plans are supposed to be at 5 feet, right? Not at 2 foot, 2.5 feet, when you do a section through the
I was
plan.
presuming that it's at 3.
Yeah, no. Then you would go right through staircases, it would be really weird. Okay.
Oh, yeah.
So we need better on that, or you put a shield on it, but I think the bigger issue is the dumpster enclosure.
Okay, so that is what is addressed by the letter from the White Castle construction supervisor. I want to point out that he's worked there for 38 years, so he came, the last extension was also the same person, so.
Okay, what does he say?
So, firstly, this restaurant has operated for decades without complaints from neighbors. The door was taken off of the dumpster enclosure in order to ensure a cleaner area. With the door taken off, it is easier for the store general manager to quickly see its cleanliness when arriving at the restaurant, thereby assuring it is kept clean. So that's why they took
So
it off.
that's why when we saw 3 dumpsters absolutely overflowing with trash, that was helping him to
He
decide
said
that
that
they weren't.
maybe like it was after a holiday or something. I don't know when it comes,
Doesn't
but he said
matter,
that
right?
he said it's easier for them to inspect everything if the door is open.
I
And
think
that's
it's
what
better for them to put these gates in. You know what, if I'm buying
Well,
food
they
from
had them
there,
and they-
and I'm driving in the drive-through and I'm looking at these dumpsters,
Makes me sick.
probably I'm gonna change my mind and I'm not gonna eat.
Okay. He said they had them and they took them off for inspection purposes.
And you already shown them on the drone, so.
yeah.
Because
you
they
don't-
had them, yeah.
Maybe you should put them back and they create
Okay.
an operational plan that includes
More frequent
more frequent
pickups.
pickups.
We talked about this at the last hearing, that it's not okay to pick this trash up once a week or whatever it was. It has to be, I think most of the time, it's every other day that it gets picked up.
Especially
And-
the food.
Yeah.
Yeah,
But
yeah.
And there was a lot of
Yeah, okay.
And there are
trash
too many
there.
dumpsters. We never see this many dumpsters in a food site. So
Yeah.
what's telling
I think
me
we
is,
discussed that,
it's
yeah.
infrequent pickups, lots and lots of rats. I mean, yay, word gets out on the street and all the rats come to White Castle.
Yeah, and he told me he has dumpsters and recycling bins, and the city has added more types of bins he has to have, so that's why he had more, but.
I would be opposed to taking these gates.
Okay. I can tell him he has to put them back,
Out of the
if
road.
that is.
Yeah,
what
me
it is.
too.
And I mean, just the way you have presented it, to me,
Yeah.
seems like it's for his convenience, so that he can do a quick look. Well, it's
Okay.
not a.
Okay.
Yeah, I
That's,
think
that's really not the intent. It's really meant to,
Okay.
you're supposed to keep this off anybody's view.
Yeah.
Okay.
And it hasn't been working.
Yeah,
You
it's
know?
not working. Right, okay. So we need them to take care of that before we can
Okay.
decide on this.
Yeah.
Okay.
And then he said that the he knows what you were talking about with the sign removal, and he can clean up whatever it looks like on the signs. And the trash cans, I just wanted to tell her about.
Yeah.
She says those trash cans are the standard trash cans used at 378 other White Castle locations.
They
or-
look terrible at 378 other
Okay,
locations.
that's the corporate standard trash can, and he says it works for them at 378 White Castle.
So they need to spend a little bit of money and buy a solid, they're usually made out of concrete, solid concrete trash can that's installed upright as opposed to in this precarious position on the edge of a hill.
Okay.
Right, and install them properly, professionally, not just kind of throw them around.
So I'll tell him the trash cans and the door.
It's funny when they say substandard stuff is our standard.
But I really think, I just want to say on behalf of them, when we went to the community board, everybody was really, they thought it was a really great site.
To
It's
have
been-
trash cans.
No, but I'm saying nothing to do with anything. They thought
Oh.
the site was well-maintained.
Oh, okay.
We came to the site, they were like, yes, it's been there for 30 years. We love having a White Castle there. Sometimes we're hungry in the middle of the night, and we go to your White Castle.
It is, the site is not bad.
Yeah, but I just want to
You have bad
recognize.
spots, then you need to fix them.
Yeah,
That's all.
understood, yeah. But I do come here sometimes with sites that I think don't look as nice.
Okay, understood, thank you. Okay, enough time for you to install the
Door and the trash.
doors and the trash cans, and give us a lighting study that is taken from above the fence height. I
At the
think
top.
this is a 7-foot fence here. I think that's what I saw on
top
the
or-
drawings.
At the top, right at the
No,
top of the fence.
above the fence, so that the light is not cut off by the fence.
Oh, okay.
Right?
Lighting study above the fence, okay.
Because the only way that works for a person is if you're standing on the residential side,
Yeah.
up against a fence.
Okay.
Then you're right, you don't see any light. But then you walk a little way from the fence, and arguably you can read a book. And the goal is to not read a book at night.
Okay.
Okay.
All right. Submission date February 12th with a continued hearing on March 3rd.
There's no earlier?
Oh,
I just feel like that's March is so far away.
good point.
Gonna be a whole new age in March.
February 1?
Yeah. Submission date January 22nd with a continued hearing February 11th.
Thank you.
That's the way it goes. Great, thanks. We're going to take lunch
I was just
break.
going to ask you, you take lunch break, or what do you want to do?
Lunch break, 30 minutes.
30?
Sorry, everybody, we haven't had lunch. It's 2:15. So we'll be back at 2:45. Okay.
No, you're just making note of these statements.
Well, what are we going to do? We have to push that.
Like, this is basically our first, like, next one.
Yeah.
January is insane already. Okay.
I just like, what are we doing? Because I don't know.
That's my baby.
Nothing, it's okay.
I tried for March.
It's fine.
No, but you can't not put anything on. You have to.
I hope you don't have to.
Mike's on, please. Okay, we're back on the record. Board of Standards and Appeals public hearing for December 10, 2019. Zoning calendar, new cases, item number 1,
2019-64BZ, 1334 East 24th Street, Brooklyn. You want to read it? Raise your right hands.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
No, that's not. That's for the neighbors. Yeah, it's you. Thank you.
Good afternoon, Lear Altman from the Law Office of Lear Altman. With me today, I have Sal Vincenti, who is the architect, and I also have the Stearns, who are the homeowners for this project. We had somebody attend your executive session yesterday and heard your comments. To begin, we have made some revisions to the plans. I've already submitted them to your
Oh, before you do that,
Yes.
did we get proof of service of the
That's
initial?
one of the things I
Yeah,
was just
okay.
about to
Yes,
say.
got it.
You
Okay,
were
good.
one step ahead of me on that.
Thank you.
I'm not sure what happened.
We
That's
made it,
proof of-
we
that's not
made it
proof.
complete, that's the last document.
No. Proof, oh, I see.
Last
Initial
document.
service.
You'll see all 6 are on there. As I said, we made a complete submission last night, responding to your comments. To begin, we have the proof of notice. That is the last document in there. You will also see we provided revised existing plans, revised proposed plans, and a letter from the architect, the zoning analysis form.
So in future, could you make sure that the proof of service forms really clearly show the dates? Because there's no stamped date from the
Okay.
post office receipt, you know, the post office stamps
Well,
these.
those are the ones that come back to me from them. I have no control over how it gets stamped in their offices.
Oh, I see, it doesn't
I
have
send
a-
them out and
the
they come
return
back to
receipt.
me.
Oh, I see, only one person actually dated it.
Right, oftentimes they don't date them or sign them, but those are the forms that were sent with the initial application.
Okay.
So I wish they did all sign them and date them. Unfortunately, it's up to the individual office. So as I was saying, we've already submitted to your board existing plans, proposed plans, a zoning analysis form, revised statement of facts and findings, and a letter from the architect. And I'll go over the changes that are on there. But before I do that, I also want to show you, we have a tax photo from the 1940s. I'll hand this up.
Do you have any more
This-
copies of?
Do you have
of
more
this?
copies of these?
The submission, I do. I have another copy, and I can hand you the original. I'm going to bring them over.
Here,
to
why
you.
don't you just hand it down?
I will
and
bring the
give me
hard copy
other
over to the
copy.
office as well today. There's another copy. Absolutely.
I'm sharing. Whoever.
That's
I'll
just
share
one
with them.
stack of-
Yeah, oh, this is existing.
There are two. And I think we have extra sets of the plans if you'd like. Should I just hand up extra sets of the plans?
Yeah,
We can do
because
that as well.
everybody should have, be
Sounds
able
good.
to follow along, right?
Just one extra set. I have an E and a P. Is there any more?
Was that submitted this morning?
It was submitted today.
Yeah.
yes.
we got
Okay,
it to
so I
drop-
could pick it up off of here.
It's in Dropbox.
Here's an E and a P, hard copy. There's another E and P.
Thank you.
You have one more? Is there another one floating?
I can give you my set.
Yeah, or we can share.
Yeah.
What's the difference? These two are different?
This is existing. It's an existing and a proposed set, and the demolition plans are at the end of the proposed set, pages A and B. So everything has been revised. The first thing you'll notice is that if you look at the second floor plan, or you'll see it on P1, you'll also see it on the second floor plan, we have gotten rid of that bump out. So the side yard is now 9 foot 11 3/4. It's no longer 8, bringing it to a total of 13 feet, which I know was a concern of the board's yesterday. As a result, that also reduced the FAR of the building down to 0.97 is where we are now. The numbers have been recalculated. We're at 0.97, below the 1.0. This has also been revised in the statement of facts and findings. Another thing that we did last night is we compared the existing plans, the proposed plans, and the demolition plans for all of the numbers. And what you will see is additional dimensions have been added to P2, P3, P4, and P5 of the proposed plans. Although the numbers did match, they didn't have them broken down on the proposed plans. So instead of showing, for instance, 18, 8, and 15, it would say 42 feet. So what we did was the additional line was added breaking it down. If you'd like, I can show you on the plan.
Just tell us where you are, because I don't know where
Sure.
the 42
On
feet.
P2, P3, P4, and P5, on the bottom of the plans, you will see additional dimensions added that will match up with the Plans A and Plan B, which is at the end of the set, the demo plan. So there was a concern as to whether everything matched up. So we
Right.
added additional dimensions to make it more clear.
Okay.
And that's on, as I said, P2, 3, 4, and 5. In addition, there was one error on page P4. The dimension on the top right of the drawing was 15, 4 3/4. It should have been 15, 5 3/4. So that 1-inch error has been corrected. There was also shading on page P3. There was a portion that was shown as existing, but it was not shaded appropriately. We've had that corrected. Although it was labeled as existing, we wanted the shading to be corrected as well. The side yard dimensions have been added as requested on P1, so that at all points you can tell what the side yards are. The height.
So before, since
Yes,
we're talking
please.
about side yards,
Please.
where's the proof that the side yards were existing conditions?
Oh, that's, if you look at this tax photo that I submitted to everybody, you will see that that house is identical to the existing house. I can show you the photograph now.
No, but how do we tell, we can't see the side yards?
Well, I can also show you, we have a Belcher Hyde map from 1929, if you'd like.
Yes.
Just pull. 24th, here we go. So it is the same building, and it's situated in the same place on the lot.
What?
You see that?
No, I don't see the little side yard extensions on this. We're talking about, you've got Mansfield Circle, is that?
Where? Yes, that's 24th, yes.
24th Street, otherwise known, was
It
Mansfield?
was in 1929, it was, yes.
Okay.
And this is just for reference, so you can see, this is the 1940 house, this is the current house. It is the same house, it hasn't changed.
No, but you don't see the side
No,
yards.
understood,
The
but I just
subject
want you to
is,
see that the house has not moved, it hasn't changed. This
no,
is the
I'm not
same
talking
house.
about moved and changed. The question is, are your side yard extensions legal side yard extensions from pre-61? That's
Yes,
the
and that's the
question. So I
19
don't think you have anything, none of these houses in the Sanborn or not Sanborn map show little protuberances on the side. So you
Show-
need more information to establish those, at least the one that's reducing the side yard to 3 feet, right?
Well, we're not reducing to 3 feet,
No,
that's.
I know,
it's
but that
existing.
side yard, if it's not a legal side yard condition, then it wouldn't be allowed to be extended vertically.
Right, just to point out, we're going back on it. We will double check that, though. If you'd like, we can certainly get you some more maps proving the 3 foot.
Otherwise, if you can't establish it, then you would pull back so
Of
that the
course.
whole building is at 5'3 3/4.
Of course, but
Going up.
we'll
right?
find something to establish that. We will look through the documents that are after 1929. But as I said, if you look, the building hasn't changed. In addition, we provided a letter to your board in that same submission. That letter is from the architect explaining how the floor joists are going to be moved. And the height of the floors on the sections has been amended so that you will see that the floor is being lowered by 1 foot. That is on T10 and 11, I believe, are the page numbers. And then once you've seen that, I can tell you the changes on the existing linear feet drawing. There was one error on there. If you were to look at the second floor plan on the left side, the dimension was previously 21, 9 5/8. That was an error in CAD. It should have been 21, 9 3/4. Let me show you something. If you look at page A. It's after P12 is A. Here we go. This number right here was previously 21, 9 5/8. It had moved back to 3/4. In the calculations, it was always 3/4. So it was correctly shown in the calculations, there was just a little error with CAD.
Okay. So, okay, I appreciate you pointing these things out, but we're not going to be able to review this on the fly. like
Understood. We
this.
want to
Okay.
let you know that we did go through every number. We checked everything last night as well. The walls are now shown identically on the existing, the proposed demolition to make it very clear for you. In addition, we've revised the statement of facts and findings. We had already talked about other houses 4 houses on one side, 4 houses to the right and 3 houses to the left that were all BSA. They were all BSA approvals with 20-foot rear yards, 2 stories and an attic. In addition, we've added discussions of the 2 buildings that were catty corner that you mentioned yesterday. The building that is catty corner to the right actually is 23 feet. It is 2 stories. And
Where's the information to tell us that?
I can show that to you now.
You need to submit it, right?
Of course, we'll be happy to submit it. Here we go. This is the back of that house, right here. This is our house. This is the catty corner house that you're talking
So how do we know that that's 23 feet?
about. The rear yard study has provided that information already. This is just a photograph to support our rear yard study and to show you how many stories it is. This one right here. There you go. Right here. And we're right here.
And what about the one on the other side?
The one on the other side is 24 feet, 1 story, and then it steps back to the 2nd story.
So then there's only one house that's 2 stories.
One house that is catty corner, then there's a house that's 3 houses over, and there's a house that's 4 houses over. Both of them are 20 feet.
I'm talking about the effect on the immediate properties, right? That's always what we talk about.
Right, and that's one of the reasons that we set back when this house was designed. I'm sure Sal would be happy to explain to you that one of the things he did was he didn't propose a 20-foot rear yard. He intentionally looked at what was around and looked for a 23-foot rear yard. That's why that request is not at 20 feet.
Right, which is, but also why, but it's not at 24, right? It's not responding to the other realities of the other neighbors, and there's no reason why it can't, right? So it's at 23, I understand that at the first floor, but on the 2nd floor, there's no reason why it can't pull back some more.
Well, it's-
And ditto, and especially on the attic level, where it's just a recreation
Do you
room,
wanna
it could pull back.
Discuss the layout.
So I don't really want to have a debate about this. This is the way we do it, right? So the reason that I want your architect and your clients here is I just want to make it clear that the instruction is to do it, not to debate about whether you should do it, right? So that we can move on and not spend 11 hearings back and forth, okay? So the indication is that the other properties have, with one exception, they have complying or close to complying 2nd floors. So this one should do the same. So 23 feet at the 1st floor, and then 25 at the 2nd, and all the way back to complying at the 3rd floor. No reason why not. Okay?
We've heard. You also had a question regarding the front yard,
Yes.
and Mr. Vincenti is here and he has something to show you.
Good afternoon, Madam Chair, members of the board. My name is Salvatore Vincenti. I'm the architect for this job. So just a couple of items. I want to show you just some pictures also, which you were questioning, are those side yards legal? And these are like, you can see from these pictures that nothing has been done for many years. I just want to show, we're going to look for it, but just for your additional information, like it's pretty consistent with the stucco. It was done many years ago, but we're certainly going to try to find what's done.
It could have been done in the 60s, post-1961, right? I'm sure it was done since
I'm sure it was
1961.
done in 1940. It
But
doesn't
it-
seem like much change.
Well, so now prove to us that it was done in 1940.
We'll try to find better proof. Let's see if
Because
there's
in
any
other words,
record.
DOB would ask you the same question. How do we know that that's an existing non-complying condition? You would have to show them,
Right,
right?
but
So you
if
have to show us.
Okay, well, it's because I also go to DOB. When we show a 1940 map, they usually take that as record.
Yes,
That is.
but your 1940 map doesn't show the little extension there.
My
on the
29
side.
map doesn't show. My 40 picture shows the exact same building. So
It doesn't show the side yard.
it doesn't, correct. That's
So
the
how
angle it
did-
was taken. I didn't take the picture in 1940, so that's the way it was
No,
taken.
I know,
Yeah.
but I don't understand this conversation. You
All
don't have
right.
you don't have any proof of that little side yard extension.
I know, but it's the exact same
You
pi-
can't tell me that DOB
okay.
accepts not proof
You
as
got it.
proof.
Okay, let's move on to the, move on to the front. So because last night it was, oops, it was a little late, she's getting the other hand. So this is what I managed to put together, just pictures of only on one side, I couldn't do both sides. So I managed to put this together. This is the whole side where our project is. So this being our project right here, our proposed resident. So
Mr.
this one
Vincenzi?
is a two-story.
Take
You
the
have to
mic.
take the mic.
All right. So this is our proposed project, 1334, right? It 3 doors down, 1320. It's 2 stories. It goes straight up. That was also, I believe, a BSA case. Yes, I believe it was. Going this way, this one is on the way now. Also a BSA case, straight up. This one is straight up also, not a BSA case. And this one was also a BSA case, straight up.
So when you say straight up, you mean there's no
2 stories, there's no
setback?
1 story enlarged. It's 15-foot front yard, which is required in an R2 zone, and then from there, they went straight up. That's what I meant. I'm sorry?
1320 is a BSA.
Is a BSA, yeah. This is a BSA case. This was a BSA case, this was not, and this was.
Okay, those are all on the same side of the street, is this?
The
house?
same side of the street. On the other side, there's a few also that go straight up, also BSA cases, but again, I didn't have time to do both sides.
Okay. One side's sufficient, I mean, that's the consistency of the road that we're looking at, right? So just, that's good, so submit that.
Right.
So we can see, okay. Okay, thanks.
All right?
Watch the wire.
Are there any speakers on this case?
Thank you, Larry.
All right. I think that's it then. So, right?
So at this point, it sounds like there are some modifications to be made to the proposed plans. We need additional proof, and you'd like us to submit the tax map with pleasure and additional proof. The tax photo, I'm sorry.
Tax photo.
Yeah, I'll submit it for the record.
Yeah, the tax photo is part of your way of proving the pre-61 condition, but what we're really looking at is that one side yard
Right.
that's substandard, right?
Right, I have a note that we're going to
So-
see what we can find pre-61, and we'll also
Right,
provide a
right.
copy of the streetscape.
I don't think
Not
there's
quite this
any
size.
question that you've got a 5'3" side yard, because that's what it shows on the pre-Sanborn map, right, or whatever, the Belcher Hyde map. It's that little 2-foot and change extension.
So I have already researched at the Department of Building. They don't have any records. But what I will try to do is, I'll try to get a copy of the tax picture of the adjacent house, and maybe it has an angle. That's what I'll try to
Because,
do.
by the way, the tax photo you provided shows the extension on the adjacent house, which also doesn't show up on the Belcher Hyde.
Right.
But in that case, it's only 1 story, right?
All right, I'll take a look at it, yeah.
And in yours, I believe it's a 2-story. Yeah, in yours, I believe you're showing it as an existing 2-story condition, right?
Existing 2-story?
Aren't you? No. Oh, you're not?
No.
No?
No, oh, okay, no. All right.
No.
So, yeah, using the tax of the other one probably will work.
I'll try to get a copy of that.
You know what, yeah, you do have it as existing, too.
Okay.
That's the attic.
Okay.
And the streetscape.
Yes, we have it, we
Yeah,
have
and the
it already.
streetscape,
We'll
right.
provide a copy of this.
Right, okay.
I think we can turn this around as quickly as you can have us back. As you see, we've already turned most of it around overnight.
Right. What about the other one? This one? This is the, how many on here, 22?
Submission date February 5th for continued hearing February 25th.
And I can already hear there's no chance to go earlier because I heard a sigh when you saw how many were already on. So, appreciate it.
Item number 2, 2019, 156BZ, 25709 Union Turnpike, Queens. Oh, thank you.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
You will have them back when you're back to your office. That's not me. This is the rest of it. This is December 9th. I want to make sure I give you the full package.
Okay, please, we have to proceed. Thanks.
Good afternoon, Madam Chair, Commissioners. Denise Vista with the Model Law Group on behalf of the applicant. We attended the executive session yesterday, and we also reviewed the letters objecting and consenting to the application. So with respect to the objections to the application, they're both related to parking. One appears to be related to on-street parking specifically. We note that the swim school patrons will most likely use the parking lot since they'll be with small children, and that the main entrance to the school is in the parking lot itself. You cannot access from Union Turnpike. And with respect to the parking on the lot, there are 609 parking spaces that are CO'd. We feel that's adequate because we basically have the same amount of parking that was required for the Duane Reade as is required for the swim school.
Do you know how many are in the C41 as opposed to the R32, where I don't know why they're in the R32?
It's a strange history for this site. I think it's roughly about 20%, and that's just a real quick estimate.
In the R32?
In the R32. Now, but everybody in the shopping center has access to all the parking spaces. There are no restrictions, maybe, but for a few for the north well. But otherwise, they're all used by all the patrons of the shopping center.
But we would need a restriction because a PCE can't be approved for an R32, so.
But this would be contained solely within the C41.
Right, so the accessory parking is considered part of the PCE, right?
Yes.
So nothing accessory to the PCE can be located in the R32. So there needs to be something that assigns like the parking spaces or something like that. In other words, to tell patrons only park in spaces 100 to 500 or something like that. Because we can't sanction unless you give us some history on this site about why in the world you have commercial use in the R32. Right.
Well, I do, and I have the architect who
Not sure
can.
it even helps.
Would it be a non-conform, or
Well,
would the commercial use be non-conforming?
That's what I don't know. We don't know any, we have no idea what the situation is.
So I will have Dennis Flynn, who was the architect back in '94, who basically helped CO this property as well as the 609 parking stalls. So he can address that, but just with respect to the parking, as far as restricting it, other than signage, I don't know how we would do that. And under the lease, as well as the other leases with the numerous tenants in the building, I don't know how we would restrict that, other than we would tell the patrons of the swim school, listen, you need to park in this area.
That's how.
Okay. That would be the only way that I would know that we could do it.
Yeah.
So when they sign up for swim lessons.
You would say, please park in the areas, parking space numbers.
Well, they're not numbered, so
No,
we'd
they're
have
not.
to basically give them a general direction.
Yeah. Where's the entrance to this one? Oh, over there, okay. Are the parking rows number? How do you find your car in the middle of a gigantic parking lot?
You hit your key fob and you hope
And
that
you
your
keep
lights go
holding
off.
it until you find your car.
So if you would like, I can have Dennis
Yeah, yeah.
Flynn, who's a partner with Rosenbaum Design Group, basically give you the history of the site because it's
Mhm.
interesting.
Please state your name for the record.
Dennis Flynn, Rosenbaum Design Group.
Move the
So
mic up
just-
a little.
I'm sorry?
Move the mic up a little so it meets your head. Okay.
So just a brief history of the site. We were involved in 1994 with securing new COs for the site. The site was built in 1949. It was prior to the current zoning regulations, and it was a prior non-conforming use when we got involved in the site. So I can't speak to what happened before '94. We filed drawings with the building department. We met with the commissioner, and it was agreed to accept the building the way it was and the site the way it was, and secure new COs for the site. The CO was kind of disorganized when
when we took over. So we worked with the commissioner at the time and secured new COs for the building. The portion of the parking lot that's located in the residential zone is the furthest parking from the building. It's usually the spaces that are last to fill up. It's only on heavy use, maybe holidays. Otherwise, people migrate toward the building, and the swim school is, the spaces that are in the residential zone are the furthest from where the swim school will be located. At the time, there was no discussion about changing zone or grandfathered use, anything like that that we're aware of. And there are no buildings in that residential zone.
Right, and so when you took this project on in the 90s, the shopping center and the parking lot was the same configuration as it is today?
Correct.
So then you must have had to show DOB some proof of existing condition, right?
Yes, an Alt 1 drawing was filed for the purposes of securing new COs and
No,
straight.
but what I mean is to establish to DOB that you had an existing non-conforming condition, you must have had to show them something.
Something prior to our.
Yeah, in other words, well, for one, you drew, did you measure this from scratch, the site?
No, we worked off of, I believe, surveys. I personally wasn't involved that early on in the project. I've been involved maybe the last 20 years.
Do you know if you have in your file anything that, like an old survey?
The only survey I have is from 1995. I do have that. I wasn't aware, I wasn't able to find anything prior to that, prior to our involvement in the site. So I believe when we took over, a new survey had been done, and we worked from that.
I was just curious that you didn't have to show DOB anything, that it was an existing non-conforming use in the R district.
I believe we did. I believe the Alt 1 drawing that we filed had a site plan.
No, but, to establish that existing use, normally DOB asks you, prove to me that this was here before 1961. And it doesn't sound like you had to prove that it was.
Not that I'm aware of, no, and there's nothing in my files about it.
Did it match the configuration from 1949, though?
I couldn't testify to that.
Yeah. Okay. I don't know. All right, so because we don't have any proof that we don't have anything, right? I would just say, let's figure out some way of communicating to the patrons that they should be parking up close to the building, as opposed to on the other side of however you describe it. Maybe you do a little diagram that says, swim school, park here. Something like that. Okay.
Okay.
Thank
I
you.
just want to confirm, though, that we wouldn't be required to install any signage because we don't have those rights under
No.
our lease.
I just am kind of curious about this. I mean, I understand that this is specifically in light of this is in light of the PCE. However, keeping in mind the entire site is being used as a commercial use, and the entire commercial user has the right to use all of the parking spaces, and there's a portion of the parking spaces, 20 or whatever it is, that is in the residential that they're allowed to use. So I'm just,
You're asking why it's an issue? Because we don't have the authority to grant it in our district, simply put. So the PCEs cannot be granted in our district. We encounter this every once in a while, where, in fact, we have another one.
I know
For us
that, but
today, but let me just finish. We have another one that from a couple of weeks ago where they have a little bitty corner of their site is actually in a district where you can't have a PCE, and they're pretty literally building a wall that just says no PCE access on that side of the wall, right? And we have other versions on that sort of theme. This is the same thing where we have no authority to allow accessory uses to the PCE to be not in the correct commercial district. So a way to deal with that is you could have some kind of, say, a brochure or a little sign that's on a counter that says all goldfish swimmers, please park in this region. That's all, right? And that way, we're discouraging the use of the R district for something that we're not allowed to grant.
So my question is relates to section 77-02, which is zoning lots not in existence prior to effective date of the amendment. So if this was a zoning lot that was there prior to December 15, 1961, will this?
But it's not it's not 25 feet, it's far more than 25 feet. So the zoning district boundary doesn't automatically move. It's more than, we looked at, I know that they looked at that, right? Then that would have been obvious, the district boundary moves.
But I think, just responding to that, though, I mean, I understand that the uses that are in there now are all as of right, so none of them have been before this board. But now,
Correct.
all of those uses are also not permitted in the R3 too, but they're allowed to utilize.
Well, maybe they are. See, that's the thing that I'm confused about, but we don't have the authority to grant at all in the R3. Whereas DOB has the authority to view some kind of grandfathered condition, grandparented condition. We don't, because it's in an R3 too, unless you apply that movement of the district boundary line, but you can't because it exceeds the 25 feet.
Sure.
So it just makes it clearer if we're just very clear that you can't extend beyond into the R3-2 for any accessory use, and just like call it a day, right? Instead of losing brain cells.
Okay.
If you need it, we can still use it.
And we also received the FDNY letter. We had every intention of putting in fire alarms, so that's not an issue, and no objection to using the non-ammonia-based fire extinguishers.
Okay.
And I
Does
believe
fire
that those.
department want to speak, or otherwise it was a letter of no objection that you issued? Right. Okay, great. All right. Are there any speakers on this one? Okay. Then I'd like to make a motion to close.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
And a motion to grant on condition that no parking that's accessory to the PCE be located in the R32 zoning district, and that the PCE put up a sign or some kind of plaque inside the PCE advising patrons to park in the area that's not in the R32, little diagram or something. Park here, something to that effect.
Okay.
Okay,
Thank you all.
sure. So a motion to grant on that?
Chair Promoter.
Aye.
Vice Chair, don't leave. Hi.
You can leave, but
No, let her, no.
listen to the vote.
You have to listen to the vote. We haven't granted you yet.
Excited.
Okay, I'll call it again. Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Application's been granted. Now you can go.
Now you can.
Item number 3, 2016-4149BZ, 500-508 Van Nest Avenue, The Bronx. Okay, the applicant's going to come first, but you can sign it. Applicants come first. Oh, you are? Oh, sorry. Okay. That's right, you're John Sack. Okay. You want to sign it too? And then, is this it for your team? Okay, so you're going to raise your right hand and she'll read you.
You ready?
We'll
Raise
wait
your
till the
right
gentleman, let's hear the gentleman's finished. Raise your right hands.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to board member questions?
Yes.
Good afternoon. Thanks for hearing me. I'm Jonathan Sachs, the developer for this site. I did have the opportunity to see the executive session yesterday, aware of the concerns of this board and many of the deficiencies that perhaps in our application. I first want to apologize to this board for our submission and for the length of time that it's taken to get here. So you understand, we're experienced developers, first time we're looking at any kind of zoning issue in the city of New York. All the building that we've done up to this point has been as of right. We've worked in quite a few municipalities.
Sorry, I need to stop you because of there's an issue with service. Just one second. Did we get proof of service of initial application? Okay.
I
could
confirmed
not-
with Darrell Ruffin 3
I
days
couldn't-
ago that we had everything submitted and in. I gave the proof of service.
Initial
and-
service, proof of service of hearing, yes, we have in the publication, we have. I couldn't find it. Daryl said he couldn't.
Okay, so it doesn't, it's
Although the
different if-
community board-
It's different if there were no notice of hearing submitted, that we have. What I don't have is proof of service of the initial application to the officials, and we just need you to submit that. But we do know that the community board heard this application, even though it was a long time ago. So the implication is there was proof of service, because otherwise the
There was
community board
service.
wouldn't have heard it.
Right.
But to complete the record properly, please make sure you get us a copy of the proof of service.
That's
okay?
that's the service of when you initially file, when you file with the board, you have 3 to 5 days, I think it's 3 to 7 days.
3 days.
3 days, sorry, thank you. To serve the electeds, the community board, council member, borough president, so forth. Those are those receipts we need.
Okay, which we
Yeah.
do have, because obviously we did them.
I
with the
looked in the
community
hard
board, and
copy.
once again, I apologize, that, and I know that ignorance of the process is not an excuse. Just want you to understand that this process is run very differently than every one of the other processes that we've run in every municipality, including other cities in New York that include New Rochelle, which we just went through a major zoning change to do a zoning change for industrial to hotel, for a 225-unit hotel we're building. So we get involved usually in these processes in a very iterative way and attempt to bring every stakeholder in. That usually includes boards that we're involved with, usually meet with those boards and go through that process. What we understand here is we should have taken this to a higher level of completion before having submitted, and we apologize for that there's review of documents that are not sufficient for the process. But it was not meant in any way to belittle this process or this board. It was just our lack of understanding of process here. What we had done in our process as background was to have engaged the community. This wasn't a situation where we just went out, designed a building and said we would like to place it here, look to get a disapproval, and then come for the zoning. We actually spent over a year working with the local officials. We've met with the borough president, we've met with every one of the councilmen and senators that were in the area. We met with multiple community groups that were represented by not just this community board, but we've worked with Morris Park and with the Van Nest Alliance. And we worked with the community board to go through multiple iterations, at least a dozen meetings and multiple iterations, to come up with a solution that we thought was going to work very well for the community. And all of this was based on our initial understanding that when we looked at the site, the subterranean nature of this bowl that was out there, and attempted to look at what our as-of-right opportunity was in an R5, which was to build the potential for 9 units in a typical townhouse that would be there, that they wouldn't be marketable if they were down in the bowl. And that we had this need as well, also, that we had to deal with a setback for off-site parking in the R5, which was going to force us to build structure or substructure to bring us up to grade that would not allow us to cost justify the job. We went through other iterations of other types of buildings, but in working with the community, there was this sense that they actually wanted something that was going to be a little bit different for this area, one that was going to be an ownership opportunity that was here. And we reiterated our thought process from, and I don't want to disparage it, but their comment constantly were, we just don't want another set of Section 8 housing here. We wanted something that was going to enhance this neighborhood, something that was going to be substantial and meaningful, and something that would bring more pride to the individuals who were going to live there. And that's what the community was looking for. So we also were very cognizant of our neighbors who were here, and how if we were to build this building in the as-of-right nature, we would be dwarfing people who were down on this bowl. They're going to be 2.5 stories now, not just below grade, from what was an open area to now being staring at a building at the edge of their property. And that wasn't going to work either. So again, these were taken into consideration. All-street parking also became a very big deal, which we saw that to build anything, we were going to have to build a lot underneath the building that was also going to be substantial to meet that, or we were going to have driveways throughout that were going to end up eliminating parking in the area by putting in curb cuts for every one of these units. So that's how we went through this process, and unfortunately, when we started to work with the BSA, we saw it again as part of our iterative process, where when we would receive back our notice of comments, we were addressing those comments. We thought then we were working towards this conclusion of ultimately presenting, but then got stuck in a quagmire of environmental. So it came up much later in our process, about a year into this, where it never addressed in the original first two notice of comments, but then addressed that we had to provide more in the environmental studies. So, and those processes took an extremely long time, including the outsourcing by this agency to the DEP, which we were having an incredibly hard time to get them to ultimately respond, but finally finished that process. So I know you were trying to force this issue. I recognize that we've got significant deficiencies. We're here to present today to give you a better understanding of this project and what we're doing, hoping then to go back. We've discussed engaging Barbara Cohn's firm, as well as Eric Palatnik's firm, representing people who know, have worked with, and understand process significantly better than we do, so we can show more respect and timeliness to this board.
So the thing is, I think your cart is far before your horse on this. I understand where you're coming from your experience in other places. Where arguably it's a different kind of a planning solution. You're actually rezoning a neighborhood or something like that to do a project. That's not what the Board of Standards and Appeals is. We're a variance. This is a variance application. So the variance application is restricted by the findings that have to be made. And it's not about the ideal project that you wish you could put here. It's about the hardship that the site presents, and then the board's determination that that hardship is a legitimate hardship that presents you with difficulties, that the site is unique. I need to remind about the uniqueness, right? So you're not like I forget what number it is, 500 and something other sites that were mentioned in a newspaper article that we talked about yesterday. And so you're in such an unusual situation that you can't develop your site in the face of the hardship and need a waiver, right?
And we fully understand, and all I'm saying is that the reason we took the process we did in this iterative way, expecting to work with the BSA, not necessarily this board, but working with the representatives that were there, is as we do with all other zoning boards.
No, but
And
it's
we're
not
planning.
like that here,
And
right?
I understand now our
Okay.
ignorance, and that's what I was apologizing for,
Mhm.
that it wasn't meant in any way to demean what your process was. But I'm just asking you to understand, we didn't understand the process and what our obligations were under that process at the time, and that we did start too early by engaging the BSA, where we should have gotten deeper into developing of the final plans, understood that the environmental was an issue.
This is an iterative process.
Mhm.
Once the initial finding that there's a unique physical condition and the condition poses a hardship has been established, then we say, okay, you have these problems. We can help you have a viable project. And the iterations are, you're asking for far too much floor area, or you're asking for too many waivers, and we push back on the amount of waivers you're requesting until we get to a place where we think you have the minimum variance necessary. But if you'll, referring to yesterday's comments, which you heard, right? Then yesterday was all about what we call the A finding, that you need to have the unique physical condition that presents the hardship. And at the moment, that's what the focus should be on, not on the desired project in the end, but why you can't use this site as of right.
I understand, and
Okay.
I have the architect here who
Okay.
is prepared to, talk to the issues so that we can make sure this board
Okay.
is comfortable with allowing us to continue and improve upon what we've done at this point, to fully present the hardship and our solution on looking to overcome that hardship that both is a benefit to the community as well as to the developer. So, with that said, I'd like to turn over to, unless there was another question, Will Alicia, who's the architect on this project.
Good evening, everyone. I'm just going to do a quick handout. This is in the tome of information you already have, but I just wanted to specifically get you some photos so that you get a little bit of clarity of what the uniqueness of the property is.
Thank you.
Samples we've seen.
Yeah. This is below grade level. Yeah.
So what I handed out was basically focusing on what Ms. Perlmutter mentioned, focusing on the uniqueness of the property. By the way, I'm William Alicio, the architect for the project. And at first glance, the first photo, I didn't want to deluge you all with a lot of photos, but the first photo you're looking at is essentially what is the condition along Adams Street. Our site is to the left, and what you see adjacent to our property is a couple of the houses that are existing there that were built back in the 1900s. So you're seeing the top of a 3-story house along the sidewalk. And that's basically our issue here. These houses could not be approved today with the building department. They would never be built. But that is a condition that we're dealing with. That's which is signifying that the property ranges below the sidewalk between 18 feet on one corner, and as you turn the corner, head down Van Ness, it's about 11 feet on the other corner. So there's a substantial drop as you're walking along Adams Street. The tops of those buildings only signify the 3rd story. So basically, the second photo, you can see how they access the rest of the building. They actually walk through across a bridge, downstairs, to the level that they need. Now again, this would not be approved today. The habitable space, the light and air requirements for front yards are such that it has to be clear and not a courtyard, because then you get into courtyard requirements and courtyard sizes. The second aspect, the 3rd photo you see is actually a picture of the retaining wall. It looks like a jungle. And that's part of the problem. Again, this is over 125-year-old wall, stone rubble construction, but that is the second part of the uniqueness of the site. I'm standing at the site grade, and the area above is where the sidewalks are.
Your property is 10 feet in from the retaining wall, right, roughly?
Well, no. Along Adams Street, it's 6 feet in.
Okay.
So the property line starts 6 feet in from the
retaining wall.
From the retaining wall, exactly. And I think that 6 feet, by the way, signifies, or could signify the depth of the monster footings that are under that wall. So they may extend 6 feet right to the property line, our property line. The one along Adams Street, our property goes right to the retaining wall. Part of the problem that we're facing with this unique site is that the majority of that retaining wall along Adams Street is not accessible to us because we don't own it. We couldn't find the ownership. It was New York Railroad back in the 1800s, and as much as we tossed the information to different entities in New York, we could not find the ownership of it. So that's another set of issues that we have to deal with. We couldn't test it. We couldn't work with it because it's not our wall. Basically along Adams Street. This picture here.
Take the mic with you, sir.
Sorry. So I brought this photo here because it shows you an aerial of our site. Our site is right here on the corner, and this red line signifies the extent of the retaining wall. It does go the entire length of Adams Street, where you see the tops of those three-story houses. And it does come partially along Van Nest. The Van Nest property, a part of the retaining wall, is on our property. So the face width, what do you do with a property like this?
So first we have to go with the uniqueness question. I
Okay.
know that, and I appreciate that for you, the site is a unique site for you to work on, right? No question that among the sites you work on, you probably haven't worked on a lot of sites like this, right? But that doesn't make the site unique in terms of how we look at uniqueness, which is, I keep trying to find the newspaper article that.
Can I just
You have to
speak for you?
differentiate yourself
Sure.
from everybody else in the neighborhood to show that you are actually put at a disadvantage by the characteristics that you're identified. More of a disadvantage than anybody else to prove your uniqueness.
Okay.
Then we could go forward.
Right.
So you're actually faced with challenge because while we were discussing this, I was just doing a little internet research and uncovered an article that covered this neighborhood, covered both the issue of the sunken pit of a lot of the lots in this area, as well as the fact that you're sitting on bedrock. And so those things spoke about the fact that this was a neighborhood-wide characteristic. And so that's your challenge, is to prove that you are unique. So if it's a neighborhood-type challenge that everybody in the neighborhood faces, then you have to somehow differentiate yourself and show us that you are suffering far more than everybody in the neighborhood who is facing this challenge.
I can respond to that.
Sure, please.
I took the way the BSA has defined uniqueness, which is some exceptional topographical or physical condition particular to and inherent to a particular zoning lot. I think we fell right in there. And how we're unique with the rest of the neighborhood is, this is not a neighborhood situation. This is strictly along Adams Street. It goes to the end of Adams Street. I walked the property several times, and it does turn the corner on Van Nest, but when it gets past our property, it's a manageable situation. There is no 125-year-old retaining wall there. There are
Right, so
older buildings there.
you're better set to put this in writing so that we can follow along an actual intensive study, because one of the factors of the uniqueness finding is that that characteristic is not so prevalent that if we were to give relief to everybody, it would affect a rezoning. And so if you're going to start your sentence with everybody on the block, and then as you turn the corner a little, has the same situation that we have, then think about it. If we were to grant this to you, whatever we would finally grant, every single person on the block and going around the corner would be able to come to us the very next day with their hand out going, I want to redevelop my property.
I just want to be clear on this. The lots adjacent to our property on Adams Street are, for the most part, would not be approvable in an R5. They're too narrow. There's also the parking requirements that they couldn't meet. So there is no property that is 10,400 square feet that has this unique quality to it in that area, period.
There are two vacant lots right along Adam that are, I think, a little bit 100 feet off the intersection of the East Tremont Avenue and Adam. And that side, sorry. So as I was saying, it seems there's a pocket of vacant site right along Adam Street, fronting along that retaining wall that you're referring to, which I think is three houses from those three sunken houses. And that is, that does not have access to two streets frontage. Here you have access to two street frontage with one street being at a lower elevation, so that there's a lot more, your site has an advantage being a bigger site, and with two street frontages, has the ability to navigate the slope challenges, which an interior lot with only one street frontage will not be able to
I'm sorry,
generate.
there is no slope on site. It's just the site is depressed. 18
Right, what I mean by
18.
slope is the slope of the street. So the Van Ness slopes down enough to come close to the sunken site condition.
Yes.
If I can. No, I just want to interrupt with this one thing. If that was the only, if that adjoining site or nearby site on Adams were the only other site like this one, that wouldn't preclude you from proving uniqueness, because you don't need to be the only one. You can be one of a few, a couple, like that. The problem is, if I quote the article that Commissioner Otley Brown found yesterday from the New York Times, it says, the city raised the streets in Van Ness around the turn of the century, creating hundreds of lots like 508 Van Ness Avenue. Plenty of older three-story homes in the area were retrofitted with street entrances on the second floor because their ground floors were suddenly a full story below the street. So a statement like that, hundreds of homes in the Van Ness area, I don't know what those are, but that's the point is you don't just look at your block. You have to look at 1,000-foot radius. That's how we determine whether we have a unique condition. And you have to be able to respond to that kind of information.
It is
right?
very clear we didn't do a good enough job so far in the written application to show the hardship. Just to go just one step further, the hardship that actually is created, which we have to clearly express in writing, is that we cannot build what was previously built. These homes were retrofitted, that were forced into this situation. We have that picture that shows you people had to put ramps, steps, and other things to deal with it. DOB would not approve us to build, we were to call that typical, that design. They don't provide air and light under current standards. At the turn of the century, they did. Then after 1910, when the railroad abandoned this, then these people were then forced to retrofit their house in order to do it. So yes, it was not a unique condition that some houses are subterranean, but it is unique today as we stand here today that you cannot build a structure as you would have built 100 years ago.
Okay, but so then that brings us to the next part of it, because we're all asking, why don't you just build your as-of-right structure the way your proposed structure is built, where you're using this pre-excavated cellar/basement or cellar and basement? Yay, you don't have like any excavation costs, and you get all of that usable area in those layers, in those levels for the things you put in cellars and basements, right? And bring yourself right up to sidewalk level and then build on top of that, just exactly like your proposed is doing.
Well,
That's
in-
the
in
part
my-
that's
in-
confusing.
In my notice of comments, I did mention something to that effect. Essentially, what you're suggesting is, why don't we build a two-story high cellar? Now, what I mentioned, and when I did the analysis with the structural guys on this, is that the cost for building a two-story high, I'm going to call it a two-story high cellar, whether it's parking on one level or cellar on the other level, the structural walls, the reinforcement required for that platform in order to bring the houses up to sidewalk level, and the subgrade conditions, which was a concern, in addition to the footing spread of the existing retaining walls. Those items were thought to be cost prohibitive.
I'm sorry. Who said that the extent of the existing retaining wall footing is inside your property? Who said that? Have you done any test?
No, we haven't
beds?
done any pros.
So it's an assumption, right?
That's only a minor concern. The primary concern was the structural work required to create a two-story high.
It's not, it doesn't need to be 2 stories.
Well,
Why?
roughly.
It needs-
On one end, I have 18 feet. I
Yes.
have to bring the house up
Mhm.
to 18 feet. That's roughly 2 stories.
Okay.
If you
And
go
the other side is.
It is less, you're right, but, okay, now you have a stepping issue. So there are complications which you can address. The point that I'm trying to make is that platform, the required sort of platform that's required to lift these houses up is not in keeping with a 9-unit development in terms of, it doesn't make any financial sense. So how do you, so I addressed that in my notes of comments. So the next condition was, and you're creating a parking structure as well with.
But isn't that what you're proposing?
Why not have you drive in off of Van Nest
Oh,
underneath the
that's
building,
in the
and
proposed.
you have parking in an unfinished sub-cellar, and then you slap a cellar on top of that actually you could put different types of things in, fitness room, laundry room, that kind of thing.
Community room?
And then build.
It was because we couldn't amortize that cost back over it to get the return on the investment that we need.
You're the
Because we
developer.
were talking about starting with a ramp, which we ultimately designed, that would come down from the Van Ness side, which is the only opportunity, because otherwise, I don't have enough, I have too much of a grade if I went from 18 feet coming in the back on Adams. I couldn't do less than 1 foot for every 10 for the grade, I'd be into the other building on the other side. So the only thing that was viable was there, or create a second level parking structure that was there to support the cars. So when we get into, so if I get into building both the parking structure, building the cellar area, building the entire ramp that goes in to support that, then I end up just creating a cost prohibitive situation of what would be essentially 2 townhouses over there. It just can't generate the return. We thought we demonstrated that in the economic study, but if we have to bring this out more clearly, sure, because that's what we compared to, saying, what would a townhouse scenario look like?
You kind of didn't. And I think you could follow all of the comments I said for the financials, that assuming you get past the A, the financials were in pretty bad shape.
Yeah,
There was no consistency from page 1 to page, I don't know, 90.
Yes,
So,
we understand that, and that work would have to be done. So, but we're trying to get across this issue of the hardship right now and understanding that attempting to build a 3-townhouse structure in an as-of-right scenario with no variance, because we'd have to come here for a variance either way if we built the parking structure, because we would be bringing the units forward so they were in line with the balance. We couldn't do the all-street parking.
Why do you need to bring the units forward?
Because I have to provide right now for a driveway, for the driveway access, in an as-of-right scenario, just building the platform and setting the houses 20 feet back off the property line to provide for the off-street parking, which then creates the curb cut. Or I have to build a ramp and a parking structure from a 2-story structure to raise the building and be able to park on the property off the street.
I don't understand. Why can't you just be building effectively a platform on which you put the houses and you drive across the platform into the house?
that's another option.
Create a platform for each
For the
garage
townhouses.
and car.
Yeah.
In a bridge for
Just for the
entrance
car.
and
Yeah,
cars.
for the entrance.
It's a platform effectively. You're building a platform, elevated however high you have to elevate, and you drive right
Set
in.
the houses back, you're suggesting.
So like that's in a completely as of right, because anything that's below grade is not defeating the front yard requirement. Right? So you have your 18-foot front yard if you wanted to have a parking pad, or I think it's 15 feet if you don't, right?
Let me
No,
just
it's 10.
clarify.
It's 10.
10 if you don't.
I'm just need to clarify if I get this. So you're suggesting that each house would have a bridge? That's the parking structure?
You're building a platform, whether you put parking underneath it or not, your choice, right? And it's,
That's what I don't understand. How can I put parking on it? The whole issue is that in the site, no matter where you are, you're a minimum of 11 feet.
no, I understand. So what I'm saying is, if you're saying you don't want to be able to, you don't want to use the parking subterranean because it's too much trouble because there's a ramp, et cetera, et cetera. Instead, you have the parking effectively at grade, but the houses are built on a platform that you construct, concrete frame platform that you construct. You drive straight into your standard little parking garage, and if you choose to enclose the lower level, then you have a nice community facility or whatever that's shared among the houses or something.
And that comes at the cost of just a concrete slab. You're the developer. A concrete slab, structural slab, costs $15 per square foot. If you look at what
To
you.
hold a car?
I'm sorry?
You mean to hold a car, to drive on it?
Yeah, 8-inch thick.
Yeah.
Yeah, 15, $20.
Okay.
That you got, in front of this, you got free excavation, free SOE, and free seller.
But we're still dealing with.
So I believe it's
Well,
it's
that-
not a
I'm not-
minus deal, it's a
I'm not
positive
sure-
deal.
I'm not sure that really, I mean, we've looked at a lot of iterations like this, in particular to try to take advantage of the community space bonus that was there. Also knowing we had Bronx Museum, we've got a bunch of interested parties who were willing to come in to utilize that space. We were attempting to get in the community space at grade and get in the residential from the other side so we could utilize that property. Otherwise, I'm not sure how we would use, without creating the ramp, off-street parking, and other things, utilize that community space. I'd somehow now.
It's all bridges.
Well, you're a corner site. I'm not saying that you have parking entrances everywhere.
Right.
It's corner site. One side of the site, you enter right into the community facility,
Even
the
if
other
access-
side into the residence.
No, even to access that lower level, I'm saying if the community space was on the
Cold.
lower level that was out there, and I was able to prove, I have to provide enough air and light. If I'm now putting bridges above that, I don't know that I would give the air
What do you
and light
mean?
to
You
the
have,
lower level.
if the building isn't built full to the property line, then you have plenty of air and light. You have 17 feet of backyard, 17 feet of height
When
in
you
the
get to low
backyard.
grade, that gets into courtyard. You know, I think we have a dialogue going here. Let me just say this, that
Mm-hmm.
it would be actually worth investigating another as-of-right condition, which is, I think, where this is going.
Yes.
One that's actually codified with the financials that are a little stronger for that particular as-of-right. Whether we create bridges for all the parking, because for 9 units, you'll need 85%, that's eight different parking structures that have to be up in the air. Or we do it a different way. We still have to deal with, are we gonna make a double height cellar to raise the buildings up? And I think those are the questions that we can probably rectify in another go at the as-of-right with the financial information that would help everyone.
Okay, so just to understand that, we're looking at the as-of-rights as not just for you to prove to us that the as-of-rights cost a lot of money and therefore we can't do it. The as-of-rights for us are, is it a viable project absent waivers?
Right.
And, you know, to make it simple, because I always used to like to use very, very simple cases. Sometimes we'll have a lot that's, you know, 20 feet wide and 100 feet deep, and the side yard regulations are 8 feet on each side. So that means you've got a 4-foot wide house. Obviously, can't be built, right? The zoning regulations are such that it's impossible to use the site. So if you use that in your head of what's happening here on the site that prevents you from actually building a project, that's the hardship. Not that I'll make more money if you give me the waivers, right?
Yeah, absolutely.
So no question, you'll make more money if you have twice the FAR, or it's actually 3 times the FAR and 3 times the height, obviously, right? So, but in this case, we're looking at how does this site actually present a hardship that can't be overcome with a little creativity, right? And without a zoning waiver.
Got it. I think that's not a hard lift for us, and I think it's something that we should undertake. The other part of the uniqueness is this retaining wall, which is, it's about 200 foot of boulder, rubble retaining wall that's over 125 years old, and that requires an extensive amount of investigation to factor in what are we going to do with this thing, which is another part of the unique part of the site. There's no other site with this kind of condition, except for those few houses on Adams Street. I walked the neighborhood, by the way. There's no other condition like this in that entire neighborhood.
But the condition of those retaining walls, has that been documented through any kind of formal investigation?
Our structural engineers looked at it. They said they were in poor condition, but we haven't done any probes. So we'd have to do about a 4-foot long probe through the retaining wall at mid-level, maybe every 8 feet. And then in addition to that, we'd have to scope out the footings, see what the extent of the footings are, how thick they are. So we have not done that. part of the reason, and the main reason, is that we don't own the retaining wall along Adams Street, and we're not sure how to leap over that. The lawyers were kind of scratching their heads about that one, too. So, I know. So do we just jump on somebody's retaining wall? We don't know the owner. You know, it's like, couldn't get clarity on that. That retaining wall is a monster, and we'd love to solve it, but it's 80% of it is not ours.
The only clarity we've been able to get so far on this retaining wall is that it was originally New York Railroad, that nobody actually has responsibility for it, and Department of Highways is maintaining it. They only say they are maintaining it, not that there's ownership. We grant them access twice a year. They come out and cut out the overgrowth and the other things that are there. But other than that, no one has been able to find any record that shows a chain of title on this 6 feet, other than when it was granted back and the street was built. And I need to look for anywhere to go to, any other kind of additional records. I've had three attorneys work
You've
on
gone
this.
to title companies?
Yes.
The attorneys in the title companies?
Yes, and our title had suggested, because he's been involved in this in several places before, he says, go to DOB, put in your application to build all the way up to the wall, because Department of Buildings wants these spaces eliminated and not have cliffs hanging off there. They want someone to take responsibility for it, and they will grant you the ability to build foundation up to the wall. I wasn't gonna count on that, but that's what they're suggesting to us.
DOB doesn't care about ownership, so
They
they're,
don't.
right, so that's a totally different.
That's what title has told us when they've had the situation without having the ability, especially when it's a municipal situation. Typically, there's always a chain of title to transfer a property that's out there in any private situation. I don't know if this was done by eminent domain or some other kind of situation when they ultimately built the road, but we can't find any record whatsoever that dates back 115 years to show how this had actually happened.
What do we always find with the signs that are owned now by the central, what is it, the railroad, that they kept changing the names of the
CSX?
railroad?
Oh,
CSX. Right? So, because we've had a lot of experience with signs mounted on railroad property.
And we were told to go to Metro North, because we were told that it was a predecessor to CSX. It went through many iterations of
Central Railroad.
But CSX ultimately ceded all of their rights to maintenance and management over to Metro North. MTA was supposed to have authority, they have no records whatsoever. They say, we don't own this property, it doesn't affect our tracks, we've got nothing to do with it, we didn't take it over as part of what was ceded to us. So, again, we just don't know. Because it would have simplified things for us if we were able to deal with both frontages.
In other words, if it were yours,
It was ours.
so what, go for a declaratory judgment or something, have the courts decide what.
Because in truth, we have to either make a bridge over that property or get ownership somehow. Which is
But
not
you
ours.
could build inbound of that wall without touching the wall.
But how do you get across there along?
Can't lever your bridge. Don't
Can't
bear,
lever over the-
don't bear on the wall.
What we were told was the only way that we could do that is we'd have to make an application for an easement for necessity. And that's how we would ultimately.
To who?
upgrade.
So, to the court, so
To the court, that
you
we
do
have
that
to-
at the same time as trying to get a declaratory judgment that the wall is yours.
How long have you owned the property?
But
Yeah.
again, we understand now that we should have been further along in this process. We were looking at this as saying, which we do with many, many other zoning boards, is to come in and say, look, this is what we're proposing. And then based on that, we would say, okay, we got an idea that this thing could fly. We'll now invest the additional dollars and energy into looking at all the other alternatives.
So it doesn't really work like that here, see?
I understand.
Right?
And
So in order to prove your hardship, we need to know whether there's an actual financial cost. So if we don't see a cost, that's fine, right? If you don't tell us that repairing the retaining wall costs X and we don't have to figure it in, then fine, we don't care how much it's costing you because it's not affecting our analysis, right?
And we thought we did, but we didn't. And we understand that now, we understand that we have to strengthen significantly both of these issues. To clearly demonstrate not just what we're verbalizing here in the hardship, but to put the economics behind that, why the hardship exists. The number one hardship, though, that I thought would have been enough was, I can't build typical here. I can't just go down department will not let me put in a structure down in the hole. I have to build it up. We didn't do a good job in representing what the cost is of that incremental cost to show you why it wasn't even.
No, you keep talking about the cost, you have to back up. The question is, it looks to us like it's physically possible to build a building on either a platform or a community facility structure that you can rent, or there's parking, or what they showed in their
You
proposed.
already have the design.
Yeah, you
It's
already
right
have the
here. You
design, it's
submitted it
just
to us.
taller,
That's the
right?
proposed, right?
Yeah.
Right, so the question
That takes
is,
advantage of the pole, right?
so the question is, why can't you do exactly the same thing for the ads of?
Because I couldn't amortize that cost. of
But
building
that's a
it.
different question. That's not the hardship then. What you're doing is you're saying, it's too expensive for me to do this thing, as opposed to, it's a unique physical condition that poses a hardship, right? It's not a hardship. You can overcome it.
But before the hardship, again, it's still got to be a unique physical condition.
Right.
And that's the first argument that you didn't make, I don't believe you made in the papers, and I think that's going to be the first hurdle. You're going to have to tell us why this physical condition is unique to you and your property, and it's not something that is shared by your neighbors.
A lot of neighbors.
Or many
It can't-
neighbors.
It doesn't have
Not-
to be one other neighbor.
But it's not something that's shared by the majority of your neighbors, or
Or a number,
or a number
a
of
large
neighbors.
number
I
of
believe
neighbors.
before we dive in this, I believe one of the issues here is they are claiming the retaining wall as a hardship because
Right.
they don't know the owner, it's deteriorated, it is all of that.
You have to take
And
that
then,
out, right.
did you investigate it? Did you test it? Did you do any analysis for the wall? Did you do any borings? No. Why? Because this is gonna cost too much.
No, that's not what they're
He's
saying.
saying you can't own.
They don't own it.
No.
But you
In
have to
your
present-
submission to us, you said an investigation, you just said it, an investigation to this wall is gonna cost too much. You just mentioned
It was in
that.
the papers, that I remember. It was in the papers.
So that even the,
Says
like the
here-
investigation of the wall itself is claimed as a hardship.
It says they think they are deteriorated but don't know for sure. They would need to do extensive investigation work to determine the state of the wall and determine a repair. That was my notes from your statement of facts.
Correct.
I don't think
Well, that's
an
correct.
investigation for this
It wasn't
wall.
about the expense, it was about that we have to do the
Okay,
extensive.
but
investigation.
I think the
point-
point is this, that either you take that out of your hardship because we can't quantify it, because you didn't provide us with the data to quantify it, or if you want it to be included in your hardship and
Yes, we-
therefore included in your costs, you must do those investigations, right? And if you can't do the investigations because you don't know who owns it, I find that a little problematic, because who's gonna care whether you do the investigations? But, right?
But
But
it's
but the thing is, you either take it out, so it doesn't complicate the rest of your story, because you're not gonna be able to give us the answers, therefore we can't rely on that statement that it's a hardship, and you stick with the concept of it's this deep bowl, and then we have those questions about what's so bad about that. It sounds like free excavation, so we don't actually see that as posing a hardship.
Yeah,
So, yeah.
the record can't rely on a conclusory statement. That's
Right.
not backed by any evidence.
Right.
And I believe if you're allowed to investigate this wall, the investigation of this wall could be very straightforward.
So I just have to, I'm thinking that any workers with liability issues would have to sign a release if they get hurt doing, so that's another.
Again,
sort of
this
This
complication.
is not our, okay. All right, I would like to actually, because the neighbors are here to speak, I'd like to move to them, and then we can come back, okay?
Okay.
So are there people to speak on this? If so, please come up.
You can come up one by one, and you'll have 3 minutes each. Please state your name for the record, you could sign in later. No, you can line up there if you want.
Hi. Thank you, members of the board, for your years of service. I'm Jeremy Warnke. I'm District Manager of Community Board 11.
Oh, sorry, I won't time you.
So you're
And-
representing board?
Yes,
Okay.
yes. I'm here in my official capacity.
There's no time limit then, okay?
Right.
Okay, I'm going to try to be brief because I do have to run. So I don't know if you have the executive board recommendation that was submitted in October 2017. It basically supported the land use committee's concerns.
which I think are more or less being addressed already. Obviously, most community boards are concerned about space or size and parking, right? So the executive board recommendation was in lieu of the full board. Our executive board only makes these recommendations when the full board generally cannot meet in time to submit a recommendation. And they had no objections, provided that less than 47 housing units and more than 24 parking spaces would be created. I know going back into previous minutes from the Land Use Committee, I know they were concerned about the FAR being expanded. And again, for the most part, I think this really, it's not stated overtly, but I think it goes back to what the board members here are saying in terms of uniqueness. So other than that, I think I will turn it over to, so we have two members of Van Ness Neighborhood Alliance here, as well as a member of our board has both hats here. But thank you very much for your time.
I appreciate your coming, but I do have a question.
Yes.
Since your executive committee met 2 years ago, right?
Yes.
And then the application is before us now.
Yes.
So, and it seems as if you were forced to have only 4 people vote on this as opposed to the full board because of some timing issue. So my question is, does the full board maybe want to look at this so that everyone can voice their opinion in a full board resolution, because we don't actually have a full resolution?
Yeah, I think members of the board would be happy to do that. And obviously provided some type of timeline in which we do. We don't meet in December, so
Right.
the next time we meet, we tend to meet the fourth Thursday of the month, so January
Okay.
would be the next meeting day.
Okay, great. Thank you.
Okay? And thank you very much for your
Madam
time.
Chair?
Mm-hmm.
I'm sorry, just for the community board, would they be weighing?
Speak up louder.
Would the community board be looking at the project as is, or any revised version?
They'd be looking at our submission, because they'd be looking at what we've looked at,
So
because
far,
at the
okay.
moment, the third week in January, they won't have a new
Sure.
submission. But I do have to say that, of course, as is normal, when the applicant submits revisions, that should also go to the community board. And if that happens to overlap, then the community board will have more information.
So can I just
Right.
ask that, I don't know, because there's been multiple submissions on this over a very long period of time, if the community board can be provided with a copy by the applicant of all the materials that have been submitted
Submitted
again?
to date,
So that
right.
they have the most up-to-date?
Yeah, it should actually be, the only one that they didn't receive is the one that was submitted 2 years ago, right, after the board voted. So we have, we had a submission in, submission December 28, 2017, and the full board, the executive committee decision is 2017, but I think it actually was
October.
before that.
Yeah, it's October.
October, okay. So that's what they should be getting, is a copy of the December 2017 submission. And then if in the interim there's a subsequent submission, then they should also, the community board should get a copy of that, as should all the other officials, right?
Okay. Thank you very much for your time.
Thank you. Next speaker, please.
Sign, yeah. In favor or opposed? You could sign either one.
Good afternoon, everybody. My apologies to Chair
your name.
and to the board, because I do not have copies for everybody, but PDF was submitted.
Your name.
Oh, I'm so sorry. Bernadette Ferrara. I'm the president of the Van Ness Neighborhood Alliance, and I'm also a board member on Community Board 11. So, and I just have a short testimony, but I also submitted a lot of the letters from the residents, from Van Ness Neighborhood Alliance, from also the Morris Park Community Association, and also what Mr. Warnicki, our district manager, the recommendation from the board. So it was submitted by PDF, so you all have that. I just don't have a hard copy for you right now. So the Van Ness Neighborhood Alliance and its residents have had many meetings throughout 2016 and 17 in discussion with this project at 500 and 508 Van Ness when it was first brought to the community's attention. The original project was out of nature with the current landscape of Van Ness, which consists of 2 and 3 family homes and a handful of apartment buildings no higher than 5 floors. The original 14-story above-ground building, bringing in a large number of people to an already condensed community, was not favorable, but more importantly, the amount of cars per family to an already difficult parking community and traffic congestion. Most of the homes were built between 1900 and 1925, some 1876, with no driveways. As residents living in Van Ness, driving around for 3 hours to find a parking spot with 4-day alternate side parking is a stressful situation. Morning and afternoon rush hour is already congested with over 22 school buses adding to this. And as of October 2019, the Morris Park Road Diet has compounded this already disastrous small community. This is also a concern that the community infrastructure cannot handle this large of a building. A note of concern was that this public hearing was received at Community Board 11 on Friday, November 22nd at noon. This gave notice to the community of this public hearing only 12 business days and 18 full days in general during the holiday season. It wasn't enough time for local residents to work on their schedules to get to this public hearing or even to reply. Also a note, the only ones to get this public notice in the mail were residents of Van Buren Street, Adams Street, and across the street on Van Ness. Mr. Alicia was at all of the meetings with myself, Van Ness Neighborhood Alliance Executive Board, and others that attended this meeting. He had our email addresses, yet none of us were made public note. I just want to say that for the record. Many are in opposition to this project because of its large volume of new people, approximately 150 people into a community that is already condensed, and the cars and the traffic congestion. That's all I have to say. I know that we met about 13 times, 13 meetings with the community, along with Mr. Sachs, at least the architect and the lawyer. So we do have a back and forth of what is going on, and we do appreciate working with the community. We just want to just keep things in mind that one of our agreements were, even though we are opposed to it, is that there was less than 47 housing apartments, that it will stay as ownership, and that hopefully more than 24 parking spaces will be created by the developer. So thank you very much. Is there any questions?
Thank you.
Thank you.
Next speaker? Yes.
Hi, my name is Charlene Jackson Mendez, and I work along with Ms. Ferrara on the Van Ness Neighborhood Alliance. I'm the vice president. Thank you for your time today, and I'll try to be quick and concise because I've got to get back to work. I wanted to say that we have had numerous meetings regarding this issue because Van Nest is like a little village, and it does have many unique characteristics. The neighborhood is somewhat isolated and cut off, so once you're in it, you really don't have many exits. So anything that would increase the number of people and the amount of traffic is a very, very serious concern. Not only because of the difficulty parking, but also safety, like would EMS, fire trucks, things like that, be able to get to people in an emergency. And in addition, we now are affected by the Morris Park Road Diet. So there's even more congestion in our area because Morris Park is the major thoroughfare, and instead of having 4 lanes, 2 on each side, now we only have 1. So there are very serious concerns about access in an emergency. In addition, I want to reiterate that we have made ourselves available to the developers, and so we are quite disappointed that we were not notified about this hearing. We want to be respectful of everyone's time, and there is no possible way for volunteers such as ourselves to adequately prepare for these meetings and advocate for our community as we promise if we don't have time to prepare. We're not paid to do any of this work. So when you don't give us enough time, it really makes it very difficult for us to believe that you genuinely want to partner with the community. The last thing that I will say is that a traffic study was conducted, and I want to call into question the quality of the traffic study. Basic information was not even correct. So for example, the study indicated that I believe Adams Street runs west, and Adams Street does not run west, it runs north. So when you have basic facts like that that are not accurate, it calls into question the entire validity of the study. And secondly, a major portion of the data provided or used to draw the conclusions in the study was taken on a day where there was no public school in session. So the data is not representative of normal traffic patterns, on a Monday through Friday. So those are the concerns that we have. I don't think we're necessarily opposed, but we want things to be done properly. We do not, we that have homes in the area, many are elderly. Some people have been in the community 40, 50, 60 years. I'm a newbie at 10 years, and we really are fighting for our community. We really love it and want to improve the quality of life. And the last point is the infrastructure. We don't know if there's a reasonable study of how it would affect things like Con Edison and sewage. And our neighborhood is very old. So we've had blackouts in the last week, a sewer pipe overflow. So those are additional concerns. Thank you very much for your time.
Thank you. Thank you.
Anyone else?
Any other speakers? Okay. Please, who's ever going to be representing?
So just to start, our final iteration of the building, which the board has, is a 6-story building, which was gleaned from the meetings that were mentioned. We actually had 2 different final iterations. One was an 8-story thinner building, one was a 6-story squatter building, and the consensus among the people that were present at that meeting was the 6-story wider building. That 6-story wider building has 46 units under the 47 and 25 parking spaces, more than 24 requested by the people of the community board. As regards the notifications, we use a third party to send that out, and we were told that everything was done in a timely manner. So I'm a little surprised, and I apologize that you guys didn't get notices earlier. I just want to conclude my statements without getting into too much detail, that we have acknowledge that we can do a better job in presenting this to the board, and we understand the dynamics that are required. We would like to continue and fulfill those requirements so that we get clarity on the as-of-right and the proposed building as well.
Okay, so I would recommend that you not do any work on the proposed, and you stick with the establishment of the uniqueness and the hardship and the as-of-right in a way that's credible to us. I'm just, while people were speaking, I'm kind of surfing around from the sky, and I see Rosedale Avenue, and I think there was another one that Commissioner Shonda saw. Rosedale Avenue has the same situation as Adams, where all of the houses sit in sort of a pit, and all are approached by driveways, but some of them are new houses, right? So you just drive straight into those houses. They're exactly like what we're talking about. I'm looking at one on Rosedale. In fact, it's 1531 Rosedale Avenue. It's two semi-attached houses, which seem to have two subcellar levels. You drive straight in from the street into those houses, and they are probably, R5 compliant. They're, looks like a 2 or 3 story house. And that's kind of what we're talking about here. And then on the other side,
Baker Avenue.
sorry?
Baker Avenue.
Baker is another one. So, and Bronx River Avenue may not have been such a deep depression, but what it looks like there is the decision was to slope down, so to allow the parking to be in that kind of classic, something that you see in the Bronx a lot, these kind of classic, really deep drive-ins. And then the buildings are 3-story buildings, but starting at a lower level. So, but they don't really read like a pit because it's sloping down in.
And we'll take another look at all those, because we did canvass the entire area, because we find that kind of situation. I'm going to guess that we found nothing that were 100-foot depth lots, and that's the issue here, that we're creating a situation coming off of Van Nest, ends up not allowing us to utilize the entire depth of the site based on the MKO. So we're going to end up with the entire area of never developed property that's in the back. We can't go off the wall. But again, we'll study it again, we'll look at those comparisons, be able to show you that this is a uniqueness in the size of a lot, the way it's structured. I think we clearly understand.
Okay, thank you.
Have you done any borings on the site?
Speak up, please.
Have you done any borings?
We only did a couple, there was a dilapidated building on the site,
Yes.
which we had to demolish because of safety reasons. And prior to that, we did just an excavation to make sure that the equipment could get down there, it wouldn't fall into something. But that's about the extent of it.
You did excavation how deep?
Only about, I went to see it about 4 feet, just in the area around the existing.
It only had to
structure.
support the heavy equipment that came in to demolish the building.
Okay. But you don't have any boring data for the property?
No, the only other sampling we did was for the.
I'm not talking about sampling, just
No, we haven't
even
done
if you,
more.
even if you
We
dug
haven't
like
done
6
all the
feet or
site
so.
conditions because we weren't getting a testimony, so we hadn't done that yet. We were making an assumption that we're gonna be able to build on that. We're gonna have to go to the next step and see, do I have enough supported bedrock that I don't have to go to the foundation?
Okay.
And that we have to
Well,
do
when
is-
they excavated the existing buildings, we got a picture of that. It's the northeast corner of the property that was done.
I can't guarantee that you're gonna have bedrock, but most likely you will.
Well, we don't know,
Another
we don't
cost.
know the strata, we don't know exactly how it produces, we don't know what depth. Yes, we have to do all of that to be able to do all of our work.
Okay, all right. Can we
Tracy
set
has
a-
something to say.
Oh, Tracy, did you want to?
Oh, I was just saying they will be doing the borings for the environmental, which is what he said,
Oh, really? Good.
for the phase
Okay.
2. We're waiting for the phase 2 plan. and
Okay.
then
We've just had the approval on the EAS, so, and
Are you going to do any borings outside the property line?
there wasn't planning.
No, I'm asking. Yes or no?
I would
Any-
only
any-
do those that were to affect what we would do from an engineering standpoint.
Check the
to
footings.
structural. Are you suggesting there's a reason we could bore outside the property line?
I'm not suggesting, I'm not directing you to do it, but if I were you, I would. Next to the wall.
Well, next to
Because
the wall.
like I said, because like I said yesterday, this wall, by your engineer's statement, it's rubble wall, dry stack, no mortar. No mortar means that it's smooth. If it has something right behind it that it's pushing against, it should have been dancing, right?
Well, we
It's
need to do
18 foot.
We need to do
tall.
a survey to see how much it's tilted and that good stuff, but yes, I think that's in order.
If you wanna do it.
We'll look at full subsurface conditions. Of course we will.
If you get any information, please send that.
Yes, yes, okay.
Okay, submission date, February 26th, with a continued hearing on March 17th.
February 25th, Kurt?
6th.
26th, thank you.
February 26th, with a continued hearing on March 17th.
Thank you.
Thank you very
Thank
much.
you.
Item number 4, 2016, 4264 BZ, 194 Moffett Street, Brooklyn. Ladies' room. Yeah. Oh, excuse me, how rude. What's that? You gotta raise your hand, I know Barbara. Don't go away. Tony, you and Barbara? Okay. Raise your right hands. Go ahead.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? I do.
Good afternoon, Sandy Anagnostu representing the applicant, and I'm joined by Mr. Arash Makani, the property owner, and Barbara Cohen, our real estate and planning consultant. I attended the board's review session yesterday. I noted the board's comments. I'd like to address some of them, and then Ms. Cohen can come up and address the financial comments, and will, of course, elaborate more in our submission. So regarding the A finding, this site is comprised of 2 tax lots, 16 feet wide, which are the only 2 vacant lots on that block front. The zoning district boundary runs down Moffett Street. Directly across from the site is an R6 residential zoning district. Historically, these 2 lots were occupied as residences. We researched the Department of Buildings and found a demo permit from well, we didn't actually find the permit, but in the docket book, it's listed as demo 618 of 69. The certified Sanborn maps that we submitted shows residences both on lot 16, 194 Moffett Street, is depicted as a dwelling and a shed from the 1900s up until the 1960s. The 194A Moffett Street, which is lot 17, is depicted as a dwelling and shed from the 1900s to the 1960s. Based on our research and what the buildings department, we believe that there was a fire, and so both of these homes were demolished. They were most likely row houses, like the type of homes that exist there, and they were both unfortunately demolished.
You didn't find any tax photos. You think it happened in the 60s, right?
Probably, because that's why that demo of 69 was, otherwise, if they were demolished for some other reason, they would have been developed as a factory. They wouldn't have lied vacant for so many decades. One of the lots was occupied from 1997 to 1998, according to environmental data resources, as Moroso Auto Clinic. That was only for 1 year. So these lots have been vacant for all these decades, and that in itself makes the history of the occupancy of these lots and prior residential development is unique. It's completely surrounded by residences across the street, all the adjacent properties.
Now, stay with
Yeah,
where you were going.
sure.
Stay with, why is it unique? Because it had these two existing houses?
Because now this site has to develop in an area which is completely developed with residences, has to comply with the zoning, the M11, and you'd have to construct a conforming building there, but the site is very small. The street is narrow. So a manufacturing building would require a certain floor plate, a certain width to permit trucks to pull in, permit forklifts. We referred this site for an extended period of time and the owner to real estate offices who looked at the possibilities of doing as of right. And it's just not conducive for that type of use. All the other comparable sites that have comparable or anything that has a conforming manufacturing use are much larger.
So maybe, so that I think was the question that was posed yesterday. So you said that a conforming use, like manufacturing, for example, wouldn't work because it's too small on a 32-foot wide lot. You need to give us more information about why it's too small. Why wouldn't it work?
Okay.
Right?
Sure.
I don't know what the answer is. But why
Trucks
wouldn't it work?
turning, loading and unloading, forklift.
So you need to do that with a plan to show us that and to explain to us why any of the conforming uses, so either like an office or a manufacturing, I don't know, about a doctor's office, something, well, it's the same, it's an office, right? Wouldn't function there.
So yeah, we'll be happy to, the suggestion about a commercial office building here, we'll be happy to do that analysis. We looked at that. Actually, within the entire 1,000-foot radius, within the M11 zone, there's one commercial building which we identified on the in the uniqueness study and the land use map, and I looked at that yesterday. It's listed, the C of O says eating and drinking establishment, but it's actually, if you go to Google Street View, it doesn't look like that. It's actually for rent. So I don't think that restaurant is existing anymore. So that one commercial building is actually not operating. I have that photo here. So we provided some letters from real estate brokers that marketed the site, and we can elaborate more on that, their efforts and what they did. They did look at different as-of-right uses, including artists, workspace, community facility.
I found that uniqueness study that you did a little on the confusing side, so it'd be great if you could clarify that by focusing on the 5 to 7 lots that are actually as narrow or narrower than the site's lot.
Right, so those 5, I'm sorry.
Because you're trying to say that some of them are in common ownership.
Yes.
So I see that it says tax lot, block 3, 4, 4, 7, 1, 23, and 24 are in common ownership. And then when you talk about what they're used for, you then say lot 3, 4, 4, 7, lot 1 is owned alone and is 22 feet wide and 43 feet in depth. You do the same thing for lots 8 and 10, 3, 4, 4, 8, lot 8 and 10. You say that's in common ownership. But then when you go into detail of the use, you say 3448 lot 8 is owned alone. I just found it confusing trying to get to
Okay.
who is actually comparable and then comparing that to the total number of lots in the industrial.
Okay, we'll clarify that. I think by eliminating the ones that are in common ownership and being used, I think we said that only 2 of those sites that we identified are comparable to our site, the same size as our site.
In that they're
But-
32 feet wide and not being used. Is that what you,
Well, they're developed with conforming uses, so they're,
because I have lot 3447, lot 1, block 3448, lot 8, block 3448, lot 10. Yeah, I think that you're saying stuff and then it seems to be, to me, getting muddled.
okay. We'll go through the analysis and we'll clarify it.
And there are 2 uniqueness study reports, so, and I think the data is different in both of them, so it would be helpful if you can consolidate. I think the earlier one had more detail, the second one has less, so you may want to consolidate and clean
Okay.
that out.
This is, sorry, I found the photo now. This is the one commercial building in the F1, which if you zoom in on Google Street View, there's a for rent sign. So it seems to be, I mean, I'll go to the area. I didn't have a chance yesterday.
I am looking at the Google Street
verify-
View, and I
yeah.
think there are 2 lots, and
There
they're
are
under
2
2.
lots.
There are 2 lots under 2 different ownership. The building does not have the sign, it's the vacant lot, which has the container and the trucks. That
Right.
is for sale.
That's for sale, but if you zoom in on that window where that ramp is of that 2-story
Oh,
building, there's a for rent sign in that window
yes,
on
I
the
do see
first
that.
floor.
Yes, I do.
Yeah.
Okay, thank you.
So the area itself is developed with 2- and 3-story with basement row houses for the most part. And as you get closer to Central Avenue, there are 4-story buildings. And then within the R6 zone, there's some more 4- and some 5-story buildings. What we're proposing, well, our current proposal is actually what would be permitted in an R6 zoning district. But we understand the concern of the board with respect to the proposed height, and we're willing to look at that and
That's great.
re-examine that, redesign. I know the vice chair had comment about the layout of the units could be better. We're willing to look at that.
Okay. So, of course, step 1 is, but I think you should be doing everything simultaneously, but step 1 is establishing that the building is unique. I mean, the site is unique. So one of only X number of vacant lots of this size or smaller, right? And then that the size of the site is posing the hardship. So the hardship can't be the letters from the real estate
Right.
agents that say I can't sell it or rent it or whatever. It's something specific about why it doesn't work for conforming uses.
Right.
Right?
Also inherent in the site, because there was an auto-related use on the lot at the time, during the soil investigation site for the environmental seeker review, soil contamination was identified. That's another physical, unique characteristic of this site, which requires remediation work.
It may not be unique if it's generally caused by some polluter off-site, right? So it would be different if it were caused by the use that had been on the site at some point. But if the use were residential up until the 60s, and then it was only used to, like,
For 1
park
year.
cars,
No, more than 1 year.
whatever, park cars for a year or something, probably the contamination is a
You know,
little bit of gasoline leaking or
Yeah,
oil leaks.
I have to say, for environmental review purposes, whenever you do phase one and they see site was used for parking, immediately they flag a phase two and require a lot of
Yes.
review. Doesn't mean it's going to amount to an exorbitant amount of remediation. It's just one of those standard protocol kind of process, and I would let, Tracy weigh in on that. That's what I've noticed with my experience with the EAS
Right,
documents.
they did follow through and they do have a rapid chest, if you want to review what remediation is required.
Right.
I see. So
But-
there is a
They
rapid.
reached that point.
But it doesn't mean that that's a unique condition, right?
No.
Well-
Unique conditions in terms of contamination are very specific, right?
But my understanding was it specifically pointed to this site and said that there were records that indicated, DEP, when they reviewed it, indicated that uses on this site show that this, a phase one is required, phase two, and then they identified this soil condition, and then subsequently we had to do the
Correct.
remediation action plan, and
Sure, but I would say out of all the sites that we get, 90% of them are required to do a phase one, phase two, a RAP, and a CHASP, right? It's because it's just the nature of the beast in New York. All of the sites, unfortunately, have some level of contamination, but the kinds of sites where the contamination rises to the level of kind of earning a variance, that's very rare, and it tends to be gas stations. And the reason for gas stations is because they unfortunately weren't properly regulated, and the contamination is often very extreme. So I wouldn't really rely on the remediation, which, by the way, you wouldn't have to do for an as-of-right project, because as-of-right, so the difference is, for a gas station, they're a spill site. They must clean up no matter whether they come to us for a variance or not. Whereas an as-of-right project doesn't have to do remediation as of right. It's your exposure to the city environmental quality review that all of a sudden draws DEP's attention to it and all of that. So you actually couldn't figure it into your as-of-right as a hardship cost. You know what I mean?
okay, I understand that, only that the owner was advised by the environmental consultant that he needs to, once he digs for foundations, he needs to take that soil out and bring in clean soil and dispose of that soil properly. So there is a cost.
But it's not a unique
Right.
cost. Everybody has it on their sites, right? And you also, no doubt, have a basement left over from the houses that were removed in the 60s.
Could be, yeah,
So if
foundations.
anything, the basement got filled with soil, and, you know, it's not the same as deeply contaminated soil that's going down deep into the subterranean levels, kind of thing. You know, they may have
Understood.
filled it with bad soil, for example.
So we're just making the point that cumulatively, all of these factors contribute to the uniqueness, and we brought up the point about the MTA because based on our experience, based on the owner's experience with other similar projects, we have to refer this to the MTA. The Department of Buildings also requires that. And we never attached a number to that. We're just saying that because this is a new development, even an as of right, we have to refer this to MTA. But we're not quantifying that. We did not include a number for that.
We're not saying that you don't need to go to MTA. We're saying that it might cost $200. That's all.
Okay. hope so, but in our experience, takes time and more. The point is, this is, any new construction in that area, because of the proximity, will require that. We were just making that
Any
point.
construction within 200 feet of the
Right.
of a TA structure
Yeah.
should be submitted to them
Right.
before start construction for
Mhm.
their review. So what you're gonna do is
Yes.
submit your drawings to them, they will look at it. I believe, my anticipation, based on my experience interacting with them, if you're that far, it's gonna be just a submission. You will pay the fee to the TA, and you will get no impact letter, most likely, which goes $200 again, so it's. But we didn't say that you don't need to go.
Okay.
So to help out your argument, once to determine the size of the building, I'd really recommend you get a copy of the Brooklyn tax photo from the 1940s, where the buildings are standing there with stoops. They're actually a little bit taller than the neighbors, just a little bit. They're more like a townhouse style, whereas
Okay.
the neighbors are row house style. So anyway, you've got two really nice buildings to go by in terms of, so I just found this tax photo. It takes a little time. You go to the Brooklyn 1940s tax photo.
Okay.
Yeah, and you can get a copy of it. And then I'd really recommend that you give Carlo a call about this subject, and he'll know what to talk about, okay? Okay. Good.
Okay.
Are there any speakers on this? Yes? Well, right, no, I mean of the public, obviously you're gonna keep up
Yeah,
your show.
there's
Okay.
more here. So, firm map, I believe we submitted it, but I have one here. We'll submit it again. Regarding ADA accessibility and elevator, the building, the units on the first floor are fully ADA accessible. All the corridors and the building is ADA accessible. We provided, besides the building department bulletin, we provided a letter from the architect certifying that all doorways, exits, and corridors of the proposed building, that's the currently proposed building, as shown on the proposed plans, meet the New York City Fire Code, New York City Building Code, and ADA accessibility requirements. All of the first floor apartments are fully ADA compliant.
So, I'm sorry, I just want to just go cut to the chase on that one. I don't know that the building that, if the board makes the A and B finding, that the board would consider a building that ultimately needs an elevator anymore, because you need to fit in with the character of this neighborhood, and this does not. But I just want to say that I don't agree with creating more housing where a person can't break an ankle and still live in the building, right? So, or age in place or any of those things. So I just think it's bad policy to try to make excuses for not having an elevator, but in addition to which, I think it's a misreading of the building code, because there's more requirements than just whether or not the height of the building regulates. There's also Fair Housing Act and other things that require accessibility. So,
Okay.
But I think it's premature to talk about it, because I think the building may end up being 2 or 3 stories tall, in which case we're not talking about an elevator building.
Right, so 25 to 30% of these units that we're proposing are affordable units, and what else was there?
That's not even reflected.
Right.
Regarding the mismatch between the statement of facts and the plans, there are amenities which we're required to provide for the quality housing, but again, we'll take a look at that, because we're looking at submitting an alternate proposed condition, but it's not reflected in the plans, but there are amenities, laundry room and
No, before you said that, you were
units.
talking about affordable units. As far as we can tell, there are no affordable units in the building. None of your financials have a mention about affordable units. And if you were actually providing affordable units, that would be a requirement of the grant, and I'm not sure that your owner would want to do that in such a small building. So maybe they would, but, you know.
Okay.
And with regards to your statement about amenities being provided, what is stated in the statement of fact and in the plan do not match.
Right, that's the point I was making. The plans will be updated to show that, because those are required amenities. Laundry room, compact room,
Well, you had a lot of other things.
We do have an open recreation area in the back that's shown on the site plan.
So you're saying that it qualifies, in other words, meets the quality housing criteria. So
Yes.
let's just, for argument's sake, say the building was of a scale that quality housing is even relevant. It may not get to be of that scale. So if it were relevant, you need to go through the checklist of all of the quality housing issues if you want to be able to use the deductions. If you don't, then the ask is whatever the ask is, right? But I don't frankly think you're going to be.
I don't think you will get to quality housing, because if the scale of the building is going to be reduced,
Yeah,
meeting the quality housing requirement is not going to get you anywhere.
right.
Okay.
That doesn't mean that you shouldn't provide these amenities if that helps your marketing.
If you have, I can have Barbara come address the issues with regarding costs and financial.
Barbara Cohen, real estate and planning consultant. The sound on the video was really hard, so I think I picked out a few items that you had concerns about. The site value.
Oh, it's tech error, because there's no way that you
Oh,
can
no, not that
hear-
you guys
yeah.
mumbled or anything. No, all your diction and projection is perfectly fine. My father would be proud as a theater professor. But anyway, since the report, is a little dated from 2016, I think you were looking for maybe some updated comps on the site value. Is that?
Well, yeah,
Or that was
usually
one?
when sites are so far flung
Mm-hmm.
and old, I get a narrative that says this is because vacant land is so scarce,
Okay.
that kind of stuff.
All right, I'll take a
So, but
look
I
at where.
didn't see that, which led me to believe, do you have anything more recent?
Okay, I'll review that. Okay.
Your error, your two-bedroom.
Yeah,
right?
I saw that. The two bedrooms correct. On page 30, the paragraph is the same as the one above in the same building, so copying, pasting should be done carefully.
The big one is the construction costs for the as-of-right.
Yeah, I
That's
also-
the biggest comment.
Yeah, and I because there were, I guess, 2 or 3 versions of the report, you had mentioned the cap rate at 6.3, and it actually, the most recent report, it was down to 6. Construction costs, I'll reach out to the cost estimator to go through the as-of-right to see where it, comes out to be what you believe is higher than, I guess, what
In
you've
addition-
seen.
Almost double. Try looking at Marshall
319,
and Swift for your guide. This is a simple one-story industrial
Yeah,
building.
no, I understand.
Yeah, right.
I
You're at $400 a square foot.
No,
all cost
390.
in, and he
Three-
got even higher
Wait,
than that.
wait. When we're talking construction costs, we're always talking the basic construction, and I believe it was 319.
319.
Right,
So then
right,
if you
that's
add
all.
the soft costs, because we had this conversation before, use Marshall and Swift as your guide, because Marshall and Swift includes a lot of the soft costs.
Right,
So-
but we're using an independent cost estimator, so I'm
Yeah,
just saying
and he's
that.
driving your
you know,
costs up to such an extent that
Well, we
I'm
wanna
not
see.
convinced by them.
Yeah,
So,
no,
That's why
that's why I
we are
use
using it.
Marshall and Swift as your guide and bring it down.
Wait a
It's
minute,
a
are we throwing the
simple-
guy out and we're going back to Marshall and
No,
Swift,
not
or we're
even that.
just?
No, we're not
Okay,
throwing him out.
okay, I
We're just saying that
okay.
when somebody brings construction costs that are so much higher than the norm for the building typology, that leads me to say, go back it up with Marshall and Swift.
No, I
because that's
understand.
more reasonable. So I'm not saying throw your guy out.
Okay, 'cause
I'm just saying, bring it down.
Okay, no, I understand, and I had looked back to other cases and where things, was the high 200s or 250, 60,
And-
whatever
and
it was.
same goes
And
for
so
the proposed
319 seemed a little high, and so what I'm just saying is, yes, I will reach out and see if, either mistake or something's not right.
And your
So,
as of right two is at $200 a square foot. So that's a community facility building. It's like nicely built out in comparison to an industrial, one-story industrial warehouse building.
Well,
You gonna put in finished floors and everything here?
It's gonna be real
I-
nice.
HVAC, central air, what is gonna be in here? This is
well,
supposed to
this
be
is what I would
like
go back, well, look,
like that.
I take what I'm given, and then I'm gonna go back and we'll go through it and see if, things add up and
Okay,
why,
well,
and explain.
those
So,
are my
yes.
comments.
Yeah,
and,
okay.
I think you had.
Yeah, the construction cost is
Yeah,
is
yeah. No, I
messed
got
up
that.
as of right and proposed, both.
Gotcha.
He's using underpinning, he's using concrete cubic yardage for a plain concrete slab that costs peanuts. He's using it at almost $600 a cubic yard. I don't know why. Underpinning, why do we need underpinning? Just, you can
Well, these
raise
are
the finished floor for the first floor slab, like the two buildings to the right and left, and then make the cellar shallower, and then you don't need any underpinning.
Can I ask a question also? Because if we look at these tax photos from the 1940s, there were two townhouses on this site. And like townhouses were almost always built with cellars, so it means that there's already a cellar filled in on this site probably, right?
Yeah, but most
So-
likely he's assuming that the previous construction was as deep as the adjacent buildings.
Yeah, yeah.
But the proposed goes down to about 10 feet below grade.
Oh, I see.
Yeah,
The
'cause it
difference
says,
between the 10
duplex
feet
there.
and the existing two houses is gonna be underpinned. So what I'm saying is, why you go 10 feet deep? Just go 6 feet deep. Match the foundation level for the two buildings to the right and left, and then elevate the first floor slab, make it match the two buildings. And then you get rid of the underpinning.
Neighbors were built.
Take a look at the cost for the excavation, take a look at the cost for the concrete. It's, I don't wanna like go over item by item,
No, I understand.
but I'm 2 years here now. They should have known that it doesn't fly.
Yeah, no, look, I will go back and have him review, listen to the
I'm not gonna
video,
shoot the
listen to
messenger.
your No, I understand, and I'm not, I can only talk construction to an extent, so, that's why it's good, everything's on tape, so he can listen, and I can understand further to also on the next go-round, if I can say, hey, too high, what's going on? What are you
It's gonna be
assuming?
one next, please. One next, go around it, please, not 10.
Oh, no, yeah, this is
Yeah,
pretty
just one,
simple.
right.
Yeah.
He's begging you.
No, look, I don't want to do it the fifth time either.
Right.
What
you know.
happens is, you
It's
give
fine.
him the comments, and then next submission comes identical to what
No.
you got before.
No,
No,
Ms.
no, I
Cohen
think
won't
we-
let that happen because we know she won't let that happen.
No, I think I'm doing it also.
Thank you.
Repeatedly to,
Right, okay.
less anxiety and, more progress. Okay. Did I catch all the little pieces?
Yeah,
Yeah.
I made the cap rate comment
really
in
nice.
reference to the minimal variance in bringing it down, bringing the height and the bulk of the building down. Saying that you could do with the lower cap rate, this is a wholly residential property.
Right. Oh, I see what you're
Yeah,
saying.
that's
All
was
right,
my
if it
comment. So I
justifies
did-
it, yeah, I mean, look at the.
And I just
the
want to make
quality.
it clear, before you touch anything on site, you need to go to, because we discussed this, you need to go to the TA and tell them what you're gonna do. So I'm not telling you not to go to the TA, just to make it clear.
Yeah, no, that was clear. It was just, that it's an added step. That's it, so I got it
Great,
all?
thank you, yes. Okay.
Submission date? So what happens is he'll give you a date for a submission, and then you put a hearing date, and then if we don't close it, it's a continued hearing. So that's a decision, that's granted, continued.
Sorry.
They're playing prices right rules. They're playing prices right rules, right?
We figure a end of February submission.
Oh, that works, perfect. So glad you said that. Okay.
Submission February 26th for a continued hearing March 17th.
Is that okay with you?
Okay, item number
Thank you.
5, 2018, 192BZ, 229 Lenox Avenue, Manhattan. Only you, Frank? Okay.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to board member questions?
Oh, I see. Oh.
Those are the neighbors. That's the immediate neighbor. I don't actually know which one's he.
Give us submission.
They're so good. Yeah. I can understand why these and these guys have awnings of the same photographing day. Very cool.
Steve, Richard.
We should do those again. Awnings.
These haven't actually been submitted yet. I just want to show that LPC, as of yesterday, did approve of our proposed application.
Frank, did you get fire department letter?
I did, and I will address that as well. I think we should be able
You have to state your name before you
All
speak.
right.
Sorry.
My name is Frank
Sorry
Noriega
about
from
that.
Sheldon Nobel on behalf of the applicant, and yes, I did receive the fire department letter, and I will be addressing that. So we did listen and we heard the board's comments from yesterday, and I think in order to address them, I think it would be best to just kind of chronologically go through this.
Sorry, are these all the same?
They're all the same, it's just for comments for everybody. So this building, its existing bulk and its footprint have been existing since the 1950s. This was a church, which again, prior to 1961, was then later issued a CO to establish that there wasn't an apartment on the top level, which was the Reverend's apartment, which then led to the legalization, or not legalization, the conversion to a Class A apartment, which is what is currently existing, with the third, second, and first floors being non-residential. Now, in 2014, the applicant actually filed an application with the DOB to alter this building to what is being proposed, and they believe this change was as of right. And actually went through the process, have gone through many plan exams, and were nearly complete until the issue came when they were looking at light and air, that the issue came up with the waiver we're requesting, which has to do with 23-861. It's not a yard waiver, it's not an open space waiver. It specifically has to do with legally required windows and their distance from the rear lot line. So this building, regardless whether it's commercial, community facility, residential, in theory, the bulk of the building is complying. It's the moment that we introduce these spaces, such as the kitchen and the living room on the first floor, that they're supposed to be 30 feet away when you measure it from the windowsill.
No, not the kitchen.
The kitchen is a habitable space. Kitchenettes, which are 80 feet or less, do not need light and air, but full-size kitchens, and if you look at the plans, it's really a kitchen and dining area, so about 700 square feet. It's
Dining
huge.
area is not a sleeping room.
Habitable room, requiring light and air. Pretty much anything that's not exempt, which are bathrooms, kitchenettes, storage.
If
But-
it was called a study, you wouldn't need sleeping.
I think DOB would disagree with you, but if that was the case, and if you're willing to opine on that and say that it's not a living room, I think DOB would accept that. But our understanding and what DOB has reviewed, that this is a habitable space that requires light and air. Therefore, these windows are now legally required, and that's why we need this waiver. So what we're asking to waive essentially is not to alter the building, at least envelope-wise, at all. And the as-of-right plans, it's actually really easy to miss the change. The as-of-right plans is actually for a bigger building. It actually enlarges the third floor terrace and creates angled skylights, which then are no longer pointed at the rear lot line. We also submitted a CCD1
How
to.
can you enlarge the third floor terrace as of right?
Because, again, sorry, let me jump back. There are no yard requirements for this building because they're within 100 feet of a corner and also on the short dimension of a block. So within 100 feet of that frontage, they do not need a rear yard. This building is entirely within that area. They do not need rear yards. Similarly, they can have 100% lot coverage. The correct cited, on the BSA analysis form does have the correct citations for those zoning sections and why that's permitted. So they can, as of right, go all the way to the lot line if they wanted to. The question is, again, these legally required windows and which way they face. The CCD1 that was submitted.
Wait, sorry, you said it's the correct citation for lot coverage. It's not a corner lot.
Correct, it is not a corner lot.
So
But it
how-
is within 100 feet of a corner. and
Yes,
there-
that means you don't need a rear yard.
Correct. There's
Why do
also
you-
a similar provision, basically the same thing, 100 feet for a corner, and I can give you the citation as well, that has to do with lot coverage. It's a different section, but it effectively does the same thing, where within 100 feet of a corner or on a short dimension of a block, you can have 100% lot coverage as well. But as a practical matter, you can see how you can run into problems because you still need light and air issues, which require 30 feet. Sorry. Correct citation is. But also, as noted, so we did do a CCD1 to try to correct this, and, oh, sorry, the lot coverage provision is 23-156. I believe there's an A and B. One has to do within 100 feet of a corner, one has to do with on the short dimension of a block. We did submit a CCD1, or I shouldn't say I did, the applicant submitted a CCD1 to confirm that this proposed idea of essentially enlarging the third floor terrace with this glass enclosure and creating these skylights, not only to provide light and air for the third floor, but also cutting back the terrace and creating a skylight to give light and air to this double height space that is the first and second floor, would be compliant.
Wait a minute, you're saying you're a shallow interior lot?
Yeah, how are you a shallow?
It's not, I believe there's, are you going to the right section? There's,
Yeah.
Because you're telling us
I'm
to go.
looking at 23-156, which is special lot coverage provision for certain interior through lots, and it says, in the district indicated, which is R6, R7, R8, R9, R10, the maximum lot coverage set forth in section 23-152, which is for quality housing building, may be increased for shallow zoning lots in accordance with paragraph A of this section, and may be increased for interior or through lots within 100 feet of corners or located within a short dimension
That's
of
what
the
he's
block.
going with.
Yes.
Okay.
So you're going with
100 feet
or
of a
located
corner.
along short
Actually,
dimension
yeah.
of the block.
sorry, we meet both 1 or 2. You can apply either the corner or along the short dimension of a
So
block.
it's the B. Within 100 feet of corner along short dimension of the block, the maximum lot coverage for interior, or in this case, it's interior, within 100 feet of the corner located on the short dimension of the block may be increased as follows, within 100 feet of the corner.
Okay.
Okay.
So again, the massing in theory could go all the way to the lot line, but we have to deal with this issue having solely to do with the legally required windows. The proposed, as of right, was to essentially create like a glass enclosure, like greenhouse, I think is what they called it. It's not truly a greenhouse, but that's what it's labeled as on the plans. To create skylights, effectively. It is not desirable. It gets rid of the terrace and open space. It's costly. It is not what the applicant wants. And certainly, I think the chair mentioned this, that the LPC would have to approve it, and they didn't get a full review of it, but our initial reaction from them, because it's changing the rear facade that is visible from the street, that is likely not something that they would approve of.
I'm having a little trouble with that because you're saying it's visible from the street because you can see it from the schoolyard
Correct.
through the street. But the rear yard was significantly, the rear wall is proposed to be significantly modified in your proposal.
The wall is remaining where it is. It's just that the exterior openings are being enlarged.
You're removing basically the entire wall at those 2 levels in order to create a 17-foot high floor, door.
Correct, and that actually, I mean, in theory, we could do both. But those windows, arguably, and Mr. Daly, I was going to have to talk about the exterior wall openings, but our understanding is the exterior wall opening itself is as of right, and the LPC has confirmed that they are okay with those windows and the way that they have been designed, but they haven't reviewed this new glass enclosure that would be proposed on top of that and potentially in addition to.
Right, but your presumption that LPC wouldn't approve it is simply that, right?
The presumption, correct, it is a presumption.
You don't
We don't
know that they wouldn't approve it, so I don't think it's appropriate for you to say they wouldn't because you didn't ask them.
Fair enough.
And if they're allowing you to create those double height windows that essentially eliminate, it eliminates the rear wall of the building for those 2 floors, then it means they're open to changes on the exterior of the building that are visible from some distance from the street, right? So, plus you're changing all the openings, it looks like, right?
There wasn't really many openings on the first floor to begin with.
How about on the upper floor?
The upper floor, I believe it's only
They're not changing the
the only issue is the third floor, which is also legal light and air, which also is not as of right.
But you have a balcony on the third floor.
Correct.
Mm-hmm. So in terms of the dimensions of windows on the third and on the fourth floor is the same.
I'm not sure I'm following you with that one.
In terms of the openings that you have on the proposed for both third and the fourth floor, is it the same as the existing?
That I'm not sure.
I'm just
to be honest,
comparing-
I didn't look at the fourth floor because it's not part of the ask, but my understanding is, I mean.
I think the point is that you're not looking at an original fabric on the rear of the building, which is why the statement that you made, I have a lot of trouble with, so I want you to back off of that.
Then I will back off that.
Okay, so I guess the main question is, which is so odd about these applications, right? What's odd about them is Department of Buildings, I think incorrectly, assumes that as soon as you have an existing building and you switch from one section in the zoning resolution to another section in the zoning resolution, you now are in a non-compliant condition when arguably the non-compliant condition predated the zoning resolution. So if I were to look at the Sanborn map, at the very least, the incursion into the yard that gets you to 20-something feet existed always. And the 11-foot extra incursion existed since almost always.
1951.
Yeah, so, and whether it was 2 stories or 1, I don't know, it's really hard to tell from that. But that's the part that's peculiar about these applications. But nonetheless, we're looking at, what's the hardship, right? Why can't you just fix this by sliding the windows back to give your living room space the 30 feet?
So I think what you just mentioned, so the first floor is about 11 feet 9 inches. We would have to chop off just under 20 feet of the building.
No, that's not what I said. I said sliding the windows back.
And then having a vacant space.
It's not a vacant space called a rear yard, right, effectively, so the reason that I'm saying that is because on a lot of loft projects that I've worked on, DOB accepts moving the rear wall back without cutting, moving the rear glazing back without removing the building.
So you end up having like
You
an
just end
enclosed
up having
patio?
like a terrace.
A larger terrace.
It's just a larger terrace, that's all. As if you've got balconies above. So it's effectively the same thing as having a balcony above. So that's why I ask, why is this such a hardship? There's a cheap way, in other words, you're already changing the windows. Why not change the windows in a different place?
I'm not sure that we've looked at that option. I don't think that's how DOB interprets it. But again, we haven't looked at this option. My understanding is you're creating effectively a room that you're ventilating through or some sort of open terrace.
No, it's open.
Oh,
It's open.
Okay. So, but
So
even
you're
still.
sliding the window wall that you're putting in back to comply with the, whatever the rear yard requirement is.
So you're saying we
right?
should have 20 feet of open space? But, I mean, I guess the hardship is you're then losing out on 400 square feet of property.
Well, but that's not a hardship. You have now a nice backyard. Like, how is that a hardship? It's a 6,000 something or other square foot house. How is that a hardship? Right?
I think it's more, again, it's more costly, and as of right options.
No. We
we're look-
don't know that it's more costly. That's my point is, you're already removing a large portion of the rear wall, right? And you're already installing brand-new, super expensive doors because they're 17 feet high, right? Why can't you just locate those doors back?
I don't think it's as simple as that. For example,
don't
just off the top of my head, there's a sprinkler system. This building is fully sprinklered to those windows. So pulling back 20 feet means we have to redo all the plumbing and whatnot with that. It's not a simple matter of just moving the doors. Not only that, but in comparison to the as-of-right option.
But isn't it just cutting the sprinkler pipe?
Yes,
Yeah,
capping them.
But
Yeah.
that's just one example. But
So in other words, I don't think you should be answering these questions on the fly because you don't actually know, but those are the questions that should be responded to.
we can address them certainly and look at that option. Again, we did not look at this option of moving the door. But I think comparing what we are proposing as of right, which doesn't move the doors, just creates the greenhouse space with the skylights to what we're asking for, is we're asking you to look at that difference because.
But I'm saying, you're saying that putting those skylights in would be costly. And I'm saying, well, then don't do the costly one, do the cheaper one, which is moving the walls back, the doors back, right?
I will certainly have to run that by the applicant to see if that is a possibility. We will certainly get back to you on that. Regarding the exterior openings, and I'm sure we're more than happy to work with the fire department on this if they feel differently. But because this has gone through an extensive plan review, one of the issues was whether or not the amount of exterior wall openings was compliant. And we did submit another AI1 on this issue, and they felt that it was compliant because of the occupancy classification of the building, specifically because this is going to be a R3 occupancy, a single-family home, at least under the 2014 building code. The restrictions are much more lenient than it would be for an R2 or pretty much any other building occupancy. That is a very technical document. I have copies of it, but we will definitely submit a copy. Mr. Daly has a copy as well. Certainly, I'm not expecting a response from him today, but we're definitely willing to work with the FDNY if they have any questions.
All right. Mr. Daly, Chief Daly, you want to?
Good afternoon, John Daly. Yes, I did receive the plans, and I appreciate that help. I had reviewed these plans with members of the fire department, fire officers, captains, and battalion chiefs. Unfortunately, New York City has a bad history of fires in single and two-family homes, multiple dwellings. They see this building as a single-family dwelling. One, they're jealous. But because it's a single-family dwelling, and with the large opening, the glass opening at the rear of the building, they're afraid that in the event of a fire, the glass, of course, will shatter and spread to adjoining property. There is an existing sprinkler system designed for the community facility, so it's really a basic commercial system. All we're asking maybe is two heads to be extended, tapped into the existing sprinkler line, to be extended closer to the window to protect that opening.
That's an opening protective. It's a
That's
standard requirement in the building code.
Right, like a lot line windows?
Yes.
It's similar. Now, we also have concerns. Now, the elevator is existing in this building?
Yes.
Yeah, okay. So, and it was existing when it was a community facility. So we have a concern. So community facility, elevators in a community facility are required to have elevator recall. In a residential building, they are not required. And I need to visit and also need the assistance of Mr. Ricketts, your compliance officer, and of course one of my suppression inspectors to visit the site, which I'll coordinate with Mr. LaBelle's office. There's one, the elevator recall has to be removed to the elevator. And the second thing is there is a booster pump that was installed and signed off a few years ago. We need to verify that that booster pump serves only domestic water. If it also serves the sprinkler system, we need a fire alarm system. I think we had a case last year on East 69th Street where they disconnected the central office connection as the sprinkler was connected to the booster pump. So I do need to visit the site and comment more on this application. Thank you.
Okay, great, thanks. See, so if you move the doors back, you'd be
Then we won't
closer
need-
to the sprinkler system that you would have to modify, and you'd probably move it right back up against one of the sprinkler heads, and then you'd be almost there.
I'm not sure the applicant will be going for that, but I will certainly run it by them as an option.
Okay.
That being said, I think they would like to move forward with this as quickly as possible if
Okay, well.
we can get an earlier.
So are there speakers on this? Okay, what about the community board
Oh.
recommendation?
I can speak on that as well. So, community board,
I forwarded you.
sorry.
I don't know, didn't see it. What did it say?
Sorry, now I gotta look.
So I'll also talk on the objection if you want to. The objection was issued on October 30th. We filed November 29th, just within the 30 days.
Yeah, we're good.
In January, we met with the land use committee of the community board. And as far as we know, that they were in favor of this, but we needed to meet with the full board. But prior to meeting with the full board, we needed to do two things. One was to meet with the Morris Park Association and get their approval, which we did. We met with them in February, got their approval, submitted that letter. And the applicant team, not our office, needed to meet with the landmarks committee of the community board, which they did in February as well. Since February, we have reached out to the community board many times, both before and after their summer recess. And for some reason, we haven't gotten a response to meet with the full board. We did, and it's definitely been more than 60 days for them to give comment.
Okay. So we're gonna reach out and,
I did reach out yesterday, I'm just trying to see.
oh, is that the one they did send a resolution, right?
It was an email, right? That was the email yesterday?
There might be the next case of mine.
Oh.
The district manager did.
Maybe that's the one.
It was the minutes, but
Okay.
not the resolution.
Yeah, okay,
I'm sorry, yeah.
okay.
I did reach out to both of those, but
Right,
I think I only got the one for the next one.
okay. And with respect to this, again, I really recommend that you look at the language in section 54-31 and give Mr. Costanza a call after you've done so.
Okay. I will definitely, but to the best of my knowledge, there are no non-compliances or non-conformances with this building, both proposed or existing or proposed.
But I thought it's not complying.
No, there's no non-compliance. That's why, the only non-compliance is the change of, once the introduction of the habitable space. That's what's triggering it.
No, but wasn't the building built as a residential building?
No, it was built as a community facility building and then later converted in the 50s to a church with one unit at the fourth floor. That's the only residential portion. And that's why we're not bringing up the fourth
It
floor.
was built in the 19th century as a community facility building?
Well, what is currently now a community facility is a church in the 1950s.
No, my question is, what was it built as? It was probably built as a residence, not as a community
It was
facility.
I have to look at the
Queen Anne
LPC
style
report.
townhouse.
It was some sort of community house. Let me see if I have the actual, but it was not a residential.
So so I don't know whether the landmarks designation report doesn't go building by building the way it normally does in these historic districts.
Well, this is a contributing building to the district, so they
I
need to mention.
understand, but normally a historic district report goes building by building ultimately, and it doesn't have any history about the use of the building, but I'm sure at landmarks you could find out what the original use of the building is. That's the question that's raised by 5431, right? Because if the building was converted to a community facility, but originally built for residential use, that's always the critical question, right?
I would be very receptive to hearing any comments on that. I'll definitely reach out to
So
Carla.
what I'd recommend before you make the second phone call is to call Landmarks and see if they have any data on the history of the building that's just not showing up in their designation report. Okay.
Absolutely. All right, thank you for the advice.
Okay.
It says it was, there was an article, I found this article, it's called Savini Hall.
Does it say?
Daytonia in Manhattan, it said extension of the elevated railroad in 1872, the area around Mount Morris Parks or rapid development. Their regiment uniformly broken when number 229 Lennox made its appearance at the Century due to a close. In contrast to the highly vertical proportions of its older neighbors, the three-storied attic home with its bowed front had a portly appearance. The seemingly squat personality design was added to by the low stoop and the oversized dormers protruding from the steep mansard roof. The peculiar house would have a rocky beginning. In 1902 was lost to foreclosure. It was purchased by someone else and resold and was sold for about $771 today.
But it's described as a house is the point.
Yeah, and then it says coming and goings, 4-story.
Okay, no, it just doesn't.
So according to Sanborn map, as of 1912 or 21, it was what you call a Savini Hall.
Right, but this is a much earlier building than 1912. The point is, it would be quite interesting to talk about it if it was built as a house, let's just say.
I like that
Okay?
idea.
Okay. All right,
Social
time.
too. Says it was a social.
Yeah.
Interesting.
All right, submission February 12th for a continued hearing March 3rd.
Thank you very much.
Thank you.
Item number 6, 2019-48BZ. Raise your right hand. Swear me.
You affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions.
Good evening. My name is Frank Noriega from Sheldon Bell on behalf of the applicant. The applicant is actually here with me, as well as his architect, George Fontan. If there are any questions that need to be directed directly to them, they are here and available to speak. We did hear the comments from the board, and most of them, unfortunately, we couldn't provide the backup documentation in time for this. But in particular, the area study of the uniqueness of this narrow lot and how it relates to the buildings in the area. I asked for a map to visually represent exactly what was stated in the statement of facts. Our consultant actually came back with a different number, but it was 38 buildings on these narrow lots. Similarly, none had side yards, and also did a study within 1,000 feet. That number increased to 260 of these buildings on narrow lots. 2 of them had side yards, but of those 2, they only had 2-foot side yards. They did not have a full 8-foot side yard. As far as looking at other options, as far as of right, the peculiar issue with this building is it's almost built entirely in the rear yard. So any vertical enlargement would be increasing the degree of non-conformance, compliance rather. So that cannot be done. And you run into the same issues with a horizontal enlargement that we are running into now. You still have side yard issues that you can't comply with. Furthermore, you have an issue, because there is a building that extends the entire length of the lot, you actually create non-compliant court conditions if you go any deeper than 8 feet. Essentially, if you create an 8-foot wide side yard to comply, the depth of that court is, or the width of that court is only 8 feet wide. So in order to maintain the natural light and air to the building behind it, you can only have an 8-foot deep building in front of it, which is, again, not compliant. We didn't even consider it, and that's why we didn't present plans as a possibility.
Sorry, why, you're saying you're creating a court because you'd have this little skinny thing and then it's not a full side yard?
Correct.
It's like an L-shaped something?
Correct. That's the only way to enlarge it, and it's just not feasible.
Okay.
We did amend the plans. They haven't been submitted. I do have copies illustrating the issue regarding the calculation for the abutting portion. There does have to abut believe it's 50%. This is a 70-foot long existing building that it needs to abut. It needs to abut by at least 35 feet. I believe it's 45 feet abutting, so it does comply. We can submit that, certainly. I know there was a question about floor area and the deduction of 100 feet. This actually comes from the definition of floor area, particularly the section that talks about what isn't floor area. In many cases, parking is reduced by 300 square feet per spot. However, in attached buildings such as this in R5 districts, that same section talks about it, it's only 100 square feet. And that's where that 100 square foot deduction
And
comes from.
you have the garage, actually?
Correct, it's
Yeah.
built into the building. There's 2 parking spaces. There's actually one in the garage and one immediately in front of it, which is our understanding is compliant in this particular circumstance.
Okay, so you're saying you get the deduction because you're putting a garage in the building, and it's for sure that the language is the garage can be in the building as opposed to an accessory building?
Well, I'll double check that, but the language is, in the definition, it's item 6, Roman numeral 2, if you want to scroll to it. But it is there, and our understanding is, yes, that it is, as long as it's an enclosed building, it's 100 square feet that can be deducted. So I think, and again, this is something that was updated in the plans that haven't been submitted yet, but we've clearly labeled what is the difference between the proposed, existing, and as of right. The as of right plans with an 8-foot side yard creates a building that is just really not habitable. It's 13 feet wide. When you take into the width of the exterior walls, it really doesn't leave any room for a hallway and allow to orient the rooms around it that makes a feasible building. As far as, there was a question regarding whether or not this could be a semi-detached home. Just as a matter of definition, it can't. There's no way to make this a semi-detached home. A semi-detached home, by definition, has to abut another semi-detached home, and there isn't one on either side. So it either has to be a detached home, which would require 13 feet of yards, which, again, we didn't look at because that would create an even more absurd result of, quick doing math, 8-foot wide building, which is not feasible. 0 lot line building, which has the same issue. Or actually, I take it back. 0 lot lines, there are no regulations for an R5 district. Or an abutting building, or the general requirement that all other types of buildings fall into this other category, which provide 2 8-foot yards, unless they comply with the section that we are proposing to waive, which means they can either abut an adjoining attached building, and if there's no attached building on one side, they have to provide an 8-foot yard, which is what we're trying not to comply with because it leads to a building that is not really practical.
But you are abutting an
Correct.
adjacent building,
Correct.
right?
On one side.
And in order to qualify for not having, to be allowed to do that, you have to show that you're abutting by X distance, right?
Correct.
So that's, the drawing that's missing is showing the X distance.
Correct. And if I may, I have a copy of the plans that have been updated. I haven't submitted these
okay.
yet, but that calculation is on here.
Oh, good. So you did add the adjacent properties so that we can see that the building is abutting by an amount, but we don't know what the amount is because it's not dimensioned.
I'm sorry, what would, I believe it's the whole length of the building?
No, so isn't the X amount of abutting a calculation? So the north side of the proposed building may abut in the existing building on the neighbor lot as of right. Neighboring building abuts its full length of 70 feet? No, it doesn't. So that proposed building abuts its full length of 46 feet. I thought there's a percentage, that's what, sorry, you want.
No, it's
we can
okay,
pass this down.
I'm good, I was just watching.
Sorry,
So,
maybe I'm gonna,
you need to, I know you did this really quickly, but there's a provision in the zoning that says you need to abut by a percentage of the total length of the abutting building, the adjoining building next door,
So,
right?
can I read it?
Yeah.
23-49A is what we are looking at, right?
Yeah.
Abuts an existing building located along a side lot line where such building was existing on December 15, 1961, or lawfully erected under the terms of this resolution, provided that walls of the building containing residences and walls of the existing building shall abut for a length equal to or greater than 1/2 of the distance between the street wall line and the rear wall line of the existing building. For the purpose of this paragraph A, an existing building shall not include an accessory building located in an interior through lot. And B is about other buildings containing residents being erected at the same time on, that's not
Doesn't
relevant.
qualify. Okay, so you need to show that it's meeting that requirement on the drawing to do the math,
Just
okay?
to do the math really quickly, so it's a 70-foot long building adjacent, which is showed street wall to the rear, and our building is 46 feet long, so it's more than 35. But yes, we can include that calculation that it's more than 50%.
Yeah.
I would comment though.
Just state your name, please.
Oh, George Fontan. I'm an architect, Fontan Architecture. I believe the deputy commissioner in Queens has a different interpretation of that based on a conversation I've had with him. That
A different interpretation of what it says?
that the building, it's no, that the I'm sorry. Can I clear?
Yeah.
That the 50% is in reference to for a building to qualify for this abutting, the building itself has to abut, but it's not necessarily the relationship. Either way, by your interpretation, we're in compliance, but the 70-foot long building is abutting 70 feet. If the 70-foot long building was abutting 34 feet, the code would not apply. That's based on conversation with Deputy Commissioner Ho that I've had.
Wait a minute.
But either
How-
way, we are in compliance.
I don't get it. How does this 70-foot building abut 70 feet when your building is only 46 feet?
Either way, we comply, but I'm just saying, based on the conversation, Mr. Ho, for the building, for this code section to apply, the building, the neighboring building has to be abutting for 50% of its length,
Okay,
independently of the relationship. But either way, we.
okay.
Let me see if I can rephrase this, and George can correct me if I'm wrong. When he's talking about the adjoining building, it has to abut the lot line.
That's.
Yes, obviously,
Yeah.
yes.
So you can't have a building that touches the lot line for 5 feet and sets away into
Right.
the court.
Yes,
Yeah.
understood.
That's Commissioner Ho's interpretation.
Well, but it's also, it couldn't be that, oh, I see,
Yeah.
Ho just says it only has to abut the lot line and not the building
It has to
itself?
abut the lot line, a minimum of 50%
Well, that-
to qualify for this exemption.
Okay, but according to that, your
We still did.
existing little back building is abutting this existing building, which isn't true, right?
Well,
I mean, your little back building, I
Is
don't know.
abutting the lot line, but it's
abuts
not
the
abutting
lot
the
line,
building.
right? It doesn't abut the buildings, that sort of makes no
It
sense.
works
Because
for
the
both,
goal
right?
is to have like semi-attached buildings, or attached buildings, depending on how you
no,
look at it, right?
we're not sure we agree with it, but in either case, we comply either way.
Okay,
which is-
good. So just show how you
Absolutely.
comply on that. Okay, good.
Now, I think the only other question, and I'll go through my notes. The big question that we couldn't answer immediately, and I'm hoping that with the submission of these maps showing both the narrowness of the lot visually, what was in the statement of facts, is also showing what, within 1,000 feet, the same circumstances, also showing that all of these narrow lots do not provide side yards, that we do have a unique condition with this site, and that this shouldn't be a problem to allow for a reduced yard requirement, in this case, abutting the lot line. The only other issue was the proof that this was an individual ownership since 1961. We certainly can present everything we have. Unfortunately, electronic documentation, as far as ACRIS, doesn't go back that far. But this building has been in existence well before zoning.
No, it's not about existence, it's
I
about
understand,
ownership.
but in conjunction, we would hope that if that's the only thing, it's just a submitting of proof that this is in separate ownership from the other lots, which we believe is the case, if that we, with
You need to
conditional
find
granting
out,
on that.
right? So that's a deed search, up prior to 61, a deed search that shows that none of the adjoining parcels were held in common ownership with this one.
Correct.
Right? Okay. And then we talked about the minimum variance, right?
So I'm going to touch a little bit more on that. So generally, the requirements, especially, and I'm just going to use an example, I know it doesn't apply here, but R6 and above, either you have a 0-foot yard or an 8-foot yard. Similarly here, it's either an 8-foot yard or you abut. The minimum variance having a partial yard, which, I mean, it's just a complete redesign of the building, but there's no real zoning provision that would allow for this. I mean, it's just a partial
It's not
variance.
about zoning.
But also, in certain circumstances where there are reduced requirements, sometimes you can have as low as a 4-foot yard. There's usually an asterisk thing that you have to be at least 8 feet away from the neighboring building. In this case, even if we go to the lot line, because of the way it's developed, it has an 8-foot driveway, so it is 8 feet away. We don't see that there is any problem with having a
No, you're misunderstanding. So our goal is to find the minimum variance necessary, right? One of the reasons that we need your study to indicate what the width of side yards are and the width of buildings are within a 1,000-foot radius is so that we can see what the typical looks like. Because if you are sort of getting a wider building than is the typical, then you're benefiting from a variance in a way that nobody else does. And the purpose of a variance is to make a property owner whole relative to the neighbors. That's all.
Absolutely, okay.
Right.
And I think our maps, which correspond to what was in the statement of facts, will establish this. And I'd like to point out that the Pluto data used to make this, actually, there is no Pluto data for side yards. The calculation is actually based on the lot width versus the building width. So basically, all of these buildings have a building width that is equal to the lot width. So it is one and the same calculation. I just want to point that out. And we can, the chart, we will provide a chart in addition to the map to illustrate that all these buildings that are less than 24 feet, which are, some of them are even bigger than our lot, do not provide side yards at all.
Okay, so when we look at the figure ground studies that are basically given to us by the various data sources, right? They do show some buildings are built full to the lot widths. Some are built with side yards, even driveways, et cetera. The widths of the lots are sometimes, like, for example, many of the lots are 16 feet wide. So you're asking for, what is it, a 21 foot wide, so you're clearly a lot wider than those lots that are 16 feet wide. So you need to make a case for why providing a 4-foot wide side yard wouldn't be a reasonable minimum variance. Okay?
Okay, we will try to clarify that. Again,
Average building width is one way
Mhm.
of all the buildings in your study area. Or you could even do a ratio of building width to lot width.
Now-
Give us that as well. That'll round it out.
absolutely, we can certainly look at that as far as average, and I'm assuming you want an average width of the buildings within our study of narrow lots.
Study area of,
Or-
no, not of the narrow lot, study area of the area in 1,000 square feet, 1,000-foot radius. What do we see in that area? Because again, you shouldn't be better situated than the neighbors who live in the same neighborhood.
Sounds good. I think that's even more
Right.
generous if we can look at buildings above and beyond what's, we showed for our narrow lot condition.
So what you're doing is two separate
Correct.
studies, right? One is to establish that you're a unique lot. Those are the ones where you're looking at everybody who's narrow like me, 21 or 25 and under, 21 and under, that kind of thing, right? Then the next is to establish what's the minimum variance in terms of the standard building typology and what would be reasonable to expect in this neighborhood for buildings. Because we have neighborhoods where all the houses are 14 feet wide. We have neighborhoods where all the houses are 60 feet wide. So it really depends on where you are, what's the standard.
So I just want to be clear so I can prepare the map accordingly. I'm looking at street wall widths within the 1,000-foot area,
It's street wall and yard widths within the 1,000-foot area.
even for or complying buildings above the 24, for
So you're
wider
looking
lots
at
with yards.
What is the type, is the architect in the room? Yes. Speaking architect talk, we're talking typology, right? What's typologically standard in the neighborhood? Show us with data and with figure ground information, and in terms of the side yards, that's information you can easily get from measurements when you blow up the maps, and you just measure right off the map, so you don't need to rely on Pluto data telling you how wide it is, you can actually figure that out yourself when you put it on the maps. We actually have lots and lots of examples of these studies, and if you need a sample or a contact for how to do this in case you don't know how to do this, we have that information. Okay? But he's got it.
Sounds good.
Okay. All right, that's it. Are there any speakers on this? No? No? Okay. Yeah. Well, we don't have any speakers. Okay.
Yeah, we're really good. Okay.
Let me see, many had one. There, right. Okay. That's fine. That's okay.
Submission date February 26th with a continued hearing March 17th.
Can you repeat that? And I know the calendar is full, but if there's anything earlier, we appreciate anything earlier.
Yeah, let me just see if anything, I don't know. February. Let's see February again. Who's not here? Oh, no, that's okay. We don't have to do that.
Okay. Submission date January 22nd for a continued hearing February 11th.
I won't be here.
These are choice.
I won't be here for it.
But, yeah, we don't have the choice. Otherwise, he has to be put off a month.
Thank you.
Okay.
Thank you.
Thank you.
Frank, could you check with Richard to see if he's going to do that second call case?
Actually, if you want to do it out of order, I hope Hillary doesn't mind. Yes, the second call. Unfortunately, I was hoping for an architect to run through that door. That is not the
Oh.
case.
Well, maybe the architect's
I'm
standing out
waiting,
there
but no.
waiting to run through the
I
door.
did hear from Richard, and no, he's not coming, and we do need to schedule a date, but as soon as possible.
Okay.
Certainly, whatever you have available.
Second call, 2018-167 BZ. This is 1133 East 22nd Street, Brooklyn. Okay, so you need a date, is it?
Yeah, if I have to swear in again, but my name is Frank Noriega, Sheldon Nobel. I have the applicant, and yes, we do need a
You
new hearing date.
This was where you were just going to make some small changes to the drawings.
Correct, and we were hoping those were going to be run in, but unfortunately that is.
You were
not the
trying
case.
to do this as a second call, and it didn't
Correct.
happen. I don't know about next week,
Okay. Submission date by Friday, December 13th, for continued hearing December 17th.
So you must make it by Friday or no deal,
That
right?
is fantastic, thank you.
Okay.
Item number 7, 2-10 BZ, 2019-193 BZ, 218-222 Second Avenue, 310 East 14th Street, 300 East 14th Street, 326 East 14th Street, and 313 East 13th Street, Manhattan.
Actually, Madam Chair, they're going to need a few moments just to
set
set up a PowerPoint.
Okay.
I don't know if the board would like a
Take a
5-minute break.
Yeah.
That's
Good
okay.
idea.
Thank you.
Tony, didn't we have Mr. Mitzner's case that was?
Yeah, no one had it. I was going to say to you after this one, and just give them a date.
So they never came?
No, I didn't see anybody.
Weird.
Is working, this guy?
Yeah, it's running, I'm not sure I did it. This side of the cameras?
We have to do that
I
over.
have to do it again, I'm sorry. Raise your right hand, I'm sorry. All right, item number 7, 2-10 BZ, 219-193 BZ, which we already read the addresses. Do you affirm to, raise your right hand, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Okay, good, sorry. You can start. Are you lead? Yeah. Okay, so you can start. Doesn't matter, they pick up. It picks up.
Good afternoon, evening.
I'm Susan Golden, a partner at the law firm Venable LLP, representing the applicant, Mount Sinai Entities. Before we get started, I thought I would introduce the Mount Sinai team here, who are, some of whom will be affirmatively speaking and some who are available to answer any questions. Dr. Jeremy Bowl is the Chief Clinical Officer for the Mount Sinai Health System and President of Mount Sinai Beth Israel and Downtown. David Dighton is the VP of Construction for Mount Sinai Health System. Brad Beckstrom is the Director of Community Affairs for Mount Sinai Health System. Brad Korn is the Director of Community Affairs for Mount Sinai Health System. Joanne Violanti is with Perkins Eastman Architects. Clayton Call is with Ennead Architects. Timothy Krawitz is with Siska Hennessy Group, the MEP engineers. Stephen Holly with AKRF, the environmental consultant. And Hillary Atzrott, also with Venable. As you know, Mount Sinai is seeking 3 waivers by amendment of a previously granted special permit and 3 waivers by a variance. The variance waivers are the rear yard floor area and signage, and the special permit would cover rear yard equivalent, height and setback, and street wall. So we attended yesterday's review session, and we plan to address many of the comments and questions today, but we're also preparing a revised submission with more detailed responses and revised materials. So we won't address everything today. Some of the comments require clarifications on the drawings and some updates. So we'll take care of that without going through every detail at the hearing. Our plan is to begin with Dr. Jeremy Bowl, who will provide a brief programmatic introduction as well as a response to the board's questions regarding integration of School of Medicine trainees throughout the space. Then Tim Krawitz and Joanne Violanti will discuss the MEP plans. I will discuss some of the board's other comments, and Hillary will address the requested signage waivers. And then other members are here for questions as things come up. So I'll turn it over now to Dr. Bowl.
Hi, good evening, and thank you for hearing us today. My name is Jeremy Bowl. I'm the president of Mount Sinai Beth Israel in Downtown and the chief clinical officer for the Mount Sinai Health System. And I'd like to give you a brief introduction. This hospital was planned over many years and has undergone several iterations before being presented to the BSA today. We believe that it will be a vital community asset as well as an important educational site for our School of Medicine and our graduate medical education programs. The hospital would not only create a modernized facility for Beth Israel, but renovates and modernizes New York Eye and Ear Hospital's facilities as well, and creates a fully integrated hospital facility. Medical professionals are the hospital's most important asset, and the proposed hospital creates a facility that will assist in retention of top talent and also ensures the continuation and, for some programs, the expansion of training programs for the Icahn School of Medicine at Mount Sinai. There are 4 key programmatic elements I'd like to delineate. First, patients suffering from acute strokes and cardiac and other emergencies will get the care they need in the most efficient manner possible. The emergency department's design ensures that those with the most imminent medical needs who arrive by ambulance can be immediately transported to the interventional platform on the 2nd floor. Second, the 2nd floor procedural platform will provide a connection from the new hospital building into New York Eye and Ear Hospital's existing OR suite. The New York Eye and Ear ORs are sized differently because of the less intense nature of eye and ear procedures. Yet through connecting these 2 floors, lower intensity procedures could occur in the New York Eye and Ear quote-unquote North building, and higher intensity procedures could occur in the new building while sharing crucial support, sterilization, pre- and post-anesthesia care functions. Also, by having radiology functions on the 2nd floor dedicated to the ORs and to the interventional radiology rooms, the ED radiology functions are more readily available to ED patients, improving patient response time and experience. And just for those of you who don't know, the state of the art in stroke and cardiac care now is that the sooner a patient is who is identified as having one of those conditions is brought into an interventional suite so that the clot can actually be removed, the more likely we are to be able to preserve their function and also improve their likelihood of survival. So that time to procedure, time to intervention is the critical factor. Third, the 3rd floor through 6th floor consist of bed floors as well as a pediatric emergency department. The beds are all based on current modern standards that are single occupancy, which leads to an enhanced patient experience and a reduction in infection rates. And these are sized to accommodate the learning needs, as we discussed. The floor plates are open and duplicative for staffing efficiency. There will be 70 total beds in the new hospital. Fourth, Beth Israel was the only downtown hospital that remained open during Hurricane Sandy, and we are committed to resiliency. The MEP systems were designed to be above grade to avoid risk during weather emergencies. I would like to address the Education Center questions as well. I know that the board had some questions regarding the Education and Training Center located within the North Building and how medical students will be integrated into the entirety of the new hospital campus. The Education and Training Center would serve as the home base for medical students and residents who are training on campus, but that is not to say they will be confined to that space. Quite the contrary. The medical students and other trainees would be an integral part of the hospital campus and serve a vital function to the success of the hospital. These trainees would be on patient floors every day. For example, the emergency medicine trainees would be on the first floor of both the North and New Building's ED, seeing patients along with their physicians. The surgical, cardiovascular, and radiology trainees would be working on the North and New Building's second floor procedural platform. The OR and interventional radiology rooms are sized to accommodate teams that include these trainees. Trainees will be in inpatient rooms on the 3rd through 6th floors of the new buildings, and those rooms were sized in order to allow the trainees to actively participate in patient cases. And within the North Building, separate and apart from the 7th floor Education Center, trainees will be working within the otolaryngology, retina, glaucoma, cornea, neuro, and oculoplastic training programs. It's imperative that we include a dedicated space for the various trainees to congregate within the new campus, because being a medical trainee is a stressful experience. And while you, of course, learn so much being on the job and in the actual patient floors, so many important lessons are taught right after a procedure. The Education Center will also allow doctors and their students to go from a case to a classroom and discuss what occurred during the various procedures. It would also serve as a hub for hospital staff and physician training, such as grand rounds, which are crucial for continuing education. Thank you. I'd like to turn this back over to Sue.
I know I have a question for you.
Yes.
So on your educational floor, the 7th floor, right? I think that you said there are 350 participants in the intern program. Does that sound right?
Right.
Okay, so it seems like that's a small amount of space for that many students. Can you just talk a little bit how many people might be up there at a time and where everybody else is?
I sure can. So when we talk about 200 to 400 trainees, they wouldn't be on campus simultaneously, but rather staggered in rounds similar to fully accredited physicians. The hospital is staffed 24/7, 365. And based on that staffing model, the Education Center is appropriately sized for training functions.
Mm-hmm. So you'll have maybe 50 people up there at a time, and the others are doing their rounds, basically, or something?
Correct.
Right, okay. Okay, thank you.
Thank you.
Mhm.
Okay. Sue?
So we'd like to walk you guys.
State your name, please.
Sorry. Tim Krawitz with Siskin Hennessy. I'm the principal in charge of the project. I'd like to take a few minutes to walk everybody through the configurations for the MEP systems, mechanical, electrical, plumbing, fire protection systems that are going to be supporting this facility.
Okay.
I'm Joanne Violante from Perkins Eastman.
So what you have here is we're going to start at the top of the building and work our way down. It might help to better understand everything that we're looking at. There's all the equipment that's shown on the top of the building is either air-cooled related equipment or exhaust fan systems required by code. So what you see here are the cooling towers. You see a cogeneration plant, portions of, and you see emergency generator plant.
You know what, you can take the mic out and then point to the things that you're talking about.
Oh, great, nice. Okay, so here are the cooling towers.
Mm-hmm.
Emergency generator plant, exhaust fans. The circles that are shown are a reference used by our design engineers when designing. There's a 25-foot distance limit between exhaust discharge and intakes as per the FGI guidelines for designs of healthcare facilities. And so it just helps them trace where they're placing equipment relative to other intakes on equipment. And we also have isolation exhaust fans for isolation rooms. And that's pretty much it for this level. And then there's a walkway through.
Sorry,
Yep,
So this is the part that's on the roof that's concealed by a screen, right? So
Yes.
it's open to the air,
so this side, let me give you the orientation. This is 13th Street,
right?
right? 14th would be further up, right? The north building that Dr. Bowl had referred to is just on the other side of this, right? So it's actually going to be sewn into the campus, if you will. There's a 15-foot setback along the south facade. That's where the screening starts, and then behind that is where the mechanical equipment would be located.
Okay. So I guess part of the question is, so all of that equipment needs to be open to the air, right?
Yeah.
Does it
So-
all need to be on the same floor plate? In other words, could some of that be relocated on another floor plate, say on the top of the Lot 20 building or someplace else?
That's a great question. Now, I want you to note the size of the equipment, right?
Yeah.
This generator plant is significant, right?
I'm not talking about that thing.
Well,
Okay.
so all of the exhaust fans that are located in this spot
Yeah.
are dedicated to this building,
Okay.
right? And so it's efficient. The risers are going to come up straight through the building, pick up the programming on each floor. The fans will hit the top of the building. To offset, and we're going to look at in a minute the Lot 20 configuration, you're going to see it's a very, very congested intake and discharge area where the two buildings connect. Okay?
Okay, so another question. So the cogen, that is servicing the entire campus or just this building?
This building.
Okay, so does that mean there's no cogen in the north building? Or there's another one?
There's no cogen. This would be the only cogen for the campus at this time.
So when you say the campus, though, it's really for the new building?
That's correct.
Okay. So none of that equipment on there is going to be servicing the other two buildings?
It's just dedicated to this building.
Okay.
Does anybody else have any other questions?
We'll be looking at.
Let's go to the next floor. So, this is the floor below. This is the 7th floor mechanical room. This is just some of the fun that's going on this floor. So what you see here, we have a chiller plant located in this general area. Air handlers are going to be located at the yellow boxes. They're going to support the 6th, 5th, 4th, and 3rd floors of the building. The blue and the green is the ductwork coming off those air handlers to support those floors. Up in the top right is medical gas systems, code required as well. Down here, we have the Con Ed network protector vault and the servicing vault. What we are designing for this building is to get out of the basement. Con Ed will have 2 sets of feeders going up the building, and they will hit the network protector vaults at the top of the building. This is a resiliency issue that Dr. Bowl hit in his first introduction conversation. What's missing, right? So some of the piping is shown, not all of the piping. The conduits are not shown yet. You can see this is a congested, we're designing a watch,
How high are the ceilings?
20 foot,
20.
slab to slab.
And of the equipment, not the ductwork, but the equipment that's sitting on the floor, how much of it needs to also be on that floor together? I mean, in other words, needs to travel together?
So good practice would, so that's a good question, right? So air handlers are supported by chillers, right? So having the equipment in close proximity to each other and not routing up and down through the building allows us to give back usable square footage on each floor for programming needs, right? We're building a hospital here, not a chiller plant, as much as the engineers in my office would love to be designing a big chiller plant. But the idea here is that all the systems here are basically interconnected. You would always find medical gas systems located at the top of the building feeding down. It's just the way it is because it's another air-cooled system, but it doesn't get put outside, so to speak. It's a smaller scale than the stuff we just saw up on the roof.
So, but the medical gases have to just be above the patient floors or above the ORs, or like where do they have to be relative to the activities?
You know, well, so the biggest need would obviously be just what you hit, right? The patient rooms and the ORs. ED as well, right? Which is really the programming of this entire facility.
Okay.
Okay?
Wait a minute, what's in the upper left corner? Go back to that one. The
Upper left, elevators?
No, behind the elevators. The blue ductwork.
That's some more exhaust systems. We just took advantage of the location being available. Okay? So, okay, now this is a little bit unusual. So this is lot 20.
Right.
We just looked at what could be considered a traditional horizontal mechanical room. This is the complete opposite. This is a vertical mechanical room. This box represents, this will be 3 air handling units stacked together. The whole purpose of this exercise was to take a floor out of the building. So the 3 air handlers are going to serve the second floor where the interventional radiology is going to be occurring, the first floor where the ED is occurring, and then the cellar level. Right? And so what we're doing is essentially feeding into the side of the building horizontally and not vertical distribution. The advantage of that, again, is we're giving programming space back to the facility so that they can treat patients and not deal with my systems. The components shown here are dedicated to the ORs that are going in on that second floor. So all of the serviceable equipment, be that reheat coils, HEPA filtration, humidifiers, things on that level that require normal maintenance will be located within an enclosure for ease of servicing for the staff. Because if we put it in the ceiling of the second floor, it'll never be serviced.
Right. How do you get to this structure?
So there's a stair. This is 14th Street, just for the orientation, right? Here's going towards 13. Here's the new building.
Right.
You can see this is up off the ground. There's a egress corridor pathway, if you will, through the facility, and a staircase that leads up.
Okay, so maintenance always comes from the 14th Street side? They don't come
That is
through the
correct.
cellar or anything from the other side?
Yes.
So, and why doesn't this building have a cellar? Wouldn't that help you if you already have a cellar and some mechanical equipment in the cellar?
Let's go to the next. So here's what we did. We've designed, for lack of a better phrase, right? This is the comments in our office. This is like designing a mechanical room in 2 lanes at a bowling alley. And if we go down below grade, because of the underpinning required of the 2 existing buildings on each side, this condition becomes even tighter, and it's not usable.
Because you have to bend to get.
Well, it gets so narrow, we can't, because the servicing requirements.
Oh, because it's not underpinning, you're doing step foundations, right? Are you doing underpinning or step?
We get very, we would have to underpin the existing building, so foundation, it would get, we would come in.
Take the mic, the mic.
Yeah, sorry, you should put the mic right.
So we would either have to underpin or, these existing buildings or to build inside the lot, which would be what we'd be looking at. So it's, and the other unfortunate thing is that it's only 22 feet wide, but unfortunately our neighbors are built over the property line by about 18 inches. So it's extremely constrained.
All the way up or just at the cellar level?
It varies. It's like angled and it's pretty messy.
Can you go back to the section, the one before? So what if you had more height on your lot 20 building? Could you put more stuff in there?
The issue, right now, we're straddling a fine line with the building code we're right at the threshold where we would have to add an egress stair into the building due to the height. So putting an egress stair in there really just negates this whole proposal because we just don't have the width once we get that stair in there. So we really tried very hard to keep it under the
So the magic height is what it's at? Is that?
Yeah.
Okay.
So, and something else to consider, right? The floor above the 3rd floor is patient floors, right? The FGI guidelines require a window per patient room. Because of the penetration points that you're seeing here on the other floors, we would be losing programming space if we added equipment further up and had to go into the side of the building.
But you'd lose, what, 2 patient rooms or on that floor? Because let's just say you only went up one more
Probably
floor.
minimum 2.
Yeah.
And the way that this is being clad is what? How are you handling the exterior?
The front facade is brick, and we're looking at either metal panel or brick for the sidewalls. We're studying that right now to see what is the
Okay,
most
so in other words, solid
advantageous.
material, because it's
Oh,
been described
definitely.
as screen.
It will definitely be solid against the neighbors. It would be, the building would be designed to meet all of the noise criteria, the acoustical criteria for that space, and the fire codes.
Vibration, issue of vibration.
Yeah.
Okay.
Can we go back to, go to the next slide, please? Sure. So you're saying that you cannot build a cellar within this?
No,
like,
because,
narrow
because
portion?
as you see, we're just making it now on servicing clearances
Yeah,
for the
because-
equipment.
Because you have encroachment from adjacent building
Yes, sir.
foundation inside your property? Do you have something like shows that as schematic? Can you just submit it to us for our
Yeah.
records?
It's shown on the survey.
Yeah.
Okay, thank you.
Yeah, and I think it's actually mentioned in our papers
Yeah.
that there's a
Yeah.
little extra for the neighbors.
And
Okay.
so, again, as you can see here, this gets rather challenging, right, to get the ductwork and piping inside and outside of this enclosure. So narrowing it anymore is going to be, it would not be feasible.
And the egress stair, I hear it, because if you have an egress stair, then you have to bend all of this stuff around, and, but there's no, and we have fire department still here?
Behind you.
Yeah, right behind us, okay. So, I'm just curious about whether you might somehow be allowed to have an egress stair or a catwalk or something that goes across the rear of your
Go back to
new
the section.
building.
Didn't we propose
Yeah, in that
at the
section,
time?
right. So what if there were like a catwalk on top of this thing? I understand about the potential loss of the rooms. I just keep looking at an opportunity to reduce the height of the mechanical floor, or like the amount of mechanical floor. that
We
you've got.
do have a catwalk across the open mechanical area in order to give FDNY access to the back of the,
Oh, yeah.
to the back of the site. But we went through this initially with the building department, and they were very concerned about the lack of egress, and that we were building this large mechanical space that would be difficult for them to get in
Right,
and
and the
fight
only
a
egress
fire.
really is these ladders at the moment. Is that the issue? Yeah. Okay.
Ladders and grading.
Ladders and,
With grading, floor grading.
Subway
yeah,
grading.
yeah, and, right. Okay.
Let's go to
Very
first floor.
interesting.
So this is the first floor. As you can see, it's more of the same. It's a recurring theme. A lot of breakout ductwork, a lot of congestion in the general area. We're envisioning that it's going to be basically wall to wall by the time we're done with it. A lot of it will probably be prefabbed on site and lifted in place because, to be quite honestly, it's probably the most efficient way to construct it. Yeah, so, sorry. So this is imagine if the floor was glass, right, on the second floor, and we're staring down into
Yeah.
the ceiling, the hung ceiling of the first floor, right? So again, the blue would be supplied ductwork, the green would be return ductwork, there's piping shown. In the red, it's a myriad amount of systems, a lot of distribution going on here. As you can see, it's the entire floor plan is like building a watch.
So, and in that space between, that was the other place I was focusing on, the space between the north and the south building, and the kind of corner of the new building, that is only up to the roof of the second floor, it's the rear yard equivalent area. I'm running out of ideas for what could go in there, but,
As have we. That would be wonderful. I probably all talked out.
Okay, this is super helpful, thank you.
Cool.
I do have, it's more of a question for maybe the director about the connections between the functions, but, so that's another thing. Okay.
Okay.
Just
So,
please state your name again.
You can just keep it there for now. I wanted to give a couple
Just
of...
state your name again, just so we can
Susan
follow
Golden.
along.
If for all the
Sure.
speakers, when you come back up, please.
Yeah.
Susan Golden, Venable. Okay, so I wanted to address a couple of status questions that were raised yesterday. The first was the Landmarks Preservation Commission sign-off on the environmental assessment
Oh,
statement.
before you go into
Yeah.
environmental though, which I know is your thing, can we just hear, this is the part about, you're here for a variance, just ask for the stuff you need, right? So My question had to do with the linkages between the north building and the new building. And some statements in the statement of facts that say, we really need these adjacencies, or for instance, with your psychiatric floor, there's a statement that said, there you are way up on the top floor, or someplace like that, I think you're on the top floor, and that there, if in the event of an emergency, you need to be able to get someone either out of there and down into the emergency department or the other way, and it seems like you're not able to do that with this plan currently, because you're having to take someone to the general elevator, then they go down into the general elevator where everyone is sitting, and then are brought into ED because there's no elevator inside that I can see in ED unless you go across to the new building.
There is an elevator that can be put into emergency service, that we are adding a rear door directly from the ED that would take you up to the 9th floor for the CPAP
Can you
unit.
show us where that is? I just don't find it on the drawings. I was looking for an elevator.
And that elevator has a key card access, so it can be locked out when it's being used for that particular type of access, so that other people don't end up on the same ride.
Mm-hmm.
So if you're looking,
You can approach the chair if you want to.
Yeah, please.
So on Z122,
Can you tell me the number again?
Z122, in the grayed out area of the north building, you can see elevator, the top
Right.
left elevator, we're adding a new door.
Oh, I see it. Opens
that
directly
opens-
into ED.
Yeah, to
okay.
open directly into ED and take you directly up
Okay.
to the.
So for
the CPAP
people looking at Z122, which is the top, that 130, which is the location of the psychiatric floor, right? They're entering into the elevator lobby, but that elevator on the upper right that says 79 square feet, that one goes down to the emergency department, but they're going to put a door in that goes the other way. Okay, thank you, very helpful. Okay. But so I guess my question was, before it's too late, think about if you want to have any other kind of a connection at other floors that would cut across the sacrosanct rear yard equivalent. It's right behind your own building, so use it if you think that there's a natural connection that's being missed, right? Because it's not imposing on anybody, right?
Right, so Mount Sinai did study that rear yard equivalent area to determine, obviously, they studied multiple iterations of the whole hospital to figure out what needed to be adjacent, which program areas needed to be adjacent to each other, and what connections are required and what type of connections are required. So some of the connections are large and obvious, like on the first floor where the ED and sort of flows into the lobby of, and other connections are not so obvious, like that rear door that we were just pointing out. The connection at the higher levels across the rear yard equivalent is not feasible, and I'll give you some kind of high-level reasons, and then we'll address this a little bit more detail in our submission. The north building's floor-to-floor heights are lower than what is required for new hospital functions, so they differ from the floor-to-floor heights in the new building. So the floors don't, as you go up, they get further and further off from each other, which makes the connection, because that space is not large, the connection becomes largely about circulation, where you've got to have ramps and stairs just to make the connection. So it doesn't become very usable space. And making the connection itself, by cutting into those two buildings, actually eliminates program space that is otherwise along the southerly wall of the north building and the northerly wall of the new building. Because by making the cut, you're eliminating a room or a lobby, or whatever the function was that was there. In addition, we also looked at sort of the feasibility of building in that area to see whether we could stick something that maybe didn't make a connection but just sat on top. In the absence of a cantilever, which has its own issues, columns would have to be inserted through the program space that's down on the existing space that's on the second floor, first floor, and cellar, and some of that space will remain in operation. The columns themselves would, aside from the disruption due to construction, would have sort of permanent disruption to the space as well, so it eliminates space. So it was determined not to be feasible to make those connections, and given the arrangement of the program spaces in the building, not necessary for program purposes to make those connections at the higher levels.
Is the board satisfied with the verbal, or do we?
Say again?
Is the board satisfied with that just verbally, or do we need a submission?
I
on
think that, you know,
I think
well,
that's-
this is a little bit different than my question was, do you need more connections? My question wasn't put more program in that space. So it really is, no, we don't need more connections because it would be disruptive or whatever the other part of the answer is.
The key areas that we need the connections are on the first floor, cellar, and second floor for the ED and the surgical and procedural platform. There are other connections throughout the campus that are, as I said, not as obvious. So just for example, there's a pneumatic tube system that's used to connect the ORs and IRs to the pathology lab. Which I think was one of the questions that you
that was a
raised
question.
yesterday.
How are they connected?
We talked about the CPAP elevator access. There are connections into the south building.
So are those pneumatic tubes part of the spaghetti of the mechanical system? Not yet.
Different consultant.
Okay.
I just wanna
Yeah.
go back to this space between the two buildings. I just looked at the geotech report. They did test pits in that like hallway portion, and the two test pits were done adjacent to the two buildings to the right and left. The footing depth is about 10 feet below grade, so I don't think underpinning will be needed, and I don't see encroachment except for an 8-inch portion for one of the footings. So they
Okay.
did two test pits, and
Okay.
I don't see what was mentioned.
You're talking about on
Okay.
lot 20?
You're talking about
The,
the lot 20 where the,
Yes, where the buildings, so we'll make sure that we point out where that's documented and.
I can,
no, it's a,
yeah, this is this portion here. They dug two test pits, the geotech engineer has done two test pits. And I did look at the geotechnical report, at the sections of, usually you dig and you look at the footing where it's located, whether it encroaches inside, and you document that. And I did look at the documentation for the two test pits. And it sounds like underpinning wouldn't be needed, and the encroachment is just minimum, like every.
right. But I think that the other issue had to do with fire egress when you
I
have
just
too much
wanted
height.
to-
Okay, so,
Yeah,
No,
we
there's
appreciate
a-
that. So we'll
yeah.
make sure that our submission explains the exact nature of the issue.
Thank you.
yeah, okay, thank you.
Okay. And then I also just briefly wanted to address the south building connection. The south building dates from the 1800s. It's the original New York
Right.
Pioneer Infirmary. It has irregular floor plates, low floor-to-floor heights, all the stuff you would expect from a building of that age. So what's in there are New York Pioneer outpatient clinical functions, and that's what's going to remain because that's the appropriate use for that space. So it doesn't require the same level of connection to the new building and the north building hospital functions. The connections tend to be more about service and support, and obviously patients coming in the main lobby have an entryway from the north building lobby into the south building.
And that's sort of to go to doctor's visits? Is that
Yes,
what that is?
yeah.
I see. So you're just controlled by the same reception from that side, basically?
Right, from
Okay.
the main lobby, exactly.
Okay.
Okay. So let's see. I did want to point out, as Tim mentioned, that we were able to achieve 15-foot setbacks on that roof level. So responding to that comment, as we sized equipment and finalized the layouts there, that worked out. So our new submission will reflect that increase in the setback at
Okay,
that
so,
level.
but that's on the
That's on the
roof.
roof to the screen, exactly.
Yes, but there's no
There's
further
no
setback
further
possible?
setback on the 7th floor. We have the, well, you saw the layout on that floor. It's very tight. The Con Ed vaults have to be right at the lot line in order to make their connections. That's, I guess, a
Oh.
Con Ed requirement. And it also,
That's
Yeah.
Even when it's on, way up there. I get when it's in the cellar.
They have,
You have to come to the
If
mic.
you speak, you have to speak with the mic, yeah.
they have very clear rules and are not willing to negotiate them.
Yes.
That's really what it comes down to.
Okay. So if you could include that, please, in your report.
Okay, we'll do that. Okay, then you had also asked about the transit volume easement. So status is that we've gone through the pre-application process with city planning. We've negotiated the easement volume, which is shown here with the MTA. We had comments on our pre-application, and we filed the draft application October 24th of 2019. And city planning advised us yesterday that we should have comments on that draft by the end of the year. This transit volume easement, this is the easement area. We're in the process of negotiating the agreement, so that'll get recorded at the end of the city planning process. This easement runs north-south along 2nd Avenue here. This is 14th. And you see this is the Lot 7 area. Lot 7, the easement encumbers below grade, at grade, the entire lot area, and then up for 20 feet. And then below grade, it also extends further south along 2nd Avenue in underneath the north building and south building areas to allow for the possibility of escalators down into that space. It's not a standard easement under the zoning resolution, but city planning and the MTA have both agreed that we can proceed with this easement because of the existing buildings that will remain on the zoning lot. They're happy to get the most that they can get from us, so.
So are they suggesting that you'll have to build a structure where the pink is above grade?
Not Mount Sinai, but for now, they're allowing us to use it as the little open space plaza that we described in the application. But when they do come along and build the station, that will be removed, and they will build some kind of access there. It'll either be, I think we had talked about escalators, with one of those glass coverings, or an elevator, whatever the.
Given this is going to happen in 50 years, there'll be a different technology.
Hologram access, I don't know.
But to be careful that your entrance then isn't going to be affected by
So the
this.
entrance.
So your plaza, it's not that people enter through the plaza.
That's correct.
right?
The entrance is on 14th Street for
Yeah,
that reason.
okay.
Yep. Okay, and I don't think we addressed your question yet about expanding, potentially cantilevering over this space. Because as you see, the easement doesn't go all the way up, but we did study that.
No, so again,
yeah.
it's not the intent to say, what can you stuff into that cantilever? Because maybe you want something to stuff into the cantilever. I was just saying that your papers were saying we can't build anywhere on that lot, which is not true because the easement is subterranean.
Yeah, so we'll
right?
go back and double check that the language is technically accurate.
Right.
I mean, the point is that we certainly can't build at grade and below grade. We can't put in footings, so this would be a cantilever if we were able to put a piece of equipment there. It's a pretty small floor plate. The real issues are disruption of the program space that's immediately adjacent in the north building, and the distance from this lot to the new building, which really just makes putting mechanical equipment there infeasible.
Right. It's more as if you wanted to expand your, your OR in the north building.
Right.
You could add more operatories, arguably, in that corner,
and
that kind of thing.
Given the small amount of space that's there, it's not worth
Right.
building the space.
But, my experience has been with these easements, it doesn't stop you from dropping your columns for your structure within the envelope. It just says that within that envelope, you better have room for the elevator and the escalator and the staircase. that
Yeah,
kind
and
of thing.
sometimes that is the case, and sometimes
Right.
you can integrate the, if you're building a new building, you can integrate the entrance, so it's not right on the corner, it can be inside the building.
Right.
In our case, this lot is so narrow that we're essentially giving them every square inch at grade, and and below there. So there's no space for us to put columns and for them to then, they at least needed to be able to sign off that they could fit escalators there, which is what they did. And they're squeezed in tight, like right up against the wall. So that was the issue with us trying to build anything that would be permanent. It would have to come out. I also wanted to answer your question on the floor area transfer. The C17A district allows 268,450 square feet, and we're proposing to use 191,880 zoning square feet. So the unused is 76,570. And of that, we want to use 11,383 square feet on the C16A portion of the zoning lot.
Can you mention the last number?
11,383.
So it's a relatively modest increase in the floor area in the C16A. I look at it like that. You're leaving on the table what you're not using in the C17A, and you're
That's
asking
correct.
for an 11,000 and change increase in the C16A, which is a much more benign sounding answer than let us move all that stuff
Right,
over to
we're not
here.
trying to maximize the floor area
Right.
because, yeah.
Okay.
Okay. And then back to seeker.
No, so then I also had a question
Yes.
about the ramp.
Oh, yes, the ramp. Okay.
Please move the ramp inside the building.
I wish we could.
Just do that.
I had the same idea and they all looked at me.
No, but you can do it. It's only 3 steps. Really?
So we did study the impact of this. Yeah. You want to address?
Yeah, let's talk to the architect.
One thing about the ramp is that it's on, that entrance, the ED entrance is on top of a very packed mechanical room. So in order to move the ramp and the stairs into the building, we would have to take height out of that mechanical space, which would impact the operations of the hospital. So that, and the fact that, you know, just roughly looking at it, it looks like it would take out at least 2, possibly 3 ED treatment bays in, you know, an equivalent area. It's really the only thing we could give up. We think that that's going to impact the number of visits that we could service.
Why would you have to use, how long does your ramp have to be?
The ramp is... We think it's about 25 feet, but we would need to have, once we bring it inside, the nice thing about having it outdoors is we have, the landings are on, it's free space on the sidewalk. Once we bring that inside the building, we need to create additional landings at the top and the bottom. We need to, maintain a distance between the doors, the 2 sets of doors. It just would become we would also be looking at we have steps out there, we would be, if we're
You
bringing.
leave the steps.
You would leave the steps?
You could leave, so this,
We would still have to drop in order to get the height to work. So it would have an impact on the mechanical space, which is owners.
can you give us more information? This one I'm having trouble with because it's a major impact on 14th Street pedestrian traffic, which sometimes gets major there. So,
Yeah.
and
We can provide some more information on this and explain, maybe a section would be helpful to show the what's below grade there and the impact of it.
And maybe photographs of the mechanical area.
Sure.
Don't you have a vault or something underneath there?
You mean under the,
Is there- under the
that would be under the
sidewalk?
sidewalk? Well, but we couldn't put, it's a mechanical
mechanical
room
vault?
in the cellar of the north building. We're not talking about sidewalk space.
No, you don't have a vault underneath the sidewalk.
Oh.
Right.
No.
Okay. Yeah, so if you could give us more in the field information about that, photographs and so on, because that seems like kind of like the least you could do.
I will say, though, that they did the studies on a good weather day, and AKRF did counts of the pedestrians, so.
But not on a weekend.
Yes, on a Saturday.
On a Saturday?
Yeah,
Okay.
they do a Saturday and one weekday, I think. in May and June. They do counts more than once, and all that information has been shared with DOT, obviously, because this would be a revocable consent. So we're in the process of working out details with DOT. But they seem satisfied with the pedestrian information. And there's so we can share more information about that arrangement, both on the sidewalk and what the internal impacts would be if we were to move it inside. You also had some questions about the census numbers.
Yeah, I just didn't understand what that sentence meant. Just
Yeah.
explain what that means.
So the numbers we provided represent expected utilization based on treatment spaces and sizes. So for example, the emergency room is projected to have 70,000 visits annually, maximizing utilization of the treatment space. The inpatient and OBS beds are expected to admit 12,000 patients annually with an average length of stay of 2 days and an occupancy of 90%. Then there was an estimate or projection of visitor counts based on historic experience at Beth Israel and daily staff counts based on each department's projections and budget. And that's how we came to those numbers, which were included in response to the NOC. So if there's something we can do to clarify.
No, I just didn't understand what those two figures were referring to.
Okay, did my explanation help, or should we do a little more work on that?
Maybe rephrase it.
Okay. When we revise the statement of facts, we'll clarify. Okay. You also asked, I think, about the old idea we had about having an ambulance lane running in the opposite direction, which was...
Oh, that was the opposite direction.
Yeah, it was in the
I'm not saying
opposite
the opposite.
direction.
What about
Yeah.
in the correct direction?
In the correct direction, so the ambulances would come down. DOT has installed a bike lane, a one-way bike lane on 13th Street. Yeah, but not two-way.
Can't we talk to them about this?
Well, the original proposal was for a two-way bike lane, so one way. It ended up as a one-way bike lane, so the ambulances would come down 13th Street adjacent to the bike lane.
So here you have people on a bike lane, and then an emergency vehicle, and then there's someone on a bike. Doesn't that sound like a bad combination to you?
I'm not going to say the obvious. Am I right? It's a protected bike lane? Yeah, it's a protected bike lane.
It has bollards all the way across, or it has...
One could say at least it's
Yeah.
right about the hospital emergency.
Yeah, I'm glad it wasn't
There
me.
is a benefit to that.
Yeah.
So that, as curious, I know that we're still waiting for DOT on this, right? That's a pretty significant question, this issue of the ambulances, and they interface with everything that's being pushed to 13th Street because of what's going on 14th Street.
Yeah. And in the early stages of planning for the hospital, Mount Sinai met with DOT from the commissioner, on down to many different divisions, because this hospital touches on a lot of the different groups within DOT. So they are both on the traffic side and on the seeker side well aware of the plans for the ambulance. The reverse lane, was not accepted by them, but they did reduce the bike lane to the one-way bike lane. So they have been involved in discussions about this and are aware of it. We haven't heard back from them yet on the latest version of the travel demand memo for seeker purposes, but this is, the planning involved conversations with DOT, so we're not expecting there to be issues with the ambulances.
So I guess one question that I do have about the pedestrian traffic on 14th Street and so on, and arguably on 13th Street issues, is we've had a number of applications for projects to be constructed on 14th Street, and or just note that there were. I'm curious whether the EAS looked at projects about to be constructed, soft sites and all of that, and the pedestrian impacts in that situation. You know what I mean?
Stephen, do you want to take that? Do you, and can I just clarify the question while he's looking? Do you mean the impact of the
Added pedestrian
added
traffic.
pedestrians for the hospital?
No, well, that's another way of looking at it, but no, I'm actually looking, because now I'm focusing on the ramp. And because there are other parts of 14th Street where it's really hard to fit your body on 14th Street, right? So if some of these projects were large housing developments, that would arguably add a lot more pedestrians, and I don't know whether they've been constructed, or they've been put on hold, or they're in permitting stage, or whatever. So that would be sort of your soft site review.
Hi, Stephen Hawley from AKRF. So looking at the analysis that was provided in the transportation section, we included a background growth rate of 0.25% per year from 2020 through 2023. And then there was one development project, a 285 hotel room project at 112 East 11th that was included in the pedestrian projections. And that was all that was identified within a quarter-mile radius.
Oh, wow, so nothing new on 14th Street? Huh, okay. Maybe they're built already. Okay. Or
Yes.
they're further west. Okay. All right.
Okay.
You're cutting off traffic on 14th Street.
Say?
Nothing, I was just thinking about the traffic plan on 14th Street.
No, that's what,
Right.
so their original project was concerned about shutting down the L for years.
Right.
And
how
now
we
it's
were
a
gonna
different.
construct. Yeah, now it's a little different.
So, but because of the bus line that's sending traffic down onto 13th Street, and also the bikes on 13th Street, right? That's the difficulty going forward. I'm curious whether eventually, talking to DOT about the future for the hospital, that maybe the bike rack, are there bike racks also on this block? I hope not.
We do have bike storage, yes.
No, I mean,
But
city bikes.
Oh, city bikes.
No, okay.
No, I don't think so. I haven't seen
Okay.
city bikes.
But anyway, so maybe, who knows, whether the bike lane maybe shouldn't be on the same street as the ambulance in the future.
Yeah. So we have,
It's hard.
the ambulance condition will be managed. And not every patient that comes to the ED comes in an ambulance, and obviously they don't all come at the same time. So it's not sort of like a continuous stream. And we also plan to have, Mount Sinai has committed to have a staff person, a sort of like a transportation director, who will manage so that the ambulances aren't kind of piling up and blocking traffic. And, you know, we've got the ambulance bays that go into the building, so they're not blocking the street.
Right.
So there is a plan in place to manage how that operation functions, and, you know, there will be outreach to DOT if necessary.
So that kind of brings up the subject of the signage, which we didn't talk about.
Right.
If you're a hysterical person grabbing a taxi or an Uber to get to the emergency room, how does the driver know where to go?
So Hillary was going to address signage.
Okay.
Before I go, I just wanted to point out that we did get the LPC sign off, which was one of your other questions
Yeah.
yesterday, back in October on the EAS. And the
Okay.
archaeology sign off was back in August. So
Right.
I think we've checked that box.
Okay.
So I'll turn it over
So
to
that
Hillary.
was shadows on the church, basically, right?
Yes, yeah, but they considered all of the historic resources in the area, which included the south building.
Oh, okay.
Okay.
Good evening, everybody. My name is Hilary Atzer out of Venable, and I'll be taking us through the sign analysis this evening. Just to first off address some of the questions that were posed yesterday. I know that Chair Perlmutter, you mentioned that there is one case that you know of that you were actively involved with in a previous life on signage at hospitals. But there's actually been 6 total sign cases. I believe I've read every sign case ever granted by the BSA for hospitals.
All 6?
All 6.
Okay.
Yes. But when you look at the hospitals in the city, there's a clear need for signage at hospitals that goes beyond what's presented in the zoning resolution. We are cognizant of the fact that DOB often takes the position that emergency room signage or some other signage can pass muster if it doesn't comply with the zoning resolution. But we're here for these other waivers, and we want to ensure that the community can find this hospital, and there's no ambiguity as to the signage that's included in the plans and that's approved and available for the hospital, and for the purpose of wayfinding. So I know you, Chair Perlmutter, mentioned yesterday that this is not really a programmatic need argument, but in these 6 total cases that the BSA has granted, wayfinding has actually been held to be a programmatic need for hospitals. So as a baseline matter, you bring up the fact that you're hysterical, you're on the way to the emergency department and you need to find it. How do you do that? You do that with our wayfinding analysis. So Clayton, if you could go to the first slide. So 212, which is a signage company who's worked on other BSA variance cases before, identified these locations, A through I, which required signage. So signs A and B, if you could go to the next one, Clayton. So signs A and C. A is the sign up here, and then it's C on the other side of the north building. Those are the building identification signage. Because when you're approaching the hospital in an emergency, you're first coming from a far distance. And based on the building context surrounding the new hospital and the north building, you can't see the location of the hospital from a distance of several avenues away unless you have this signage that's located at the top of the building. And I know it was mentioned that there's existing signage on the north building, and why can't we just rely upon that signage? It's actually for 2 reasons. The first reason is that that signage is actually lower than the proposed signage here. So this would raise us above the building so that we would be able to have the signage identifiable from a further distance.
Wait, where's the existing sign?
The existing sign is actually slightly lower on the building. So yes, this one here, so this writing on the bottom, this portion is partially within the area, but this is below where the proposed signage would be. The other reason is that this north building was constructed after 1961, so it's technically speaking not legally non-complying signage because it was put on the building in the late 60s rather than early 60s. So that's the reason that...
So you can't rely on it, in other words.
Exactly. We can't rely upon that signage moving forward at DOB. Then when it comes to the various blade signs that you see, as you approach the hospital, the taxi or the pedestrian needs to be able to see the location of the entrances. So we have the emergency department entrance on 14th Street. We have the main hospital entrance on 14th Street adjacent to the plaza. And then on 13th Street, we'll have the ambulance and the loading entrances. Clayton, if you could go to the next slide. One more. So if you're coming from east to west, it's very challenging to spot where the emergency department is without this additional signage. And we want it to be abundantly clear where this signage needs to go.
So that's if you're coming down the FDR Drive?
This is if you're turning off the FDR Drive onto 14th Street and you're approaching from east to west. So this is the as of right condition, and this is the proposed condition. If you could go to the next one, Clayton. So this view is on 2nd Avenue.
Wait, can you go back, instead of saying this, can you say what the difference is? Because they're so teeny and
Sure.
we're looking at them from far away.
Absolutely.
Okay.
So obviously you can see that if you're approaching from east to west, it's very challenging to identify the location of the building without the signage on the top of the building. So this is the building identification signage, because you'll see this is the zoning compliance scheme, and it's challenging from a distance of, this is mid-block between Avenue A and 1st Avenue. So this is as you'd be going down 14th Street. You can't see the location of the north building. And as you're getting even closer, so this second scheme is going even closer to the building, it still remains challenging to identify the ER with the small signage, but if you have the complying signage, it's much clearer as to the location of the building and, crucially, the ED entrance for pedestrians. And as you'll recall, 14th Street is the location of pedestrian access, walk-in access to the ED, so it needs to be abundantly clear at the pedestrian level.
But so I guess my question is, again, because the images are so little, and if that were proportionately where I'm seeing this from, I still don't have really anywhere to go. I may know there's a hospital, but I won't know that that's the ED, at least not from this distance. But,
Sure.
so I'm curious, you know, for instance, I mentioned banners,
Mm-hmm.
right? And we do see lots of hospitals that they take full advantage of the banners, where they're like marching up along. Even the new school marches their banners.
Absolutely.
And there was a comment in the statement that banners don't wear well, but in fact, I don't see anywhere a description in the zoning resolution that says what a banner is made out of.
Sure.
So I'm curious, why not make it out of something that wears well and have more of an identifier on that facade to say, you know, hospital getting closer, ED. Something like that, because I think it's super subtle the way
Sure.
you've got it now, actually. So
Absolutely. This isn't to say that potentially in the future, as the hospital would become operational, that banners wouldn't be used on a temporary basis, especially as the community gets acquainted to the location of the new hospital and the various entrances. I think what's important to note with banners is they're not a permanent wayfinding solution. They're more of a temporary decorative solution. They do have maintenance issues, and something else I'd like to point out that we will be discussing in our supplemental submission to the board. This is also an eye and ear infirmary. And there are 2010 ADA guidelines that actually say that signage should be of a high contrast nature, and banners prove problematic both from a contrast and from the waves that it can create on the banner itself. And so we did do some research on banners in the context of specifically people with visual impairments, and they are not as beneficial on a day-to-day basis. So we want to make sure that the hospital is serving all populations, and we believe that the wayfinding program and the signage request is the best way to do so. So Clayton, if you could just click through to the next slides. So this is the viewpoint from the northerly corner of 2nd Avenue and 14th Street. Again, this would be the plaza area. This is the main hospital entrance here. The plaza would be adjacent to that. And again, this is so that pedestrians know that the emergency department is further to the east on 14th Street and that this is the main hospital entrance, and there's a clear delineation. And this is just another view of that same area down 14th Street, so it would be clear that emergencies, main entrance.
So is there any way you could put some kind of signage on that corner that's like an arrow signage for emergency rooms? So if you're approaching by car, you don't at the last minute go, hang a left.
Yes, that's certainly something. So this presentation only focuses on any sign that would require a variance. Any signage under 12 square feet that's directional signage, under 1210 doesn't get counted towards the actual total signage count. So there may be some small additional signs that are used, standpipe signage, et cetera, along the building. Next
In
slide.
your new submission, could we see what that signage would look like with the small signs as well?
Sure, of course.
Thank you.
I'm just traveling around the world of signs in hospitals while we talk. I don't know about that ADA argument. According to that, almost all these hospitals are out of compliance with ADA, and they have these gigantic banners stretched in front of their buildings. They're gigantic.
Banners are often used. Chair Perlmutter, I am not debating that banners are often used. New York Eye and Ear has banners right now that are used on 14th Street, but again, it's not the primary wayfinding signage for the hospital. So,
you know how big this this banner I'm looking at is 6 stories tall and about 25 feet wide. You're telling me that's not a wayfinding? It's red.
That is, I will have to do a Google search for that, and maybe think creatively about what banners would be there. But again, I think that the longevity of the signage, especially opening this new hospital in the community, making it a lasting and visually beautiful place for the community as well. To that point, to address your question yesterday about the north building facade, there will be new cladding that's added to the north building. So this isn't, just some new building that Mount Sinai wants to add. It's a new building for the community and making it look its best. Obviously, the goal of signage is wayfinding, but we want it to look nice as well. And this allows it to not just be a banner, but actual structure for the hospital. Clayton, if you could go to the next slide. Again, this is 2nd Avenue looking north. Keep going. And this is, again, 2nd Avenue looking north at the angle of where the plaza would be located. And then we also included, just because I know there was a question about how the signage was calculated, we have 3 pages that in the interest of time I won't go through, but we can modify any of the signage plans to reflect the full frontages. Because of some of the unique positions of the blade signs, we counted them as part of the frontage that they actually faced rather than the zoning lot frontage. So I think that might have been what created some of the ambiguity as to what signage was on which frontage, but we can clearly outline
You
that.
just need a chart that goes through each sign, how many square feet, which frontage it applies to, therefore how many square feet on that frontage. And then, the kind of reality is emergency usually doesn't get counted. So maybe what you do is you pull away those kinds of signs so that you're really only including like the identifiers. And that way we can see this many square feet is in the word emergency. And this many square feet is in the identifier type signs, and only this many is in the signs that extend higher than 25 feet.
Understood.
That kind of thing.
Certainly, will do.
And all that by way of trying to discourage some shopping mall from coming to us for a sign variance, because they also need visibility. So you need to make sure that when you write this, that the reason for all of these things is ambulances, and I remember from this other application, ambulances driving from other parts of the city where, because you're a specialty hospital, how in the world does the ambulance driver who's never been here find you, right? And how in the world does the Uber driver with the hysterical person in the back seat find you and go to the right entrance and not, that's the other question, how do they know not to go to the ambulance entrance?
Along with the time is of the essence that they were speaking of with the stints.
Speak louder,
Along
please.
with the time is of the essence as they were speaking of with the stints need to be placed as soon as possible. That would add to why there should be sufficient signage for this hospital.
Right, but to clarify for some kind of sign that tells ambulances you go this way versus kind of everyone else, you go that way. Because
Absolutely.
I can see lots of people dropping off on 13th Street because, by the way, they were on a bicycle, and on their bicycle, they passed the ambulance entrance.
Understood. We will make sure to clarify all of that.
Okay. All right. Anything else we left out?
I think that was everything that.
Can I just add something?
Yes.
I think with regard, I had some concerns, and I think this was very helpful. And from what you have diagrammatically shown, at least lead me for a complex of this magnitude with 3 frontages, this is a reasonable, I mean, without it being too blingy and too out there for the residential neighbors to look into. I think this is a reasonable balance.
The bling will come with the banners.
Thank you.
So
Just give them a minute, okay? Okay. All right.
We know that you had other clarifications and questions, and we'll address that in the submission, including the comments about the subcellar conditions.
Yes.
So if.
Try to solve it as opposed to giving any reason why you can't on the interior ramp. That's one that, think about, all the questions, the resolution on those questions. We're just talking about moving a ramp, which is such a ridiculous solution for disabled access in the first place, right? I mean, in the sense that it's a shame that we have all these ramps clogging up our sidewalks all over the place, and you're going to all this trouble to build this very expensive building and gut renovate and all of that. The least you could do is put the level change inside the building, right? So let's just give that a real college try, okay? And I always say to the architects, pretend I'm your client, and the client tells you, I want the ramp inside, okay?
We understand.
Okay, so
Excuse me.
we
Thank
still
you.
have DOT and some other, right?
DOT and hazmat, I believe. we're waiting
Yeah,
for.
so for hazardous materials, we had gotten some comments on the work plan, which were addressed, and we'll be submitting the Phase 2 report when it's complete. But the EAS, I don't think requires the full completion of that process to be wrapped up
We generally take it to the wrap and the
to the wrap and the CHASP. Got it.
Okay.
Okay.
Okay. How much time are we talking?
They're
It's a
looking for.
DLT priority
Yeah.
project.
Well,
And also,
They're looking for
the
February
landmarks?
4th. Yeah.
no,
Yeah,
we,
yeah, so I mentioned that maybe while you were out of the room, that we had gotten the landmark
Yes.
sign off, yep. So
Okay.
I know that because we had done a lot of these studies early in the planning for the building,
DOT, you mean?
no,
No.
all of the different studies we talked about, the mechanical equipment and the different configurations, I think we can be prepared to resubmit by mid-January for maybe like a February 11th next hearing.
The 11th does not work, but
20, oh,
Don't they have another requirement that they have to meet?
Susan,
let's see.
Susan, Ms.
Yeah.
Golden.
the DOH process.
It's 20 people. That's it?
Oh,
That
yes.
can be complete.
Madam Chair, Madam Chair,
Hmm.
there's a
Sorry?
commitment, they have a time frame on a DOH issue, right?
Sorry, what's your DOH issue?
Oh, that's right, yes. Department of Health reached out with questions about the status of the environmental review because it's a coordinated review.
Ah.
And they are planning their public hearing process to occur in January 24th.
So that means,
We won't have completion of that process, so we reached out to Department of Health contacts who are handling the environmental review on their end, and they determined that they don't require the decision before they can have that public hearing. So,
so we have more time with DOT. Do we know we're coordinating this review with DOH?
Yes.
We do, okay. Good. Otherwise, I don't feel coordinated, okay? All right, so then we can give it a little bit more time on that, right? But anyway,
11th doesn't work?
January 25, how many are we up to, 21?
yeah.
16, okay.
You can't
No, so
squeeze
we
it
do-
in the 11th, it
Huh?
doesn't work? Doesn't squeeze it in?
What's the
Oh,
question?
Oh, oh,
Yeah,
oh.
no.
Oh.
Does that work?
Yeah, I think.
Okay. Submission date February 5th for a continued hearing on February 25th.
and there's no way we can do this a little bit earlier?
But so I'm a little confused. So we're trying to get a DOT response.
You
and
want to have
turnaround,
DOT so
and
that we can be
know-
wrapped up?
We all know we're having trouble with DOT, right? So it would be better to just do this once more, right?
Yes.
As opposed to several times.
Okay. So February 5th, you said?
And February 25th.
Thank you. Okay.
Okay, thank you, everybody.
Thank you very much for your time.
Very helpful, thank you.
Oh, shoot.
I'm sorry.
Sorry.
I thought, yeah, I'm
So
sorry.
sorry.
Yeah, we thought you were sitting next to everybody. I didn't think there was any member of the public. Yes,
sorry.
I'm so
3
sorry.
minutes. I apologize. My fault.
Everyone else is part of the team, right? Okay.
I'm the mystery guest.
Yeah, okay.
Favor?
Always
opposed?
wear
You're
different
opposed.
colors than the team.
Please state your name for the record, and you have 3 minutes.
We could give them a little.
Good evening. My name is Kevin Ramsey, and I want to thank the board for this opportunity to see the hospital's plans for the first time. All of the following statements and opinions I'm about to make are my own. I'm a 29-year resident of the block. For the past 5 years, the community has...
Of the block as in 13th Street?
As in 320 East 14th Street, right next door.
Okay.
For the past 5 years, the community has asked Mount Sinai to let us know of its plans for the residence hall on 13th Street, and for 5 years, we were told the same thing. We are building as of right. We don't need to tell you of our plans. Unfortunately, this, like so many other statements by the hospital, turned out not to be true. I don't think that this should be an amendment to a previously approved special permit, as this for-profit corporation seeks to replace a residential structure with an industrial structure. The new use of this site should be subject to complete review to determine the negative effects on the residential quality of life of this community. This industrial building that is proposed will dramatically and negatively affect all the residential units it faces, is not in keeping with the historic residential architecture that surrounds it, will dangerously increase environmental light and noise pollution, and will create a block that is unfit for healthy human habitation. To effectively evaluate the change from a residential block to an industrial block, we need to see detailed analysis of the increase in light, noise, and air pollution. We need to know how the construction will further damage the foundation of our buildings, already cracked and weakened by the demolition of the residential structure. Once completed, we need to know how many additional late night and early morning deliveries and pickups will be made to accommodate this industrial structure. We need to know how snow and ice will be discarded from the rooftop. We need to know how much worse this will make the traffic on 14th Street, 13th Street, and 1st and 2nd Avenues. We need to know which toxins this industrial building will release into our environments, our homes, our synagogue, and our community center. I've lived next door to the hospital for 29 years, so I'm under no illusions. This hospital has filled the basement of the building where I live with 6 feet of water. This hospital refused for decades to address a loud HVAC system until it finally broke. This hospital has refused to acknowledge or address the horrifyingly large rat and mouse infestation in its south building. And this hospital has failed to address other issues that have been ongoing. In short, the hospital has not shown itself to be a good neighbor. I ask that this board hold this powerful for-profit corporation accountable, and before rendering a decision on this application, insist on a complete evaluation of a change from a residential to an industrial building. Thank you for your time.
What do you mean by an industrial building?
It's not commercial, right? Because it involves a large amount of materials coming in, right? Oxygen, nitrogen. This is delivered already to the existing hospital. So it's not commercial in the sense that it would be if it were retail, for example. So I'm not exactly sure where it fits.
It's called a community facility building. That's what a hospital is.
Okay.
So like a church and a synagogue are also community facility buildings. They're buildings that service the needs of the community. That's what a hospital is considered.
But is it?
Right, but it's, so an industrial building is actually like a building that manufactures something.
And yet I would say that it more represents an industrial building, unlike a synagogue, which does not need to have nightly deliveries of nitrogen and oxygen, does not have hazardous waste that needs to be removed. So I think it's not exactly like a synagogue, not exactly like a community center. I understand that it serves the needs of the community, but its needs, its infrastructure needs are dramatically different from those.
Per zoning regulation, the use that they're proposing, that's existing and that is being enlarged, is very consistent with the zoning regulation definition, which allows hospital-related use as medical facilities, and that's what this facility is.
Yeah, but so just to clarify, they are building the use as of right. What they're asking us for is mostly a waiver of height and setback on 13th Street.
Right.
That's the main part of it, so the building is a little bit taller on the 13th Street side because of the mechanical floor. And they are asking for a waiver to encroach somewhat into their rear yard, but it's only up to, what's the height, 30-something feet? What's the height? So it doesn't go all the way up into their required rear yard, right? So the things that we're helping to facilitate are relatively minimal. Could they do it as of right? They can't do the same thing as of right, but they can certainly build a hospital as of right. It's just they wouldn't be quite as tall, and they wouldn't be able to penetrate as much into their rear yard that's opposite you, right? But meanwhile, they had a special permit already, and they're just kind of modifying that somewhat to encroach on the rear yard that faces between the two buildings, which doesn't affect you because it's their building to their building, right?
Right.
So, which is something they need a waiver for because of the zoning, but you wouldn't be aware of because you can't see that part.
Right. But
Okay, but,
It's a
yeah.
community facility.
So, thank you, appreciate your, so what is the height of it?
Sorry, it's
37 feet.
37 feet.
Okay, so it's 37 feet high as opposed to the full height of the building, which is, whatever. That's the full height of the building, 130 to the roof, something like that? 130 to the top of?
135 feet to the top of the mechanical.
Mechanical roof, right, okay. And these plans are available for, have you seen the floor plan, the proposal?
no, this is the first I've seen. of the
Okay, so
proposal.
you're welcome to come to our office at 250 Broadway and review the materials. Also, the community board, but I guess you're not that far. It's probably easier for you to come to 250 Broadway. You can get the contact information from Ms. Matias if you
Okay.
want to come and review the drawings. And so I thank you very much for coming to
Thank you.
speak, okay? And actually, I would recommend this is the milk and cookie speech, okay? So I recommend for all community facilities that come to neighborhoods, and also for for-profit developers, but it's more, let's say, important, I think, for a community facility, that you reach out to your immediate neighbors and you invite them to what I call the milk and cookie session, where you make a presentation about what you are actually doing, so you don't get a comment that we asked them and they wouldn't tell us, and they told us it's as of right when it's not, right? Tell them what you're doing, answer their questions, promise to cure the problems that are being presented, and actually cure them. This is a recommendation for living peacefully together, okay?
Yeah, and just to reassure you, Mount Sinai does participate in a working group that, of community officials and stakeholders. There have been several town halls about the new hospital, and they have actually reached out to the buildings on 14th Street that would be behind, and are starting that process of briefing people. In fact, the first one is tomorrow night.
Okay. Yes, please,
Yeah.
please. Yeah, please come up.
And, right, obviously presented to the community board.
Right, well, that's a different thing.
It's Jeremy Bowl again, and thank you for that comment, and we agree. We've had over 70 meetings with members of the public, including a standing working group with elected officials and the community boards. We are regularly, multiple days every week, doing exactly what you recommend. And I apologize if we have not connected. That's a failing on our part, and I recognize that. So when we leave here, we'll make sure you have our information. Okay, and we should work directly on the issues that you're bringing up. Most of what you raised tonight, we have addressed in many of those forums, but for example, the issue of mice and rats I hadn't heard until tonight. So I would like to spend more time understanding what your concerns are so that we can try to address them as best as possible.
And, you know,
Well, thank
one
you.
way of course, doing it, which you probably know, is flyers under the doors of all the adjoining properties in the lobby of the larger buildings that have lobbies, right?
Yeah.
Helps.
So thank
Okay.
you for that.
Thank you. Okay. All right, so we already did the schedule. So for the neighbors' information, There's a submission that they have to make. You're welcome to come to the board office and review the submission. A copy of it must be submitted to the community board as well. So if that's closer for you, that's kind of your choice. And they're going to come back here on
February 25th.
February 25th, and their submission is February 5th. So that's when, after which you could come to the board office to review the submission.
You have to
Okay?
make an appointment.
Yeah.
I gave
So,
him a card.
and you gave him the information. Okay, great. Thank you very
Okay.
much, everyone.
Item number 9, 2017-207BZ, which is 2030 Broadway, Manhattan. No one showed up, so
No,
what date do you
that was
want
a
to give?
no-show, so we just need a date at our
So it's
convenience.
postponed.
Right?
It's an extension of time for PCE.
It's not a problem, Matt. Isn't this core fusion?
This is Core Power
This is
Yoga.
Core Power, right.
Extension of time to get a C of O.
This is, I'm sorry, this is a new, an SOC,
Yeah, no one showed up.
an extension of time to get a CFO?
Extension of time to obtain a C of O, which expired August 21st. It's in the Upper West Side Central Historic District.
Well, it's okay because we also wanted to notice the building, so it's an opportunity to notice the neighbors. It's not such, and that way it'll be the initial hearing where neighbors, if there's a problem with noisy yogis.
So perhaps a note to staff, even though there aren't notice requirements for extensions of time, but maybe.
I'll put a new notice here.
A notice should be sent in with the instruction of the.
New notice.
Yes, right,
Okay.
okay. So, do we have anything like a, you don't need to go that far out. No, do it from like the 11th.
No, so submission date of January 22nd with a hearing of February 11th.
And this was something where I don't know whether fire department was interested.
Excuse me, fire department.
Fire department. I don't know whether you wanted to, but anyway, we didn't get a response from you on 2030 Broadway, which is just an extension of time on a PCE. That's a yoga studio in a residential building.
To apologize to the John Daly Fire Department. I should have submitted a letter. I never had a chance to review it, but
Okay.
now I will.
Ah, okay.
Thank you.
Thank you. Thank you very much. All right.
Okay, this concludes the public hearing for December 10th, 2019.